When I go to space, will you catch me on the round? In a satellite or not, will I come up with a crowd? When I go to space, will the people here swinging from a chandelier watch me ride the loop-de-loop twice? In a boat you only float, cars are fast, but still you hope to take you where the stars look so nice. When I go to space, 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 when I go to school, will I get another page? If you're breaking all the rules, teachers gonna kick your ass. So when I go to school, I'm gonna write it down, show 'em who's the only clown to graduate without getting pied. Lockers fall like dominoes, hear it on the radios, clanking down the halls, alright. When I go to school, when I go to school, when I go to school, when I go to school. When I go to church, will you hear me pray to God? Lord, I'm really sorry for. Now could you give me what I want? Church, will I suddenly know all the answers? More money, walking around, will I have love? Is heaven gonna let me in? I won't tell lies, I'll tell him in, 'cause hell is where I don't wanna go. When I go to space, 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 when I go to space.
Wow, this is some pretty crazy stuff.
What's going on, everyone? Yeah, my audio is kind of fucking up here. I caught that on the intro. I was hoping, I stopped into Malibu's guys stream just a little bit ago. I was hoping that she would have me up just so I could address her trolls. But she was ready to do something else. I don't know how many of her trolls come into my stream, but I do want to address them.
Whatever.
I really want to address them. It's like, you gotta find a better course in life. That's just like it's personal information to her trolls. You come at her, you get yourself on the radar, and then she will come at you later. She takes the trolls in order. So when you make yourself known, trust one fact that you will get fucked with later on when you become the biggest troll. But she takes the trolls in order. I do want to thank her supporters. I am on my phone. If I was not on my phone, I would have a banner lined up to sub to her because she needs the subs. She's doing awesome. Her and I are good. And there have been people that have been trying really hard to drive a wedge between her and I. Well, you know what? It ain't fucking working. It ain't fucking working. I love her. She at least likes me. She's not used that serious L word as of yet. But that's where it is. And I don't give a fuck what you say. It's good. My thoughts are not going to change. And when me being new to YouTube, yeah, I kind of appreciate the input on the previous knowledge that I'm not aware of. Yeah, I do appreciate that. But I'm going to make my decisions where I see fit, because everybody has a past. We all have a past. I've got a past, but I don't live there anymore. All right. So I am willing to forgive a lot of shit, and trying to drive that wedge between me and her, at least on my end, it ain't gonna fucking work. Y'all might be better off trying to dig into my past and driving that wedge towards her. I don't know. Maybe you'd be doing yourself a better favor, because I'm not a vindictive person. I do my best not to go after the people that don't fucking matter to me.
This is not.
Well, I appreciate all of you. I don't see you in every day. I only see you when I come here. Yeah, so good luck with that.
I didn't say that.
But yeah, I also wanted to try and do this on her stream, because I also wanted to address her supporters and just say thank you. But again, like I said, the main reason for this is because her trolls come to her streams, and I really wanted to address them. You know what? Such is life. You don't always get what you want. Just take what you can get, be happy with it. Change what you can, settle for what you can't. And if you can't accept either part of that, then it kind of sucks to be you. Anyway, you all have a great night. Thank you for stopping by. Malibu, I love you, baby. I hope you see this. Y'all have a great night. Peace out, everybody. How the fuck do I end this on my phone now? Oh, shit.
This is not a lie.
So, Victor, are you surprised that they're going to put Laura Olson on?
This is not a game.
They were going to call her yesterday.
This is not a lie. This is not a game.
I doxed her ass. Okay? Technically, it was fellow man first.
I've got doxes on all you bitches.
To another round of that. It will be interesting to see how aggressive this questioning is and what questions are asked. It is obviously personal. It will not play well with the public who feels like this is a personal matter that's not related to the case. The defense will have to prove why it's related to the articles of impeachment.
Yeah. Well, and where it relates is how KenPaxton, by the accounts, especially Missy Carey, described how he was using his security detail and his scheduler, and in terms of how he was using the functions of the portions of his office to hide the affair, to carry it out, and then also how she comes to work, how she comes to move from San Antonio to live in Austin and work for Nate Paul.
But over and over, the defense has said everybody in Austin has affairs. It's not illegal to have an affair. Just like they've said, you can't trust the DPS, you can't trust the FBI. And they've made all these arguments that resonate with the 31 members of the Senate and with a lot of the general public. They have to show delinquencies, maladministration. The question is whether the prosecution's going to be able to make that case.
Yeah, I don't know. Victor?
We'll have to wait and see.
Yeah, and I'm not. On one level, I'm surprised they're calling her because I do think there is some downside.
Members, so you're clear on the rules and the agreement that we made with both parties before the trial that witnesses must be given 24-hour notice. And Ms. Olson was put on the list at 3:53 yesterday, so she would not be eligible until 3:53 today. And the same thing applies. Either side can put on a witness on their list up till noon that they can call in the morning the next morning, but after that, it's when they put them on the list. The defense has some on the list for later this afternoon, for example, that they can't call up until then if they choose to. So with that, Mr. DeGarrett?
Yes, Your Honor. Ms. Epley will call Ray Chester as the next witness.
Bailiff will bring in Ray Chester.
I've got doxes on all you bitches.
And members, the reason for that was so each side can prepare for a witness in time when they appear.
I didn't say that. You said that.
Mr. Chester, if you'll raise your right hand, I do solemnly swear or affirm that the evidence I give upon this Senate of the Texas impeachment charges against Warren Kenneth Paxton Jr. shall be the truth, the whole truth, nothing but the truth, so help me God. Please have a seat. And as we encourage everyone, be close to the mic as you can. to be as close to the microphone as you can be when you speak. Thank you. You may proceed, Ms. Epley.
Thank you, Mr. President. Please introduce yourself to the ladies and gentlemen of the Senate.
My name is Ray Chester.
And Mr. Chester, what do you do for a living?
I'm an attorney in private practice. I'm a partner at the Austin law firm of McGinnis Lockridge.
Are you the same Ray Chester that we might have heard connected to the Mitty Foundation and issues with the Office of the Attorney General in 2020?
Yes, I've represented the Mitty Foundation since 2016.
And where is the Mitty Foundation located?
Currently, they're mainly located in Brownsville.
Okay. What does the Mitty Foundation do?
Currently, well, they were started by Roy Mitty, who grew up dirt poor in Brownsville and self-made man. It's actually a family foundation. It's not a public charity. They don't accept public donations. And for many years, they mainly provided scholarships to needy students. And in recent years, they've shifted their focus back to Roy's hometown of Brownsville, and they've developed the Mitty Cultural District in Brownsville.
Who runs the Mitty Foundation now?
Roy's grandson, R.J. Mitty. R.J. was born with cerebral palsy. You may know him as Walt Jr. from the TV show Breaking Bad. He's an accomplished actor. More importantly, he's an international spokesperson on disabilities and the rights of the disabled. He's worked with the United Nations, the State Department, United Cerebral Palsy Foundation, and he gives motivational speeches to students on anti-bullying and overcoming disabilities.
Thank you, sir. The Mitty Foundation has been disparaged somewhat over the last couple of days in regards to prior management. How long ago were those issues?
They were in the 2000s, and the Mitty Foundation received a clean bill of health in 2011 and has been squeaky clean ever since.
Has management changed since that date?
Yes, the problems were Roy's son and RJ's dad.
Let me interrupt you, Mr. Chester. I'm sorry. I'm on a time clock, and I expect they might ask you those questions.
Okay.
What I'm trying to determine is there any rational basis, given the change of management and the time frame, for the Office of the Attorney General to use those issues to justify intervention?
Objection.
None.
Objection, Mr. President, calls for speculation and improper opinion by this witness without a predicate.
Overruled.
You may answer the question.
None whatsoever.
Let me turn your attention quickly then to the settlement from World Class Holdings that we've heard in detail. What was that settlement value?
We settled in July of 2019 for $10.5 million.
After the breach of contract, what did the Office of the Attorney General push you to settle for at mediation?
Objection, hearsay.
Sustained.
Your Honor, if I may, he was present at the interactions. It's an operative fact, and it's already in the record. There is no harm from the hearsay.
I ruled.
Okay.
Mr. President, to be clear, because this may come up again, all these conversations would be privileged under Texas Rule of Evidence 408 as settlement discussions as well.
Mr. Chester, would you or the Mitty Foundation have an opinion as to whether or not you're interested in waiving that privilege?
We are willing to waive that privilege.
In that case, what would the result have been of you agreeing to settle at the mediation with Darren McCarty?
Objection calls for speculation and hearsay.
Overruled.
We would have received pennies on the dollar.
Do you have an approximate value, or do you recall the number that you were pushed to accept?
The only firm offer was...
Objection, Mr. President. Hearsay.
Your Honor, it's an admission by party opponent. It was an action on behalf of KenPaxton by the Office of the Attorney General, and it's integral to the facts of this case.
And there is no evidence of that. None.
The evidence comes from the witness, as it always does in trial.
Not for a moment. Overruled.
Let me do it this way, since relevant facts are already in the record for the Senate to consider. What is the end result considering that you were able to proceed with litigation?
We are poised to wrap up the litigation. The partnership properties are under contract. MIDI stands to receive approximately $23 million.
And when you say stands to receive, is that up to whether or not Nate Paul or World Class Holdings chooses to pay you?
No, fortunately, we're not depending on that because that would be fruitless. We will be paid out of the sales proceeds.
So the $23 million will come out of the sale of the property itself without any decision-making on the part of Nate Paul or World Class Holdings?
Correct.
Is that a delta of almost $18 million in loss if you had taken prior deals?
Then leading.
Sustained.
What is the difference between those values and where you ended up?
It's going to be about $17 million more than we were offered when the Attorney General was involved.
Thank you. Pass the witness.
Mr. Little.
Mr. President. Mr. Chester, how much money did your client, the MIDI Foundation, invest with Nate Paul?
$3 million. Well, in these two projects, $3 million. There were some other projects as well.
Okay, but the projects that are at issue in the litigation we are here to talk about, the MIDI Foundation invested $3 million in charitable funds with Nate Paul, correct?
With Family Foundation funds, yes.
Yes, and when we say Family Foundation funds, those are funds that were committed by the family to the charity, true?
Yes.
Okay, and of those $3 million that were invested in this program with Nate Paul, it's really a private equity real estate deal, right?
It's a limited partnership.
Yeah, which we generally refer to as a private equity deal, right?
There's a slight nuance difference, but it's similar.
Yeah, it's very similar. You're in business litigation, correct?
Yes.
You've been in business litigation a long time, right?
Yes.
How many years?
Well, I've focused on commercial litigation about the last 10 years. Before that, I did other things.
Okay. I just want to make sure that I can harmonize this for everybody. The MIDI Foundation invested $3 million with Nate Paul, and they're going to get $23 million back, right?
Right. We invested in 2010, 2011. Yes, sir.
Right. So who at the charity made the decision to invest charitable funds in a private equity real estate deal?
That would have been the board at the time.
And how many years did you say you've been doing business litigation?
Full-time, 10, off and on, my whole career.
Okay. Have you ever seen a charity make a $3 million investment in a private equity real estate deal before this?
Yes, sir.
Yeah. Do you remember the circumstance?
No, and I don't think it was exactly $3 million, but I just don't think it's an uncommon occurrence. They actually had 4 successful investments with Mr. Paul before his troubles arose.
I want to make sure that the jury heard that because I don't think I heard it very clearly. What did you say?
I said that they had a total of 6 investments, and the first 3 they made money on. The 4th one, he tried to swindle them. They still made money, and now there's 2 remaining.
Okay. But the one that you're saying Nate Paul tried to swindle them on, that's the one they're going to make $23 million. They're going to make, I'm sorry. You're shaking your head at me.
I may have misled you. The last 2 are the ones that they're going to make $23 million on. The 4th one was the one he tried to swindle them on.
Okay. That has nothing to do with the litigation.
Not really, no.
So the MIDI Foundations have been the MIDI Foundation's been a long-time investor with Nate Paul before having anything to do with the Attorney General. Is that right?
Yes.
Okay. During the pendency of your representation, has leadership of the MIDI Foundation changed?
Yes.
And do you know a man named Dilum Chandrasoma?
I do.
And he is no longer with the foundation, is that right?
That's right.
And what were the circumstances, Mr. Chester, under which he exited that foundation?
He was arrested in 2019 for a domestic incident. The charges were later dropped, but we immediately asked him to resign.
He was accused of beating his wife and son, I think.
I don't know the details, but it was some type of domestic violence incident.
Something like that?
Charges were dropped, though.
I see. On an affidavit of non-prosecution, I'm sure, by his family, true?
I don't know, but we asked him to retire nonetheless.
Now, by the time the AG's office intervened in your pending action, your client had spent almost $800,000 or so with you, true?
Right, most of that after...
Objection, Your Honor, relevance.
Overruled.
Right, most of that after Mr. Paul defaulted on the settlement, yes.
Okay, so just to be clear, your law firm charged, and I want to make sure that we have this in order. These are charitable funds that the foundation is paying you with, right?
Yes.
And you charged that client almost $800,000, right?
At reduced
Objection,
rate,
Your Honor.
since it was a charity.
I'm sorry, objection, Your Honor, relevance. If I could take him on a brief voir dire, I would be able to establish why attorney's fees are irrelevant to any conversation here.
Mr. President, we don't voir dire on relevance. The clear relevance of this is how the Mitty Foundation uses its money. It's at issue on direct. It's at issue now.
It is also recuperated.
Overruled.
Okay. So you were charging, I believe, $450 an hour to the foundation, right?
At that time, yes.
And that's well below your rack rate of $625 at the time, right?
Might have been $715 at the time, but yes, it was well below my normal rate.
And what's your rate now?
My standard rate is $715.
Okay. And you had already, by the point the OAG's office intervened in the dispute, you had already gone through a AAA arbitration, correct?
We were just getting going in a AAA arbitration.
I'm sorry, you and I are both business litigators, so this may be a little inside baseball, but AAA is American Arbitration Association, yes?
Right.
Yes, and so what had happened was you, on behalf of your client, filed a AAA proceeding to arbitrate a dispute with Nate Paul's businesses, right?
Actually, Nate Paul filed it, but yes.
But you had counterclaims, right?
Yes, we did.
And you prevailed, right?
We won, yes.
Yeah, but to be fair, you never gave the Attorney General's office notice of that proceeding as is required by law, true?
I believe the law requires notice of a lawsuit, and there was a lawsuit, and I was a little late giving them notice.
And you were probably close to a year late, right? Something like that?
Yes. However, the lawsuit was dormant for most of that year, but yes.
I'm not being accusatory. You just didn't know.
I didn't know.
Yeah.
The judge told me she was the former head of charitable trust, and she said, have you given the AG's office notice? I'm like, oh my God. And so I sent it the next day.
Of course, of course. So the pendency of the intervention by the Attorney General's office, it lasted a total of about 3 months, right?
Approximately.
Okay. Between us business litigators, 3 months is nothing in the life of business litigation, is it?
Well, this has been going on 5 years, so I recognize your point, but those are some crucial 3 months that cost us a lot of time and money.
Well, I want to talk about what happened during that period of time. So at some point, the Office of the Attorney General intervened, and that's, well, why don't we just go ahead and pull it out so everybody has it in the record. I'm going to show you what's been previously marked as Exhibit AG 156. May I approach the witness, Your Honor?
Thank you. Am I doing okay with the microphone? Yes, you are. Thank you.
Now, if you would, Mr. Arroyo, Exhibit AG 156. Thank you. And Mr. Chester, just tell the jury, when was this filed?
June 8th of 2020, 10 days after the stay was lifted.
Okay. Now I'm going to hand you a really big document.
Oh, my Lord.
I know. That's what I said, too. Now, this is the transcript of the hearing on your motion for sanctions. Okay?
Okay. Which one? We had about 8 of those.
You got a bunch of them, right? This one is from June 25, 2020, 17 days after the AG's office intervened.
Okay.
It's marked as AG Exhibit 13.
Ugh.
Mr. Little, are you entering this into evidence?
I am, Mr. President. This is AG Exhibit 13. We move for admission.
No objection.
I was glad you say you didn't want to read it. We'd have been here for a while. No objection. Enter
Now,
0013 into evidence.
Thank you. Now, Mr. Chester, as a litigator, if the AG's office were going to intervene to help Nate Paul, your motion for sanctions and the receiver's motion for contempt and sanctions probably a pretty good time to do it, huh?
I couldn't comment on that.
Well, why don't you hold...
I'm not sure what you mean.
This is 433 pages. Why don't you just hold this booger up for the jury, if you would? Just hold it up for them so they can see it.
It's the transcript's only about a first third. The rest of it's exhibits. But
Yes. And this was a lengthy hearing. You argued, you introduced evidence, offered and admitted it. True?
Yes, sir. I did my best.
It looks like you did. It looks like you did a very good job. You won this hearing, right?
I believe so, yes.
Did the Office of the Attorney General fight for Nate Paul on any of it?
Not in this hearing.
They didn't try to keep him out of contempt. They didn't try to keep him out of discovery sanctions, did they?
Not in this hearing.
At some point in time, toward the end of June, so maybe about 3 weeks or so, 2 to 3 weeks after the intervention, you were contacted about doing a mediation by someone at the AG's office. True?
I was contacted almost daily about that from the moment the intervention was filed.
And to be clear for the jury who may or may not be civil litigators, I know some of them are, mediation is just a formal settlement conference presided over by a mediator. Yes?
Right. This would have been our third one in this case.
Yes. And so what the AG's office was proposing was to have the parties, the Mitty Foundation and the Nate Paul entities, come together with the mediator to see if they could reach a settlement. True?
Yes, it would have been the third mediation and we'd already settled the case. But yes, sir, you're correct.
Okay. And to be clear, you could not settle the case, correct?
Explain, please.
Yeah. You couldn't settle the case. And one of the reasons was your other SEC attorneys are, well, let me try to back into this a little bit differently. How many lawyers do you have at McGinnis Lockridge?
70 or so.
Do you have securities enforcement attorneys?
Securities enforcement attorneys? No, we do not.
Okay. Do you have securities litigators at your firm?
You're looking at him.
I'm looking at him?
Yes, sir.
You're a man of many talents, aren't you? So
I know a little bit about everything and not a lot about anything.
That's great. Speaks very highly of you. So, Mr. Chester, at this point in time, one of the concerns that you had was back in 2019 when Nate Paul was raided, the SEC had someone involved in that raid, true?
That was, yes.
And one of your concerns about settling the case by the Mitty Foundation against Nate Paul and his entities was that if the SEC sued Nate Paul and got a receiver appointed, that receiver might try to disgorge the settlement. Yes?
We call that clawback, and that was a concern.
Yes, and it was a concern that you had, and a very good reason not to settle. True?
And I expressed that to the Attorney General's office on multiple occasions, yes, sir.
To whom? At the Attorney General?
Josh Coppy and Darren McCarty.
And Darren McCarty was, well, you used a word to describe him in your testimony before the House, right?
That was,
what word?
That was indiscreet.
What word did you use to describe him?
It begins with an A and it ends with an E and it has 7 letters.
Okay. But you don't have any evidence that KenPaxton ordered him to be an a-hole to you, do you?
Other than what Mr. McCarty told me.
Oh, other than what Mr. McCarty told you now?
Right.
Okay. To be clear, maybe Darren McCarty was just born that way, right?
Or maybe he was just doing what he was told.
But you don't know either way, do you?
I don't know either way.
I didn't think so. At some point in time, bankruptcy entered the discussion in this litigation, true?
Mr. Paul filed bankruptcy 5 minutes before the deposition of his vice president of accounting. Yes, sir.
Okay, and just tell the ladies and gentlemen of the jury, what happens when you file a bankruptcy petition on behalf of an entity in litigation?
There's an automatic stay in all litigation involving that entity.
Okay. I'm going to approach you with what has been marked as Exhibit AG 212. And while I'm up there, I'm going to give you AG 41-2 to save time, okay?
Okay.
Mr. President, we move for admission of exhibits AG 212 and 41.
41's been pre-admitted, so it's on our books.
Thank you, Mr. President.
212, any objection?
No, Your Honor. Like most exhibits, these match things we would produce on our own.
Mr. Arroyo, if you would, exhibit AG 212.
Please admit 212 into evidence.
And exhibit 212 is a letter from you, true?
Yes, sir.
Okay, and you're writing to Elizabeth Dykeman. Who's Elizabeth Dykeman?
She was a court administrator for one of the judges in Travis County District Court.
Okay, and you're notifying her of removing a briefing deadline, I guess, as a result of a bankruptcy filing, is that right?
Yes, as we discussed, when the automatic stay kicks in, then everything stops, but the judges don't necessarily know that, so it's customary to notify them.
Okay, so I just want to be clear, for one of the 3 months that the AG was intervened in this lawsuit, it was subject to the automatic stay, right?
Right, although we were litigating like crazy in bankruptcy court.
Yeah, but AG wasn't part of that, true?
I don't believe so.
They were a notice party, but they weren't part of the litigation in bankruptcy court, true?
I don't believe they appeared in bankruptcy court.
Okay, so to be fair, you're litigating with this guy on behalf of the Mitty Foundation all over the place. AAA, State District Court, multiple lawsuits, bankruptcy court.
8 appeals.
8 appeals. And all that's with charitable money, right?
Yes, sir.
Okay.
Trying to get our charitable money back. Yes, sir.
And I believe you. And it sounds like you're going to get over 7 times the initial capital outlay back, right?
Long, hard fight, but yes, sir.
Okay. And to be clear for the ladies and gentlemen of the jury, in the previous 2 months before that bankruptcy filing by Nate Paul's entity in this litigation, AG's office was trying to foster a settlement between the parties, true?
They were trying to force a settlement on us.
When you say force, they can't force you to do anything, can they?
They were applying pressure. They weren't successful, but they tried.
They couldn't force you to do anything, could they?
I'll stand by my previous answer. They were trying, but they could not force us.
I appreciate your answer, but I need an answer to my question.
Okay.
The Office of the Attorney General could not force you to settle anything, true?
No, just pressure us.
No further questions.
Redirect?
No, Mr. President, thank you.
Are both sides excusing the witness?
Yes, Your Honor.
We release this witness.
Thank you. Mr. Chester.
The House calls Andrew Wicker.
Bailiff, bring in Andrew Wicker.
I didn't say that. You said that.
But he can silence you from doing any artwork at all. That should concern everybody, no matter what you think of me or any of these other characters. You need to be concerned about that.
Okay? my dogster ass.
Mr. Wicker, please raise your
Technically,
right
it was
hand.
fellow man first in a chat, but I went on a chat, freaking saying her whole name, you know, and that's when you guys would have picked up her talks, you know, you're all listening that night, you know, and like, she accuses you guys doing it. It's like so weird, and she's sticking to that story, you know.
I know, it's weird. She'll say, like, I put the number, I put her here, she said it a bunch of times.
It's a large room. Yeah.
Okay. Andrew James Wicker.
Thank you. I appreciate it. Tell us a little bit about your background. Where did you grow up? Where did you go to school?
I went to school at Prestonwood Christian Academy. That's where I graduated from high school. I grew up in Prosper, Texas, a little town north of Frisco, Texas, in North Dallas.
Let me pause you for a moment. Okay. Can y'all hear him well enough? Okay.
No? Okay, how about this?
Thank you, much better. Right. Please go ahead.
My name is Andrew James Wicker. I grew up in Prosper, Texas. I grew up going to school at Prestonwood Christian Academy, which is where I graduated from high school. I then continued on to go to SMU for undergrad, and then I went on to a graduate degree at Georgetown University.
Okay. Can you tell us a little bit about what activities you were involved in college or in while getting your master's?
In terms of my involvement in college, my first job was working for Don Huffines on his Senate campaign. And then I continued on to later be involved with founding the Young Americans for Freedom chapter at SMU, where I served as vice president. And then I helped refound the College Republicans for SMU. I ended up working with several student organizations on a 9/11 flag memorial and pro-life memorial. We had a tiff, I would say, with the administration. And so I got involved in politics in that way, and then I continued on to Georgetown and landed in DC for my graduation, and then I went to work for General Paxton.
Okay. Do you recall approximately what time or the date that you went to work for KenPaxton?
My employment with the OAG started September of 2019.
How did you originally meet Mr. Paxton?
I had met General Paxton previously, both as my state senator, but also as the Attorney General at various Lincoln Reagan Day dinners. In terms of my employment and the opportunity to start working for him, I met him through Mark Rylander, who was a previous associate in North Texas in terms of my community. And I was recommended for the position by Mark Rylander to General Paxton. And that's whenever I met him at the Marriott Marquis in DC, and I was hired.
Okay. If Jeff Mateer was the first assistant, did Mr. Rylander have a nickname as well?
He was known commonly as the first friend.
Okay. And through that connection, you end up working at the Office of the Attorney General. In what role? What'd you do?
My title was Executive Aide to the Texas Attorney General, and then I was also on the campaign staff as well.
And what does an executive aide do?
My responsibilities expanded and contracted as I also had to assume scheduling responsibilities. We had 2 schedulers during my time there. Whenever we did not have a scheduler, I assumed those responsibilities, but my standard job responsibilities during whenever I was performing the functions as an executive aide was to ensure that the general was going to his schedule on time, that he was prepared for those appointments, and that he had all necessary documents and context to the discussions that he was having for that day.
That sounds like a great deal of access to the Attorney General. Is that fair?
Yes.
Approximately how much time did you spend with each other in any given day?
At least 8 hours, normally closer to probably 10.
And was that just weekdays or weekends as well?
That would include weekends.
How often was Attorney General Ken Paxton in Austin in 2020?
This was during COVID, so after probably the first 3 or 4 weeks of COVID setting in, he spent the majority of his time in Austin, starting in probably about April-May timeframe through the remainder of 2020.
And where was Senator Angela Paxton?
She regularly split her time both between their home in McKinney and in Austin.
What was your relationship with the Paxtons, individually and as a couple?
Individually, I would call General Paxton as a friend. I spent a great deal of time with him. He and I bonded over a good number of activities such as watching football, sometimes talking politics, but just talking life. With Senator Paxton, I would say that she was nothing but loving and caring. I think she also understood that the demands of the job kept me away from my family, so in many ways, she was kind and understanding in the way that a mother would be normally. As a couple, I would say that they were incredibly welcoming and caring to me, and always inclusive.
So, fair to say there's no animosity or bad blood between you and the Paxtons?
Not from me, no.
Are you part of some vast conspiracy to harm them?
No.
Are you in league with TLR or the Bushes?
No.
Are you here to tell the truth?
Yes.
I'm going to turn your attention to Nate Paul. Are you familiar with that name?
Yes.
How so?
During 2020, I was introduced to Nate Paul, and there were a number of activities and discussions that revolved around Nate Paul throughout 2020.
Can you tell me the first time you remember hearing of Nate Paul or meeting him?
The first time I remember meeting Nate Paul would have been February or March of 2020. General Paxton and I met him for lunch at Terry Black's barbecue.
Was it just the three of you?
It was.
And what was the topic of conversation?
Objection, hearsay.
Your Honor,
Sustained.
may I please respond? Anything from Ken Paxton is an admission by party opponent. Nate Paul is very clearly tied to a conspiracy, at least in terms of the evidence before this Senate, and Drew Wicker is available for cross-examination. None of that evidence is hearsay.
Again, Your Honor, the question she asked, she did not specify who was talking. Anything Nate Paul may or may not have said would be hearsay.
Sustained.
In the course of getting to know Nate Paul,
I think that's Ken Paxton's mistress showing up to court. Just a quick update there. She's going to come testify apparently today. Interesting. Alleged mistress. Laura Olson. Oh my gosh, we just doxed the Attorney General's mistress. Laura Olson. Man, that looks like another Manchelle Obama. That's got some wide shoulders. Well, better shut up anyway. All right, we're back to it.
At this moment, you're no longer in the United States. You were deported on August the 18th. But there's still a possibility that you'll be able to return to the U.S. in the very near future. Tell us about that.
The case is not over yet. It's still running in the U.S. federal court. It's still running, and I could get an answer for it during the next week or the next half year. And if I win, I will be able to get my asylum and enter into America. The whole heart of the case is not just me, it's not just my family, it's really the U.S. federal court are asking questions. What do prosecution look like? And this is for all of us. This is for the body of Christ. Also because this is a new kind of case. This is a very unique case as it is right now. But this is also going to set a precedent for case to come in the future. So therefore, it's a very important matter. And it's much bigger, as we have said, than just me and my family. But yes, the case is still running, and I could still win the asylum case.
Wow, Torben Sondergaard, after he's been released, maybe for a few weeks now, from a ICE facility in Florida, where he spent over a year, something like that. But yeah, interesting there. He looks a little hardened from being in jail that long. He's got that hardened look to him, just to let you know. Man, he looks like a gangster for Jesus now. He ready. Put him in. Right? All right, back to the Ken Paxton trial there. I just wanted to slip that in for me. It looks
so
like
it is not only not
serious here. We're going back like 2 minutes on this. There we go.
Speculation. He can testify about what he saw and maybe what he heard from Ken Paxton, but that's the extent of it.
It's foundational evidence, Your Honor. He can testify to his rational perception of the facts.
Sustained.
Did you see the two of these men interact with one another?
Yes.
And what did you see in terms of their demeanor?
A cordial relationship?
Did Mr. Paxton look to be under pressure to you?
No.
Now, I'm going to turn your attention to the second time you had lunch with them. Do you recall that?
Yes.
And where was that?
That was at Polvos, downtown in Austin.
Do you recall approximately when?
This would have been May, June timeframe.
Okay. And was anybody else present for that lunch?
Ryan Bangert.
Does Mr. Bangert work for Attorney General Ken Paxton at that point?
He did.
Is he there in his personal capacity or as part of his job duties?
He was asked by the general to attend as part of his job responsibilities.
And what was the topic of that conversation?
The Mitty Foundation.
Did anything change in regards to what Mr. Paul wanted between the first and the second lunch?
Objection, Your Honor. This calls for hearsay again.
Your Honor, if I may, I would really appreciate it if you would look at 801 E2D specific to co-conspirator statements.
Your Honor, there's no evidence of any silly conspiracy. This is hearsay.
This entire trial has been about a conspiracy, Your Honor.
Sustained.
Who paid for lunch?
Nate Paul.
How did you perceive their demeanor and interactions with one another, hostile or friendly?
Between Nate Paul and KenPaxton?
Yes, sir.
Friendly.
What about Ryan Bangert? How was his demeanor?
Inquisitive.
Did he seem to agree with what it is they wanted?
Objection, Your Honor. Speculation. We've already heard from Mr. Bangert.
That is exactly why it's
speculation.
relevant, Your Honor. He attacked the credibility of Mr. Bangert. So it is not only not hearsay because he's a representative working for Attorney General Ken Paxton who would have adopted a belief in or offered contrary information to. In addition to that, it's a consistent statement used to rehabilitate Ryan Bangert because of their attacks.
Your Honor, I'm sorry to belabor this, but Mr. Bangert testified. And to have this witness tell us what Mr. Bangert's attitude was about some lunch 3 or 4 years ago is just improper.
Time frame has nothing to do with exceptions to hearsay, Your Honor.
Overruled.
Thank you. Can you please tell me what Ryan Bangert was saying in response to this conversation?
Okay, Your Honor, now she...
Okay, real quick. We've got some body language action happening. Got some skin coloration change in the face. He won't adjust the microphone up. He's got to go down to it for some reason. And he's all bound up. He's being pressed. Okay? We need Nunya up in here to keep him pressed. He's got his hands all bound up. He's starting to get bound up. He's starting to sweat a little bit. We're going to see a collar adjustment here in a minute. He's going to start having the Pepto-Bismol, like, freaking burps here any second. They've all been in the back room slamming Pepto-Bismol before this meeting. They're all pressed, right? They're freaking expensive suits. Straight up pressed and double pressed.
Change the question. And
I'm entitled to do that.
Let me finish my objection, please. Now instead of the witness answering the last question, now she's asked a clearly hearsay question.
I went more specifically at it after the court's ruling, which I'm entitled to do.
She cannot ask this witness what Ryan Bangert said. She just can't do that, and that's what she just did.
Sustained.
Thank you, Your Honor. I'm going to turn your attention to the third lunch involving Nate Paul and Ken Paxton. Can you tell me when that was?
This would have been June, July timeframe.
Of 2020?
Yes, ma'am.
And who was present at that lunch?
General Paxton, myself, and Nate Paul.
What was the topic of conversation for this lunch?
The FBI raid on Nate Paul's home and office.
Specifically, access to the affidavit underlying that search warrant?
Objection leading. And again, Your Honor, I'm sorry to interrupt, but she's asking about what Nate Paul said at a lunch. That's improper, and that would be hearsay.
Your Honor, may we approach?
You may approach.
Okay, so Victor, your reaction to what we're seeing right now.
So the strategy we were talking about before the proceeding started today, where we see the shotgun objections strategy is being employed, and it's obviously very effective. It's breaking the flow of testimony on an important witness. What's notable is when I'm trying cases, I like to watch my jury as I'm looking at the jurors in this instance during one of the back and forth between the prosecutor and the defense. You can see Senator West, who is a very good trial lawyer and litigator here in the Metroplex, looking very perplexed by some of the rulings.
Of course, that was the ruling where they had the exchange about, she said this is all about a conspiracy, and Busby said, well, they haven't presented any silly conspiracy. So, Governor Patrick actually upheld Busby on that, which made Royce West.
And you kind of
wrinkle his
shook your
brow.
head.
And that is
surprised us.
that's where I saw Senator West looking perplexed, and I was perplexed myself. The evidentiary basis that was proffered by the prosecutor was actually a good basis for the admission of that testimony.
Does this show the limitations of having a presiding judge who is not a lawyer and not a judge?
It does, but the prosecutor is doing a really good job of educating as she is presenting her objections. Or she's responding to the objections.
But this also allowed the defense attorney to bring back up this boogeyman of there was no
video of Laura Olson. So we thought we were going to get Laura Olson, the former mistress, on the stand this morning. Victor, what do you make of this? This is a screw up, right?
It is. You want to make sure that if there's going to be testimony that's critical and there is a requirement to exchange information regarding who's going to testify, that you meet that deadline. So, yeah.
That's another man shell. Look at those look at the football shoulders. I'm telling you, looks like it's been wrecked a few times on the freaking front line of the football team, like Scotty Karate, right? Just getting wrecked, and the tonsils just wrecked at the front line for the freaking football guys. Not even as a bench warmer, it's like the linebacker, you know what I'm saying?
Judicious, there's another word, judicious in terms of how they're subtracting time from both sides.
It appears that way. I'll hear testimony from her today.
And what do they have to do with her?
Well, they really have to end strong. You have to have a strong ending, and I expect that that's what we'll see with this witness.
They still have to tie the bow around this package.
I mean, they have brought a lot of allegations, but they haven't really put them together, and they need to show, I mean, that she's the quid pro quo. I mean, she's what
Thanks for helping Nate.
all this access to Laura Olson. That's their allegation.
Well, let's think about this as well. And past this prologue, what we're going to see is even more objections
As that witness is testifying, so I'll be interested to see how effective the testimony is going to be in the face of the barrage of objections that I expect we'll see.
It'll be fascinating to me to see who the defense chooses to be her cross-examiner.
You know, are we going to have Busby? Or are we going to have Mitch Little? I mean, Mitch Little is very bombastic.
Yes.
Yeah.
I would expect we'll see Busby.
You think it'll be Busby?
Yeah, we'll see.
Because you don't want to be the star, right?
Yeah.
Will it be
Justice O'Neill, who has a soft touch, or who will the prosecution write? Who would you have be her question?
Probably Justice O'Neill.
Would you have a female question?
I think that would be very effective.
Want to have somebody that's, going to elicit that sympathetic
Exactly.
testimony, right? You got to be real careful with this witness.
Got to be very deft.
And then you just have the further complicating factor that Angela Paxton is in that room.
How uncomfortable is that? Yes.
Oh, I don't think uncomfortable begins to cover how this is. This is a really tough moment, but I was really shocked when they couldn't put her on the stand because they didn't put her on the list in time. I'm just like, guys, I expect, you tell us we're getting these, really amazing lawyers, but this to me is a really dumb screw up.
Well, look, mistakes happen. Some of the best trial lawyers make errors, but when the moment is big and the stakes are high, you typically make sure that you have your I's dotted and your T's crossed. So I have to say I am surprised.
It was supposed to be a big lead-off for the day, and now it'll be a cleanup hitter for the day. But if the time doesn't run out. You mentioned Angela Paxton. It was interesting yesterday to see the widely circulated photo of her looking down, staring. It seemed to be staring at her wedding ring, staring into her lap, staring at her wedding ring during some of the testimony. I believe it was during some of the Kamek testimony. And so it was, people all had their own interpretations of what Senator Paxton was thinking.
Well, and you can imagine, just even how you moderate your facial expressions and just everything. I mean, that would be, I would not want to be in her shoes. That is a really awful thing. No matter where you stand on this, I would not want to be the wife sitting in the room watching your husband's former mistress testify. That's just.
Here's Dan.
Okay,
We'll
we're back.
sustain the objection.
I was 5 and he was 6. We rode on horses made of sticks. He wore black and I wore white. He would always
We will sustain the objection.
bang, bang. He shot me down. Bang, bang. I hit the ground.
May I proceed? Outside of those 3 lunches in which you ate with Nate Paul and Ken Paxton, did you have occasion to be around them on other times, other occasions?
Yes.
What kind of things would you do together? Where would you see them?
There were 2 types of instances. The first was continued lunches, usually at Pulver's. The second was meeting at Nate Paul's place of business. And I was not part of those discussions whenever those did occur.
So to make sure that I understand, there would be times you were at lunch but not seated at the table and eating with them.
That's correct.
How many times did that occur?
Dozen and a half.
And what about trips to Nate Paul's business? How many times do you recall that happening?
At least a half dozen.
Were you ever at Nate Paul's home?
No.
And did you ever see Nate Paul join Ken Paxton at the office?
Only once.
Okay, we'll come back to that in a moment. Your Honor, at this time, the House offers House Exhibit 704, which is a public record. It is already on file, and there's a business records affidavit attached that has been on file with the court and defense for over 14 days.
Any objection once you read that?
I can almost feel your lips against mine. Your kiss in my mind, but I'm dreaming. So far from home.
Your Honor, there's a facial problem on this exhibit. It claims an affidavit proving up 12 pages of records, but apparently there's 23. I don't know if there's anything in here that matters, but the affidavit is improper and obviously inaccurate, unless somebody wants to correct me.
Your Honor, it's a record of the Texas Department of Public Safety, and pursuant to the rules related to public records, it would be incumbent upon Mr. Busby to establish why he thinks the records would be inaccurate. Also, the page count is likely attributable to the fact that photographs were enlarged and attached.
Again, Your Honor, she's the proponent of this document, it says it's 12 pages, it's not 12 pages. I mean, that right there gives us some element of maybe it's not trustworthy, and she's the proponent, she needs to show us why the
affidavit doesn't match the documents attached. That's her job. Your Honor, I'm confident in my response as it exists, but let me speak to my co-counsel for a moment.
May I approach and give the court a copy of what I'm looking at?
I would also add that at the conclusion of each of the records is a notification that it's a certified copy. It comes in 3 different exceptions to hearsay: business record, public record, and it's a certified copy. Additionally, I emphasize that the Attorney General works for the state of Texas, and these are state of Texas records. It's intellectually dishonest for him to fight them. Mr. President, while you're considering, can I also ask that the clock be stopped? About 10 minutes between the last 2 sections of this. It's an excellent defense strategy, but it's slowing us down since we agreed to all of their exhibits, and they would not for hours.
Your Honor, I'm sorry. This is important. First off, I've been called intellectually dishonest because I look at an affidavit that says 12 pages and it's 23. And now that we're playing games because they're offering an exhibit that's clearly not what they claim it is. So I'm just making my objections, and that's all I'm doing.
Yes, you stipulated it was 12, it's 23.
Yep.
So I am going to overrule the objection because there are 5 large photographs and they account for it, and it is a government document. But I'm not giving you back the time because if you had explained this up front, we wouldn't be having this issue.
That seems fair, Mr. President. I'll go faster.
Overruled. Here's your document back.
Stacy, would you turn to, don't publish it yet, but
704 is admitted into evidence.
turn to the picture we discussed. If we were to show you a picture of Nate Paul, would you be able to identify him?
Yes.
And are you going to feel like I've led you, or if I show you the wrong picture, will you correct it?
Yes.
Yes, you'll correct me?
Yes, I will.
Thank you,
correct.
sir. Permission to publish.
Yes.
Who do you see on the screen before you?
That is Nate Paul.
And is this the same person that was having lunch with KenPaxton on those occasions and whose office that you visited?
It was.
And is this the same person who is currently facing charges in the federal courts?
Objection, hearsay, and relevance.
Sustained.
Is this the same person who was discussing the Mitty Foundation in front of you?
Objection, hearsay. We've already discussed this. This is hearsay.
He was having the conversation with KenPaxton, who's a party opponent, Your Honor. And again, I would direct you to 801.
Overruled.
Thank you. Is this the same person who was discussing Mitty with you and KenPaxton?
Yes.
The same person who discussed that in front of Ryan Bangert?
Yes.
And was he making requests or pressure upon the office?
Objection, hearsay.
Overruled.
What kind of things was he asking the office to do?
Objection, Your Honor, that's hearsay.
Let me go back and do it exactly the same way that he just overruled. Is this the same person who was talking to Nate Paul and KenPaxton about Mitty?
Yes.
And what kind of things was he asking the office to do?
Objection, assumes facts not in evidence. No one's established he was asking for anything. Hearsay.
What was he asking of the office?
Again, Your Honor, she just asked the exact same question. Hearsay and assumes facts not in evidence.
I understand why he doesn't want this in, Your Honor, but can we stop the clock again?
No, we're not going to stop the clock each moment we haven't throughout the trial. If there's a long delay, I will stop the clock and give you time back.
It's bullshit.
There's a sustained objection, and both sides need to stop the ongoing speaking.
Yeah, I mean, especially when he did get a
Don't give him
clarification.
any credit. No order.
None. Is Nate Paul going to be considered a co-conspirator for the purpose of this line of questioning or not?
Your Honor, before you, if I could, a conspiracy requires an agreement. Can I take the witness on voir dire to establish there's never an agreement? A conspiracy at its heart requires an agreement between two parties and then acts in furtherance of the conspiracy. There's been no evidence whatsoever in this trial. There can be no evidence in this trial of any agreement between Nate Paul and Attorney General Paxton. This witness will confirm that. I would like to take him on voir dire to establish that, and we'll put an end to all this.
If I may clarify, it is not incumbent on the sponsoring witness to establish conspiracy. That is an obligation of the court or the presiding officer. This entire case has been about Nate Paul and KenPaxton, and I understand why they don't want it in, but that goes to weight, not admissibility, and he can be crossed on these issues. This entire trial has been about Nate Paul and KenPaxton.
Two questions, Your Honor, to establish with this young man that there's never an agreement. He never heard an agreement, no conspiracy, and we can quit talking about that. They can use this word all day long like they've been, but they cannot establish an agreement between Nate Paul and KenPaxton.
If I may.
We'll stop the clock for a moment. Mr. Busby, come up.
It's bullshit.
It's bullshit.
Total
It's total bullshit.
It's bullshit.
Yeah. Yeah. I mean, especially when he did.
Don't give him any credit.
Okay,
no
Victor,
order.
talk this about what
Yeah, so this is very interesting. We're seeing the clinical
None.
rules of evidence through the barrage
None.
of objections and the responses.
None.
It's all very great.
None.
So what they're probably talking about right now
None.
is
I mean, especially when he did.
Don't give him any
defensive
credit.
request to voir
No
dire the
order.
witness on
None.
a foundational fact that would
None.
be necessary to
None. 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 I mean, especially when he did.
Don't give him any credit. No quarter.
None. None.
It's bullshit.
It's bullshit.
Total
It's total bullshit.
It's bullshit.
Yeah. Yeah. I mean, especially when he did.
Don't give him any credit. No quarter.
None. None. None.
None. None.
you say applies, and it really goes to the crux of
Will we rule on that issue today?
Yes, Your Honor, based on the ruling, I will proceed. I'm going to turn your attention to specific silos in the office. Are you comfortable with that term? Do you know what I mean? In terms of MIDI, foreclosure, open records, and branding Kamek with a search warrant.
Yes.
Okay. Turning your attention to the open records request, who was in charge of the division during that relevant time period?
Ryan Vassar.
And do you recall an occasion in which you were asked to collect a file specific to an open records request?
Yes.
What were you asked to do?
I was asked to pick up those documents for Ryan Vassar and provide them to General Paxton.
Did you do that?
Yes.
What, if anything, do you recall about that package?
I recall that it was in a sealed manila envelope and it had a CD with it.
And when you say CD, I know common parlance, but can you explain specifically what you mean?
A compact disc to go into a computer to maintain digital files.
So something with structure to it that would hold additional data.
Yes,
Why do you remember it being there?
because it was on the outside.
Where did you take that file?
General Paxton.
How long did it stay with General Paxton, or did you collect it at some point?
I did collect it at some point.
How long was it gone? How long was it with?
A week and a half.
After you collected the file, where did you return it to?
Ryan Vassar.
Do you recall during this time frame whether or not you had done any pickups or deliveries involving Nate Paul and Ken Paxton?
The deliveries that I made to Nate Paul took place in May and June.
Okay, and can you tell us about that?
There were 3 occurrences in which I met Nate Paul to pick up or deliver items. The first was to deliver a manila envelope. The second was to pick up the general's phone that he had left at Nate Paul's office. And the third was to pick up documents related to the Mitty Foundation to deliver to Ryan Bangert.
Now, you mentioned the delivery of a manila envelope. Do you recall whether that was substantially similar to the one that you had picked up from Ryan Vassar and delivered to Ken Paxton?
I do not.
Do you recall how heavy or thick the package was?
I do not.
Could you use your fingers to demonstrate for the senators, similar to the way you explained it to us the first time? What is the smallest and largest it could have been?
The smallest that it could have been would have been about this.
I'm sorry, Drew. You want to object? He already said he doesn't remember. Now he's just speculating. Overruled.
Please go ahead.
The way I explained it to the House impeachment managers was this size to this size.
And do you recall whether or not that package had any CDs attached to it?
I do not.
Do you know if it contained any?
No.
So would you be able to tell these senators that it was in any way substantially different than from what you received from Ryan Vassar and delivered to Ken Paxton?
No.
Okay. When we first spoke, do you recall approximately when that was?
May.
May?
May of this year.
And did you want to speak with us?
No.
What did you understand at the time, whether you were correct or incorrect? What did you understand we were doing?
My understanding was that there were questions about funding the settlement of the whistleblowers.
And when you arrived, was it subsequent to a subpoena?
It was.
Was that necessary in order to have you attend?
It was.
Did you arrive alone?
No.
Who were you with?
My attorney.
Who is your attorney?
John Evans.
Is he present here today?
He is.
And why did you retain Mr. Evans?
I retained Mr. Evans 3 years ago after the events that occurred in the fall of 2020. I retained Mr. Evans after being reached out to by the FBI, and after being offered counsel by the Office of the Attorney General, I chose to retain my own counsel that would look out for my own interests.
I want to make sure that I understand. At some point, the Office of the Attorney General offered to provide you an attorney?
Yes.
Are you under the impression you had done anything wrong?
No.
Did the Office of the Attorney General indicate whether or not they wanted you to speak to FBI?
They indicated that they would not like me to speak to the FBI.
And you said to protect your interests. What concerns did you have about using their attorney as opposed to your own?
I would assume that an attorney employed by the Office of the Attorney General would look out for the interest of that institution, but not for me.
And did you feel then that your motives or your interests were not aligned?
I didn't know that they were not aligned, but I wanted to make sure that they were aligned to my interests.
Okay. When we had you come in and speak to us in May of 2023, what was your demeanor, in your opinion, when you first came in? Were you forthcoming and happy to talk?
No.
Were you honest to the best of your ability?
Yes.
And was that statement consistent with the testimony you're giving today?
Yes.
And was it consistent with the testimony, or at least the statements you had provided 3 years before that date?
Yes, they were.
I saw you hesitate. Did you correct yourself on your own at some point during the conversation with us?
I did.
What was that about?
The correction was a question by the House team asking me whether or not I had delivered documents to Nate Paul. Over the course of that discussion, I was asked about it again, and I recalled that I had in fact done so, and I have since verified with my attorney and with other law enforcement officials that that is consistent with my testimony from 3 years ago.
Thank you, sir. There was some implication that we had threatened, or I think it was Mr. Busby talking about squeezing you. Did you feel squeezed?
No.
Did we threaten you at all?
No.
Did we lead you or give you the answers?
No.
So when you made that correction, why did you do it?
I did so because I remembered something and I had misrepresented my testimony whenever I provided an incorrect answer earlier, and so I sought to correct that.
Thank you, sir. I'm going to turn your attention then to the foreclosure and specifically whether or not you overheard any conversations involving KenPaxton related to the foreclosure.
Okay.
Do you recall any conversations?
I recall one conversation.
And what was that?
It was a conversation where I was in Ryan Bangert's office and overheard he and Ryan Bangert discussing...
Sorry, Drew. He who?
General Paxton and Ryan Bangert were discussing the opinion, and General Paxton asked Mr. Bangert if he had been able to reach out and contact an individual. Mr. Bangert responded that this individual had not been helpful in the matter that he had reached out about.
Let me pause you. Not helpful in what way? They just declined to assist?
I'm not completely aware, no.
Okay, go ahead.
The second part of that conversation was in which the general expressed a desire to make sure that grandmothers were not evicted from their homes, and that's where I learned about the foreclosure opinion.
Are you aware that there was a stay related to residential homes at the time?
At the time, I probably was.
So the foreclosure letter would have impacted commercial business, not residential?
Objection, leading, and speculation. Sustained.
I'm going to turn your attention to the Omni Hotel in the summer of 2020. Were you familiar with that hotel at that time?
I was.
Why is that?
During the course of General Paxton's renovations at his home, that's where he was staying in the interim.
Okay, I'm going to come back to the renovations at his home, but help me understand, do you have any personal knowledge of Mr. Paxton being at the Omni in the summer of 2020?
I do.
How's that?
General Paxton called off his protective detail for the time that he was staying at the Omni Hotel. And as part of my job responsibilities, I picked him up and dropped him off each day to the Omni Hotel.
Did Mr. Paxton drop his security detail on few or many occasions in 2020?
It came in spurts.
Help me understand spurts. What would that frequency be?
There were times at which it was highly frequent and I was his primary means of transportation, and there were other times at which we utilized the protective detail.
And while we're on the topic so that I can move a little faster, what about items being on a schedule? Was everything he did through OHE or personally reflected on a schedule?
No.
Is the schedule supposed to contain the comings and goings of the Attorney General?
More generally, yes.
Why is that?
For the assistance of DPS specifically, I would provide a 2-week outlook on the schedule so that they could understand where appointments were, what time, who their POC was at that place and time, so that they could coordinate security efforts.
And were there occasions in which Mr. Paxton's plans were not contained on his schedule?
Yes.
Specifically related to Nate Paul?
Yes.
How do you know that?
Because I managed the schedule.
Did you have concerns about that at the time?
No.
At some point, did it become concerning enough to you for you to speak to a supervisor?
Yes.
Who was your supervisor?
Blake Brickman.
And why would you go to Blake Brickman about such a concern?
I was receiving some new requests in terms of both transportation as well as documentation and scheduling, and I was trying to understand the best way to handle that with my boss, who is General Paxton.
I'm going to return you back to the Omni. On one occasion, were you there with your family?
Yes.
Can you quickly tell this Senate why you were there and for how long?
My family had come down for a weekend. I don't recall if there was any sort of special significance for that occasion. They were down there to stay there for the weekend. General Paxton was also there at that time due to the renovations being conducted on his home, and they were staying down there, and I chose to stay with them for the time that they were at that hotel as well.
Did you have occasion to see Ken Paxton while you were there?
I did run into him, yes.
Can you please tell us about that?
My mom and sister had gone up to the hotel room. My father and I had run back to my apartment downtown. Upon returning to the Omni Hotel and entering the lobby, we turned right to go into the elevators. We had pushed the button and were waiting on the elevators, and on the other side of the door, my father and I heard a lively discussion. Just to be clear, not adversarial, just lively. And whenever the doors opened, two individuals exited. One was General Paxton. He was in workout attire, and he told us that he was going to the gym. The other individual was in a dress and high heels and exited rather quickly. General Paxton walked out, shook my hand as well as my father's. We spoke for a moment, and then he told us he was going to work out.
Was there anyone else on the elevator for which that lively conversation could have included?
No.
And what, if anything, did you notice about the dynamic between the two, if anything at all?
I couldn't overhear the conversation, but whenever they exited, she quickly exited the elevator, and that was the only time I really saw them interact in person.
Did that cause any concern for you or questions?
It did spur some questions.
And who would you have directed those questions to?
I reached out to Mark Rylander about that.
And why did you reach out to Mark Rylander?
Prior to coming to the office of the Attorney General, I had been informed that there had been...
Objection, hearsay.
Sustained.
Did you have reason to think, whether true or not true on the part of Mr. Rylander, this might be something of interest to him?
Objection. Yes. Again, Your Honor, she's just trying to ask a different way. This is based on hearsay.
Overruled.
Did you have any reason to think this might be of interest to him?
Yes.
And was it?
Yes.
Did he seem to understand who it was you had seen?
Yes.
Did you receive a photograph to confirm?
Yes.
Now, I'm not going to show you the same photograph, but I am going to show you a person. Would you be able to tell me if this was the person that you saw in the elevator?
Yes.
May I approach? So used to government work, I forget we have technology. Can I turn everyone's attention to 704? And Stacy, would you pull up the photograph, please? Do you recognize the person in this picture, whether you know her name or not?
I do.
For purposes of the record, the person being depicted in the photograph is Laura Olson, as established by her Texas driver's license. Thank you, Stacy. I have $6.99. Next, Your Honor, the House offers Exhibit 699. It is a business record as established by the affidavit on the face. I'm confident that the page count will match this time, as there's no substantial photographs, and it has been on record for over 14 days. And it is being admitted by agreement, as I understand it.
Any objection?
No objection, Your Honor.
Admit Exhibit 699 into evidence.
Now, Mr. Wicker, I'm not going to have you do this, but inside of an apartment complex application, would it explain where you have lived before, where you're going to live now? I know that didn't make sense. Are you aware of the fact that application leases will establish your prior address as well as your current one?
Yes.
And is the name on that record the same as the driver's license, Laura Olson?
It is.
Is that the woman that you saw step off the elevator with Ken Paxton?
It is.
You mentioned home renovations. Do you remember why those renovations were occurring?
There were storms late spring that caused water damage to General Paxton's Austin home.
Okay. I don't want you to give the address, but could you give us the street name so that we're all familiar with the fact that we're speaking about the same thing?
Margarinita Crescent.
So you said spring. Do you recall what month the damage occurred in?
This probably would have occurred March, April timeframe.
Okay. And do you know where the damage was?
To the best of my recollection, it was confined to the master bedroom.
Why would you know that?
I met with the insurance adjuster multiple times at the request of General Paxton while he was out of town or in other meetings.
So there were occasions where you were authorized on his behalf to conduct personal business, for example, the adjustment of the insurance?
I was authorized to greet the insurance adjuster and show them the home.
Does that mean you would sometimes also receive records related to the home renovation?
I can only think of one occurrence in which that happened.
And what was that?
I received an invoice that I had been included on from the STEAM team.
And are you aware, as the adjuster, that there are some renovations that were done pursuant to the water damage itself and covered by insurance?
I would assume so, yes.
Okay. I'm going to turn everyone's attention to House Exhibit 703. Again, it's a business record. It's Cupertino Builders. There is a business record affidavit, and it's been on file for over 14 days.
Any objection?
No, sir.
Admit 703 into evidence.
Stacy, would you please pull up the face of the email that's attached? Mr. Wicker, do you recognize the name of the individual who sent the email?
Kevin Wood.
And who is Kevin Wood?
Kevin Wood was the lead contractor at the Paxton's home renovation.
Is he someone that you met personally?
He is.
How many times did you see or speak with Kevin Wood?
At least a half dozen.
And do you see that on the to line is the name Raj Kumar?
I see, yes, I do.
And moving down further, do you see that Nate Paul was or N Paul at worldclass.com was the person who emailed Kevin Wood?
I do.
Where is that? What are we looking at?
Is the body of that email related to home items or repairs, things that need to be done?
It would appear so, yes.
I'm going to have Stacy then turn to the first couple of pictures in the file. Can we see the next? Does anything about the home being depicted look familiar to you?
Several of these images do appear to be, that's the Paxton's dining room.
Are you wondering or are you sure?
No, I'm positive.
Thank you. On how many occasions were you at the Margarinita home in the summer of 2020 during renovations?
During the renovations, half dozen.
Okay. And do you recall any times that you were present where Kevin Wood and Ken Paxton were both there?
I do.
I'm going to turn your attention to a conversation about the kitchen. Do you recall whether or not there was any damage to that area of the home?
I do not.
Would it make sense then that these are things external to insurance coverage?
It would make sense.
Is that an area of the home that you ever discussed in regards to being an adjuster or a adjuster, rather?
Not to my recollection.
Okay. Can you walk us through any conversations you overheard between Kevin Wood and Ken Paxton?
Objection, Your Honor. Anything Kevin Wood may have said would be hearsay.
At this stage, Your Honor, it's not being offered for the truth. It's to set an anchor. I will get more specific in a moment.
Again, Your Honor, the question is very nonspecific, and anything she's going to ask about what Kevin Wood may have said is hearsay.
Your Honor, it is clear from the course of the conversation that Kevin Wood was acting as a service provider. At that point, the truth doesn't matter. At the point in which it does, it goes to his motive, intent, and plan.
Again, Your Honor, you've already, she just said what Kevin Wood said wouldn't matter. I agree. Hearsay and irrelevant.
I didn't say it ultimately wouldn't matter, Your Honor. It will matter very much.
Sustain.
Did you get an idea as to what the relationship was between KenPaxton and Kevin Wood?
Kevin Wood was the lead contractor on General Paxton's home.
And if Mr. Paxton then wanted additional things or changes to the renovation, whom would he speak with?
Kevin Wood.
Is there any other way Mr. Paxton would find out the timing of renovations or the duration of renovations or the cost of renovations other than Kevin Wood?
Objection, compound, and speculation. She is asking what Ken Paxton would do and what he would know. That's pure speculation.
It's an operative fact, Your Honor. There's no other way for him to know it.
Again, she just asked what Ken Paxton might know. That's speculation.
I'm going to overrule. You can answer if you know.
Not to my knowledge.
I don't even remember the question at this point, frankly. I might have to read it back. At any point, were there conversations about changes to the property?
Yes.
Isn't that the entire point of a contractor?
Yes.
And at any point, were there discussions about particular items in the home?
Yes.
Would what matters to you be whether a counter is granted or not, or whether the renovations are occurring at this stage?
Objection, vague, and relevance.
Did you care what his countertops were made of?
Again, Your Honor, what does it matter whether young Drew Wicker cares about the countertops? It's irrelevant.
Overrule.
Did you care what the countertops were made of?
No.
Did anything about a conversation related to countertops concern you?
Objection, hearsay.
It is not being offered for the truth of the matter asserted. There's no statement. It asks if he overheard something he was concerned about.
She just asked for hearsay right there, Your Honor. That's hearsay.
No, Your Honor, it goes to state of mind.
Overruled.
Thank you. At some point, did you hear something that concerned you?
Yes.
What was that?
Objection, hearsay.
Your Honor, there's three places. One, nucleus of operative facts, because it goes to the center of this. Specific to hearsay, it goes to state of mind. There's no other way for General Paxton to know how long something is going to take or what it will cost other than speaking to his contractor. And finally, it goes to Drew Wicker's state of mind in regards to what he does next because of what he heard, whether the statement is true or not.
Your Honor, we need to know who she's talking about was speaking. I think she's trying to elicit testimony about what this man heard a contractor say who has been subpoenaed and who could come here and testify. This is not the right witness for that.
I'm going to overrule. You're not saying it's the truth of the matter, just the statement was made.
That's at this point, Your Honor. Mr. President, thank you. What did you hear that concerned you?
Kevin Wood stated that he would check with Nate on several of the items.
Now, was that about how long something would take or when something would be delivered?
No, sir. No, ma'am. It was with regards to cost.
Now, if Kevin Wood's a contractor who's trying to make money on his own, why would he need to check with anyone?
Objection, speculation.
Sustained.
So let's back up a little bit. What would he have to check with Nate on specifically? Please tell us in detail what you recall.
He was stating that he would need to check with Nate on the cost of countertops and renovations to the cabinetry in the kitchen.
I'm going to be very specific. Did he have to check on the cost, or did he have to check on, did Mr. Wood seem to already understand what the cost would be?
Yes.
And what was the cost?
He mentioned the total of $20,000.
For what?
For the cabinetry and the countertops.
And what was Ken Paxton's response? That he wanted to do it or did not want to do it?
He stated that he would like to move forward.
And then what was said by Kevin Wood?
He said, I would check with Nate.
Did you relay that conversation to anyone?
I related to 2 individuals.
Were either of them people who worked above you in the Office of the Attorney?
Yes.
Were you relaying the information to be salacious or for another reason?
I was seeking advice.
And who did you speak to?
I spoke to Mark Rylander and Blake Brickman.
What did Mark Rylander or Blake Brickman advise you to do?
Objection, hearsay.
Your Honor, Okay. What did you do after speaking to Mark Rylander and Blake Brickman?
I spoke to General Paxton.
What did you say to Mr. General Paxton?
I asked him about the conversation that I'd overheard, and I stated that I walked away with a certain impression, and that
Pause you. With what impression?
I walked away with the impression that Nate Paul was involved in the renovations of General Paxton's home.
What concerns did you have about that?
Given the fact that we were working on several items related to Mr. Paul, it felt as though there might be an inappropriate relationship there.
Were you that clear with the General?
Yes.
And what happened?
He stated that he appreciated me bringing his concern to him, and that he then assured me that that was in fact not the case.
Did his explanation absolve all concerns?
No.
How did you feel at the conclusion of that conversation?
Still uneasy, but I never discussed it after that with him.
Okay. Are you aware of the fact that we've issued subpoenas for Kevin Wood for him to address these issues and that he does not intend to testify before this court?
Objection, speculation. She's just testifying now.
Sustained.
Did you spend much time at the Paxton home after that?
Not much, no.
Why not?
It was a mix of ongoing renovations, increased travel, and just lack of requests to be there.
Did you feel comfortable about the home or being present at the home?
Not always, no.
Why is that?
There were still some lingering concerns over the questions that I'd asked the General, but I had not followed up on those concerns.
In the summer of 2020, prior to the whistleblowing allegations, did you have an opinion as to the veracity or the truthfulness of Mark Penley?
Yes.
And what was it?
He seemed to be an individual of the utmost integrity.
And did you have an opinion as to the credibility or truthfulness of Jeff Mateer?
Yes.
I'm sorry, it's not proper for one witness to talk about whether another witness is truthful. That's just not how it works.
It absolutely is, Your Honor.
So please let me finish and quit interrupting, please. Your Honor, it's not proper for one witness to sit up on the stand and say, this person's truthful, that's not how it works. It's improper, I object.
He's absolutely right in a vacuum. I would have no authority to talk about the character of truthfulness as a primary rule, and I wouldn't infringe it. But once he attacks their credibility, Rule 405A1 allows me to establish by reputation or opinion a relevant character trait. In this case, truthfulness.
That's not how it works, Your Honor.
Yes, it is.
Anyway, this is not how it works, Your Honor. You don't get up here and bring one witness and talk about the veracity of all the other witnesses. Now, if she feels like Mr. Penley's veracity was challenged on some particular statement, then she brings a different statement to try to rehabilitate him. But she don't do it with this witness.
You could do it with any witness, Your Honor.
Will sustain the objection.
How did you communicate with KenPaxton in 2020?
Through email and text message and phone calls.
How many cell phones did KenPaxton have?
He had 2 primary, and he later obtained 2 more cell phones.
I learned through the course of opening that I used the term burner phone incorrectly. Apparently, they have to be cheap and from 7-Eleven. What would you call extra phones that most people don't know about?
Extra phones.
Okay, so two primary phones, 2 extra phones.
Yes, ma'am.
Do you have the phone number of his personal phone?
I do.
And would you give us the last 4 digits of that, please?
cell phone is 8128.
And what about his work phone?
0220.
Can you describe for us physically what the other two phones look like?
The other two phones being the extra?
That's correct.
Okay. The other two phones, one was a Samsung Galaxy Fold, the other was a red iPhone.
You mentioned that you also communicated with him by email. Outside of work email, did he have another?
He did.
What kind of account was that?
It was a Proton mail.
And do you know how the Proton account was set up?
It was set up through the OAG's office.
Why was that?
We went to China.
So it was safer to discuss business on that phone than it would be for a Chinese hacker to get into a personal cell or a work cell, correct?
Yes.
But do you also know that their headquarters are out of the United States?
I believe they're in Switzerland.
And so they wouldn't be subsequent to a search warrant and are not provided as part of a public records request to the OAG.
Objection, speculation, Your Honor. Sustained.
And are you familiar with something called Signal?
I am.
What is that?
It is an encrypted messaging app.
Encrypted, also making it safer, correct?
Yes.
Are you aware that they too are housed out of the country, not subsequent to, or not under the pressures of a subpoena and not provided by the OAG?
Again, Your Honor, this is just her testifying what she thinks Signal is. This witness doesn't know this. It's speculation and improper.
Sustained.
At any point, did General Paxton ask to use technology that you provided?
Yes.
What was that?
He used my personal cell phone.
How many times did the General use your personal cell phone?
At least 3 to 4.
Were you able to hear those conversations or who they were with?
I was not.
Were you able to determine after you got your property back why he needed your phone?
No.
Why not?
Whenever I received my cellular device back, the call log had been wiped.
And did he use anything of yours other than your cell phone?
No.
Do you recall after the whistleblowers, Mr. Paxton asking to use your laptop?
Yes.
What was that about?
That was a request. He was working on a letter to the Inspector General of the United States.
Can you anchor that in time for us? What had just occurred?
This was late October, and this would have been after the whistleblower complaint.
And do you know, what were you asked to do?
I was asked, General Paxton handed me a hard copy of a document and asked me to transcribe the events outlined in the document in the form of a letter to the Inspector General.
And by hard copy, you mean like what I have here?
Yes.
So not handwriting, but typed written?
Yes.
Why would you need to be provided a typed written copy of anything that's already in electronic format?
Objection, speculation. Overruled.
Why would you need to be provided a hand copy of anything that's already in electronic format?
I don't know.
And what were you asked to do? Transcribe, you said?
Yes.
Were you making additions or deletions?
I did make several additions, yes.
What kind of additions?
Since it was asked to be in the format of a letter to Inspector General Horowitz, it was addressed to Inspector General Horowitz. There was a slight introduction that I'd been asked to include, and then this sign-off was asked to be as General Paxton.
At this time, I offer House Exhibit 573. This is part of the Office of the Attorney General records. There is a business record affidavit. It has been on file for greater than 14 days.
Any objection?
No objection, Your Honor.
Please admit Exhibit 573 to evidence, into evidence.
Mr. Wicker, will you take a moment and look at the body of that letter and let me know if you recognize it?
This is the letter that I was asked to write for Inspector General Horowitz.
So if I turn you to the top where you add Dear Mr. Horowitz, you typed that in?
Yes.
Do you know who that is?
He was or is the Inspector General of the United States.
We've heard about the Office of the Inspector General throughout this trial. Do you know whether or not that's the appropriate person to go to if you want to make complaints about federal prosecutors or federal agents?
That is my understanding, yes.
At any point prior to the whistleblow situation, had KenPaxton talked to you about or in your presence about the Office of the Attorney General?
About the Office of the Attorney General, yes.
Had he ever suggested going there or that they were the correct place to bring this complaint?
He had not mentioned that to me, no.
In fact, do you know that he didn't want to take it to OIG prior to that?
Objection, speculation. Overruled.
Do you know whether or not he wanted to take Nate Paul's complaint to the OIG prior to the whistleblowers coming forward?
I do not.
And then once you look at this letter, I'm going to turn you down to the bottom in regards to the allegations made by Nate Paul, and I'm going to go quickly. Did these amount to things like not getting to use the restroom?
It did.
And when you drafted it, did you realize part of Nate Paul's big federal complaint is that he couldn't call his attorney except from using an agent's cell phone?
Yes.
And that he was not allowed to call for counsel, and that's why they provided him a cell phone?
Yes.
Are you aware that the only allegations he makes, well, let me do this differently. Where were you when you were helping type this up for the General?
This letter was written in the Office of the Attorney General.
On what laptop?
My state laptop.
And what did you do with the laptop after typing up the letter?
I followed up with General Paxton about having completed the transcribed letter.
And then what?
And I asked him what he'd like to do with it.
And what was the response?
He said that he had several insertions that he would like to make and that he would let me know about when he needed it.
Did he have you email him or put it into a USB drive?
Not to my recollection, no.
What did he do?
He asked me to bring my state laptop to his Austin home so that he could work on the letter.
And did he make changes to your knowledge?
To my knowledge, no.
Okay. Okay. After drafting the letter for the Attorney General, do you know whether or not the letter was ever sent to OIG?
I do not.
Let me turn your attention then to the conclusion of your career there. What was the status of your job?
The status was that I was both the scheduler as well as the executive aide.
Well, I mean, at the end, in October of 2020, leading into November. Were you offered a promotion? Were you offered a change in job function?
I was.
And what was that?
General Paxton had expressed an interest in myself taking on greater responsibilities with regards to certain policy areas, and that I would continue with my present job responsibilities, but also take on the additional policy-related responsibilities.
And at some point you'd mentioned that FBI had reached out to you and you make KenPaxton aware of that. Is that accurate?
Yes.
And what did he do?
General Paxton's question that he asked me was, why?
Did you have a response for him?
No, I did not.
What, if anything, did he direct you to do?
He did not direct me to do anything at that time.
Did he take you anywhere?
Not at that time, no.
Okay, ultimately, you say not at that time, so what happens next in regards to that?
The next discussion I had with a member of the AG staff regarding the FBI was Brent Webster requested to meet with me.
And what, if anything, did Brent Webster have to say on behalf of the Office of the Attorney General?
Objection, hearsay, Your Honor. Sustained.
Was he working in his official capacity as a representative or employee of the Office of the Attorney General?
That is my understanding, yes.
Same question, Your Honor, subsequent to 801 ED, which is specific to representatives or employees. Brent Webster is making the comment to Mr. Wicker in his capacity as an employee of KenPaxton.
It's the same objection, Your Honor. We've established in this trial, you can't, that's not how it works. You cannot just come up here and ask him what somebody else said other than General Paxton himself.
You can when he's being directed as part of his employment.
He's not an employee of KenPaxton.
He's an agent of KenPaxton, so we'll overrule.
Thank you. What, if anything, did Brent Webster tell you?
Mr. Webster said that he understood that the FBI had reached out to me and that I should not respond.
Did he tell you why?
He said that I ran the risk of incriminating myself.
And did he then bring you back to KenPaxton?
Eventually, yes.
What was that conversation about?
He believed that there was an opportunity to assert attorney-client privilege.
So he too wanted to prevent you from speaking to FBI?
It certainly seems that way, yes.
And were you asked to speak to anyone else about this?
Leslie French.
And what did she tell you to do?
Leslie French advised me that she had been through something similar and that there was nothing to worry about, that the AG's office would provide me with counsel while I met with the FBI, and that there was no need for me to bring my own counsel.
What was your response?
My response was that I would feel more comfortable retaining my own counsel that would look out for my interests.
Why did you respond that way?
Because that's where I would have been that's how I would have felt comfortable in that instance.
After all of this, what decision do you ultimately make about this promotion?
The conversation that occurred regarding the promotion was all at once, and this was actually, I informed General Paxton that I would not be taking the promotion, but I would gladly accept the responsibilities.
Why were you making that distinction?
I did not want the general to have the appearance of having offered me anything in light of the FBI reaching out.
So you were trying to protect the appearance of what that would look like for General Paxton?
For General Paxton and myself.
Thank you. Did you ultimately put in your notice and quit?
I did resign, yes.
Was that on November 2nd, 2020?
If I recall correctly, yes.
Makes sense then that payments would stop, is that correct?
Yes.
And did they stop from the Office of the Attorney General?
They did.
Did they stop overall?
No.
Were you provided?
I was continued to be provided a monthly stipend by the campaign.
Did you notify Ken Paxton's campaign that you were still receiving money and that you should not be?
No, I had let them know that I was leaving and to cut off my access to both the email and the calendar, and that I should cease receiving stipends.
When did you cease receiving stipends?
Not until the following year.
And what, if anything, did you do with that extra money that you had been provided?
Michelle Smith had sent me a W-2 with that amount. I contacted her, not understanding that I continued to be paid. I asked her what I should do with the money and if General Paxton would like it back. She reached out to General Paxton, who informed her to tell me to keep it. And I stated no problem, and I went ahead and donated the money back.
They told you to keep it and you donated it back?
Yes.
Why did you do that?
I didn't do the work.
How did you feel about receiving money from Ken Paxton's campaign after you ceased employment and in light of all the facts relevant today?
I have no reason to believe that it was with malicious intent. It might have been an innocent mistake.
I think maybe more specifically, I'm talking about your character. What made you return it?
I didn't put in the work, and I did not want any instance, I didn't want it to appear as though I might have any conflict of interest if anything like this ever came about.
Thank you, sir. Pass the witness.
We're going to take a break now, and members, we went longer in this section, so we'll take a 20-minute break, and then we'll go till 12:30. We'll move lunch 12:30 to 1:30 today. So be back here at 15 minutes after 11.
Okay. I'm going to start with Victor, because you're the legal guy.
Right.
Walk us through this.
So there's a lot going on. There were lots of objections, as there have been throughout the proceedings. So I want to talk about what we saw today. There's a lot of back and forth about the admissibility of testimony regarding what other people said. And the prosecutor was talking about a co-conspirator exception, which is an important exception when there's a conspiracy trial. We even use it in civil cases as well. There was a bench conference, and at the bench conference, what was happening, and the trial aficionados like me will appreciate what the rule I'm about to talk to your viewers about. Texas Rule of Evidence 104 indicates that when lawyers like Busby are making objections like they're making, the judge has to rule on any preliminary question that goes to the admissibility of evidence. The judge could have allowed voir dire of the witness, but it appears that the governor at the bench conference basically ruled on the objection in favor of the defense. And I could tell that by the way the prosecutor pivoted away to another subject.
Well, I got a text message from one of the attorneys that was on, and he says co-conspirators are not, all in caps, hearsay, and that he says all statements by Nate Paul come into any courtroom anywhere in the U.S. You don't have to definitively prove a conspiracy for the admission of evidence. Busby's objection goes to the, quote, weight and credibility for which Busby has the opportunity to cross-examine him upon the statements. But
so you don't have to prove the conspiracy beyond a reasonable doubt or by a preponderance of the evidence even to establish the admissibility of the statement under the exception, but there has to be some proffer or some showing that satisfies the court that the statement is admissible under that exception. Personally, I think the exception was established, but obviously this is not a courtroom, this is a Senate impeachment trial.
But he's letting some of it in, but not all of it.
Well, you know, there's some instances today where I'm thinking that should be sustained and it's overruled, that should be overruled and it's sustained. For the most part, it appears that he's trying to get it right. He's consulting with the legal advisor on the rules of evidence.
Bud?
Well, Busby's playing Dan Patrick like an old fiddle. You know, he just, you know, he's gotten his way now. He's convinced Dan Patrick that he can't let Nate Paul be considered a co-conspirator, which is, you know, the basis of the House's prosecution. And so he can't get that across to Dan Patrick yet. Every time something comes up, he's trying to tell Dan Patrick, that's not the way it works. That's not the way it works. And he's trying to tell Dan Patrick the way it works. You know, he's continuously objecting to everything. You know, the clock continues to run. And, you know, it just continues to be this, you know, the Tony Busby show, even though the prosecutor, Erin Epley, is doing an excellent job. She is pushing this witness through. She knows she's on a clock. She's playing a fast game. I wish she'd been questioning some of the witnesses earlier in the trial.
Yeah, I think you're right. I think it would have made a big difference because there was a lot of time spent on some of these early witnesses. And now we have to wonder, are we going to get to Laura Olson? Are we going to, I mean, based on the way the clock's been running, probably, but it's going to come down to the wire.
It's going to come down to the wire, and I agree. She has been moving at a rapid fire pace with a witness that you probably wanted to be a lot more methodical and slow with.
Well, the one point is, though, that Rusty Hardin's more effective with the jury. The jury, you know, the old folksy members of the jury, you know, react to the old folksy prosecutor. And they probably also think Erin Epley's a little too clipped and a little too rushed. They probably have the same misogyny that Tony Busby.
Talk about patriarchy?
Well, yes, showing that Tony Busby's showing. So, but you know, Epley is doing a good job, but I'm not sure the Senate appreciates that.
Well, I personally appreciate her approach because I feel like we're moving through these witnesses a lot faster. We're getting where we need to go, and we're not. I guess I got a little tired of the Matlock approach. Let's move it along, guys. I mean, because it just felt like with some of those, it took forever with Mateer and Bangert and some of these earlier ones. It felt like we could have moved through this a little quicker, and I mean, you know, Bud, you were saying earlier you didn't think that they haven't what they need to get these senators convict. So, or not convict. I don't use that word. Sustain.
Sustain.
So you know, if you want to get through what you need to get through, you needed to move this case expeditiously.
Well, you know, time is short now, and
Very short.
You need to play fast. You can't run the ball. You know, you have to throw deep, and you have to, you know, you have to make first downs, and that's what they've got her in there doing.
What do you think about Victor? About, you know, just this testimony about the renovations? How effective was that?
Well, the way I want to talk about that is to comment on how quickly we're moving through this testimony. You want to plan your testimony and your witnesses so that when you get to testimony like this, she's very effective in being efficient and moving quickly, but you don't want to move this fast. And my impression is that with better clock management, we would have delved more deeply into some of the testimony that we've heard from this witness.
But she kind of doesn't have a choice. She doesn't have a
She
choice.
doesn't have a
Rusty
choice.
Hardin didn't leave her a choice.
Right. She doesn't have a choice, but in answer to your question, in my view, it's not as effective as it could have been if she could have slowly unwound it with more time.
Yeah, the $20,000 countertops came and went.
Right.
You know, the $14,000 to Brandon Kamek yesterday, we dwelt on for 20 minutes. But today, the 20,000, was that how much it was?
It was. I wrote down 20,000.
The Kamek, I mean, yet today the $20,000 just is, and then we went from $20,000 to 4 phones to, I mean, it was this.
Well, right. I wanted to hear more about it, but I understand why she had to move on.
Yeah.
She cannot dwell on it.
No, absolutely.
She's got to manage the clock here. We're in the fourth quarter. I mean, I'm not much of a football person, so I probably shouldn't speak in football analogies.
You got it right.
I mean, I know a little bit. I mean, I am an American here. But, we're, was it fourth quarter down to the first yard line, or maybe we're not that close, but we're getting close.
I've fallen, and I can't get up.
We're sending help immediately.
Say my name. Say my name.
She showed you lies. I'm going to show you the truth. I'm going to unleash the news.
Hi, I'm on the floor. I can't get up. I'm really, really sick, so thought I would just shoot you a video. You can see my perspective now. So now I'm in the hallway. I can't live like this for much longer.
No, Raina, not doing it. Oh, great. I'm having like stabbing fucking pains in my gut. I haven't had this in a while. This is her. She's doing dark spells. I rebuke your fucking spells and the dark demon that comes through you. In Jesus Christ's name, I rebuke the dark energy in you that comes through you, whatever. Don't you ever come anywhere near me, and I defer to my higher power to take this energy and do it as thou wilt. I say a mirror, a Christ-shaped box with the mirror finished facing inwards for 10 million years. This energy is never to touch me again. Yeah, they do this. They do. I don't know if they've got voodoo dolls or sticking pins in my gut or something. I have no fucking idea. But now I'm gonna have to go because I'm having a serious gastric problem. It's not a fucking gastric attack, LARP. It's a real thing. I want to read what you're saying, but I really should sign off, but I literally can't even sign off because I'm having a stabbing pain in my stomach. I'm having a gastric attack, so I'm upside down on an exercise ball. My sister just fed me something. Sometimes I worry that there might be rat poison in it. Oh, yeah, I gotta sign off. I'm in bad shape.
Hi, I'm on the floor. I can't get up. I'm really, really sick, so I can shoot you a video.
Just in case, just know that. Hopefully not. I'll come back later if I'm not dead. I'm not kidding. No welfare check needed though, right? Hey! Did everybody leave?
I'm Betty Washington. Malibu Sky used to be one of our warriors, and she asked us for money to help with her house and a car. She said that she was going to have her car repossessed and all this stuff. So I was like, well, go make a GoFundMe, you know, and we'll help you out because that's how we do it. Or we'll pay the bill for you or something like that. You know, that's how we do it. And so she comes to me and she's like, well, I can't make a GoFundMe. And I was like, why? And she's like, because I've had several other ones.
Read your comments and I can't. I'd have to go lay on the ball, like on the you know, the exercise ball. I have to lay on it. Well, there's different names for it. Someone says it's a hiatal hernia. Somebody says it's not like colitis, ulcerative colitis. No, it's not. I don't know. I can't explain it, but I don't think I'm going to be able to read your comments. I have to get on this ball right now, which is not blown up enough.
We rode on horses made of sticks.
Damn it. Oh, God. Oh, dear Lord.
He would
I
always
pray, give me a
win the
full
fight.
healing
Bang,
right now.
you shot me down. Bang, bang,
Evil, I rebuke their person, I rebuke their spells, no weapon formed against me shall prosper ever. Any swing of space of time or direction. I knew I should have gotten this pill.
She brought it out. Now, mind you, the whole time that she had been with us, she never said she was sick. Not one time to us.
I gotta deal with this. There's a bunch of things. I might have to even just get in the bath. That's all about. Can help with all the. Anyway, the hiatal hernias and all the organs start oh, you're fucking discrediting, fucking denigrating lies and slander.
She's 11 years old. She has no kids, no husband, and I'm not going to support
Tried not to fall off the ball. It really doesn't have enough air in it, quite honestly. Let's just go back to this.
Didn't even take the time to lie.
That's not a fart. I still want a fucking ball. That's just like scrub me something. The last thing I need right now. Did everybody leave?
The evidence part. So, he said the evidence is there.
He's got to be over the target then.
Hey, we're getting the band back together here.
Uh-oh.
Angela's here.
Yeah.
That's when the trouble starts.
Oh, shit.
And say Detective Word Salad ABC, who protected a convicted pedo and helps edit videos for a convicted murderer, but he's gonna throw stones. That's what I.
Well, first of all, you redhead witch bitch. I didn't make videos for John. And as far as protecting a PED, you guys are the one that need to make Kim into a victim of CP, but you won't go after the pred. For some reason, they don't go after the preds and troll them but they like to protect them. But I'm supposedly supporting a Pete, but they don't. They're not going after the Pred that planted CP on Kim's computer for some reason, and I didn't make videos for John. So anyway,
Wanted to say
let's go back. Let's listen to her say that
that
again.
it videos for a convicted murderer, but he's gonna throw stones.
Whoa.
That's what I
Wow.
wanted to say.
Yeah.
Yeah.
As she goes on for another
I wonder
hour.
what about that? Like, how do you throw stones when you got all that going on with actual convicted people? I'm just trying to understand it.
Well, obviously, you know, he's expert at background information and did his research when it came to JD.
Oh, right.
Right.
Yeah. I'm sure he's heard all the documents being
See-
read lately.
I hope.
See, usually what I do is I'm too busy to look everybody up, like everybody needs me to look everybody up for them. So what I do is wait for people to bring out the charges, and I'll go by what somebody says until somebody brings out the actual charges. But you see, the thing is, okay, is you got this lady here, okay, Kim, right? She accused Clovis of planting CP on one of her devices or, you know, something like that. And then the civil case gets dropped day before court, right? She's supposed to be a victim of CP. But watch who shows up, right? This is great.
So, yeah, he likes to hang out with straight up convicted criminals, but he wants to talk about Edward.
Oh, yeah. So Edward shows up, and amazingly enough, the CP suspect, but that was back in 2019, right? That case is, I don't believe is closed, but the CP suspect, Edward, shows up, has had 5 charges, gets it dropped down to 1, serves 21 days for meth, right? Okay, so we're gonna go through it, okay? This guy, Nick Cuck, big alcoholic, right? Scotty MMA, used to be a crackhead. And, well, these other two, right? Meth head right here. Meth head Edward. Right? Oh, wow, this is great. I'm not the one that's got the charges, people.
You fucking idiot.
Speaking of which, is this Edward?
Oh, shit. Yeah.
Hey.
All right. Yeah, go, PEdward Defense Force. All right, you guys are doing great. Yeah, panel full of meth heads, doing good, and an alcoholic.
What's going on?
Edward, look at this panel.
Welcome
to the panel.
He's not the dumbest motherfucker.
He is. This is like birthday stuff right here, Kim. Wow, I'm telling you. Yeah. Ooh, birthday stuff.
Where are you, Emwen? You crying bitch? Where are you? Where'd you go? Come on, you want to talk about Edward? Let's talk. Come on. And Nicola, and now that's not true. And one of these days, when all this stuff comes flying out,
yeah,
you're gonna be.
Hey, all of a sudden I got Scotty MMA calling my phone, but it's probably just Anton ghosting his number. He's trying to get us to fight more. Seriously, Anton's been ghosting numbers as other people to try to get you to answer, and if you don't, then all of a sudden he'll spam your freaking phone with texts and voicemails. That's some pretty fucked up shit, man. And it's actually causing damage to my device. Actually, that's illegal, dude. Because he's so butthurt because his buddies that probably hired him to spam the shit out of everybody, they're getting destroyed. So whenever they come up, all of a sudden Spamton pops up somehow.
Oh, this panel looks racist.
you're gonna fucking apologize for all your PEdward.
Oh my goodness.
Yeah.
Okay, Token. Let's see. I know the guy that used to call
Oh, I don't care. The country
Urban.
can say whatever she wants to about it. Fuck her.
I know you're used to it by now. It's been many months.
Racist.
Racist. It's a racist panel. Oh no.
Listen, it was Eric that called Urban Token, wasn't it?
Yes. Yes. I believe so.
Nicola, you don't know that either. I'm not going to argue with you. I think you guys just take whatever you're fed sometimes and you go to the bank.
They cashed it in already.
Yep.
I'm telling you, it's gone.
But Aaron, on the other hand, there's convictions going on with those people.
Yeah,
Sure
what
enough.
did you say a minute ago? I'm not the one.
I know. You don't even have charges. Unbelievable. But Aaron's hanging out, editing videos, doing all that with a guy that is convicted of taking somebody's life.
So Aaron's the kind of guy that would buy condoms for a family.
Probably.
Wow. Listen to that sick projection coming from CP suspect PEdward. And wow, once again, staying on loop. Redhead witch bitch, Spamsla G, trying to say I'm making videos for John when I didn't. It was for Vic, right? But they're not going to bring up that PEdward's wife accused him of marital rape, and also psychologically mind screwing minors, and especially children with special needs. Wow, in the same house. And they're not going to bring up that he should, pay his child support for some reason. They're going to stay on loop with the things that we've fed them to be able to deflect away from these serious things, like the CP case. Interesting. Involved in a CP case. No, definitely a victim, because Scotty, the old crackhead Scotty, says that Kim is a victim of CP, but they don't have a culprit for some reason, right? This guy suspected of CP and living with his brother that is also a suspect of CP. Okay, all right, keep going. Yeah.
Yep, that's for sure. That's for sure.
Yeah, see.
God, haven't seen all of us on a panel.
Hey, something I didn't notice is that you got PEdward there. Watch what he does with his bullshit little meth troll tactics on his little cue card, and he's not doxing with his chest either. Okay, when he talks shit about Mr. Cox, he gets all quiet. Oh, he's just gonna do some meth head trolling in his cue card and change his name around and his picture. Good thing I taught him how to do that a long time ago, the fucking dumbasses. Took them long enough to, figure it out. Dumbasses.
You see how it's got to be repeated to try to sink
it in, like they're trying to apply either voice to skull or some type of neuro-linguistic programming. Just gotta repeat it. Oh yeah. It's true. He made videos for a convicted murderer. No, I didn't, and not even for the rodent. Didn't make videos for him.
They would take mine. Rodent took mine and used mine, so you guys could go around and say, oh yeah, he working with the pedo because he took one of my videos and using it. Okay, and it wasn't even really my video. It was just a music mix video. It's not even mine, so anybody can download it and use it. But they'll weaponize the sickos, just like for some reason this PEdward Defense Force really protecting their PEdward. Right? Oh my gosh, so great. Listen how she got to try to be so convincing on loop that I made videos for John.
Convicted for taking somebody's life.
Well, Aaron's the kind of guy that.
Hold on, there you go.
You don't even have charges.
Yep, don't have charges. Not me.
Unbelievable. But Aaron's hanging out, editing videos, you know, doing all that with a guy that is convicted of taking somebody's life.
Well, Aaron's the kind of guy that would buy condoms for a family.
Probably. Mm-hmm.
Dude.
Mm-hmm.
Edward, actually, I've seen pictures of Edward's family, and I can see how these guys project so hard that PEdward, okay, more than likely is the one that should show up to his family reunions with condoms. Just saying, PEdward.
Yep. That's for sure. That's for sure. God, I haven't seen all of us on a panel together. I think it's been a few years. All of us at the same time.
Yeah, it's been a minute.
Right?
Why doesn't Aaron come back?
Oh, I don't know. He only talks shit when, you know, people aren't around to defend themselves.
He wasn't making any sense as usual. It was all that word salad stuff he does. He just puts a bunch of names together and makes it a sentence.
Yeah.
That's
and does it loudly.
That's what I think Spamsla G does in the chat rooms when she starts spamming it up when she gets all pissed off and they're losing their narrative bullshit. Isn't that great? Oh yeah, and the reason why I took off real quick is I knew there wasn't going to be any debating, right? It was just a yelling contest because Kim's spazzing out and she was going to go to bed an hour ago. Right, but I'm not gonna panel up with known meth head and CP suspect like this guy here, right? And I think that's being worked on, right? I'm thinking there is something there, and the reason why he's not being investigated is the whole reason further. The reason why he's not being charged with CP. There's a reason why Kim's case dropped the day of court for some reason. Yeah, I'm saying, right? Wow. Incredible.
Aaron, you're welcome back, though, buddy. We got 10 spots.
Come on, Aaron. Let's go.
We are live, Simon.
Let's do this.
I'd rather
do it live.
I'd rather go out in the yard and go clean up dog doo than panel up with a witch and some sellouts and some meth heads and CP suspects and dude, seriously, man, wow.
Right, Simon? Because it's been so long since all of us have been on panel together, like all at the same time.
Yeah, and spreading their LARP out.
Let's do this. Panel up, bitch.
Aaron is known for ducking. He is kind of an official duck.
Wow. Official duck, right? Oh yeah, and I'm just gonna record this for later. No, I much rather come on and try to have a conversation, but obviously immediately it's just on loop, like, you know, like spazzed out, communified pieces of space trash on loop, dude. Seriously. And, yeah, I'd much rather just take care of it this way where no one's yelling over each other constantly. This is sick, man. These guys are joking. These guys are joking.
If he's not editing videos for JD.
Oh yeah, maybe that's why he had to go.
So, did y'all hear about Scotty? You know about John Davis?
Loosely, yes. I know a little bit about him. I've been, since, you know, all the, you left us for the pred catcher, and that's where all the drama is over there. I've been trying to get caught up a little bit.
Okay, so you,
I know a few of the outside characters, and I'm getting more confused than what I understand, but I do know that that guy allegedly killed a chomo, but then it came out that he killed the guy over his baby mama drug deal shit.
Yeah.
And
he met him at the car wash and sped his vehicle up, you know, onto the other guy's vehicle, like, you know, right up on it. So he was trying to escape out the passenger side, so he doesn't get killed because his truck coming at him. And John Davis decided that was a perfect time to say he was reaching for a gun and shoot it 8 times in the back.
Yep. We just got done listening to all the documents being read from the court.
Yeah. And that's what
Do
they
you
do.
know
They find some weirdo, right? And I'm not saying John's a weirdo, but they just find anybody that they can, and then all of a sudden, oh, I'm best friends with him. Oh, Cox is making videos for him. Oh, he's best friends with him, right? And this isn't the first time, you know. And if you actually do go through the court case record, a lot of these people's claims that they're trying to throw out there about John are not true. But they twist them around, and they're using their fantasy. They're trying to LARP it up, make themselves look better to get away from the CP suspects, right? Right. Wow, and the alcoholic, Nick Cuck here, he thinks he's pretty badass. Okay.
JT gonna go on with you? Did he want to do that?
He said not tonight.
Oh, he said not tonight. Okay. I
Oh.
was just curious because they were gonna kind of go over them all again at one time versus all the separate pieces.
JT.
Right.
Yeah,
I think-
JT, their arsonist buddy, right? That lit the Benet family house on fire, John Benet Ramsey's. That buddy of theirs, right? Once again, I'm not the one that's got all these charges. You guys do. Wow.
That would be great.
I might try to see if Bobby will do it. Nevermore would do it. Nevermore.
Oh.
The perfect redneck.
Oh, he'd be perfect. Yeah, that would be interesting to just listen to it all at once.
Yeah.
And everybody did a great job with all those documents. Like you guys literally got into your parts and everything.
Yeah, LARPing it up.
He wasn't even allowed to have a gun because his mom's gun.
Right. That he said was just in there.
Yeah, it just happened to me in the truck.
Mm-hmm.
Just in case.
Right. Hey, Athrenas.
Oh yeah, speaking of
Also,
it
don't let
in the
Simon-
same truck, you know, when PEdward was in the back of his back of a cruiser with his brother that he lives with, the main CP suspect in this case. Just amazing the way these guys are trying to skirt around all of this. The PEdward Defense Force. Man, that's not
On the
working.
panel will go to shit. Oh my God. Poor Simon.
Paul's a long-time friend of the channel.
That's cute.
That's pretty boring.
That's nice. Don't let Simon on the panel will go to shit. Simon.
Paul knows. No, there's a. It's Yaxley's father.
Oh man. Oh wow. Okay. That's great.
But you know, once you fuck with me, Yaxley.
What? What's Scotty really gonna do?
Oh yeah. There you go.
Aaron found out
Hey,
that already.
no. If Scotty could actually do something, he already would have. This is the best they got. PEdward, an Alki, a redheaded witch, Kim that's so burnt out from whatever drugs they've got her on, and an ex-crackhead right here, where Fellowmon says he's getting intimate with his younger, disabled students on the mat. Okay, all right.
But yes, if Aaron apologizes to Kim and stops doxing Kim, then I will take the wrench away from his address. I don't know if that's his address or not.
Okay, that's actually some terrorist shit, because they were actually putting all those doxes out first, and Kim put her name on the internet first. See, these are domestic terrorists, on the verge of domestic terrorists, right? You either shut up or they're going to say that you support murderers and rapists and sickos, right? When it's so interesting where Scotty worked with Mark Connors. See what I'm saying? He worked with Mark Connors, the unregistered sex offender, for some reason, but they don't really want to get in depth about that and the Brady violations. You know, I'm not sticking up for any sicko, but hey, when it comes to the facts, let's talk about the facts if you guys want to talk about the facts of the case. But they're dictating it the way, I mean, I guess their handlers need it, you know, need him to, right? Part of the PEdward Defense Force and the Muffin crew. Oh man, these guys are losers.
So he's upset about that.
Well, I guess you shouldn't have kept putting your phone number out on there, huh?
Yeah, he was calling me a bunch today. I just left. I was going
Wow,
down the
it's
alley.
interesting. He's trying to say I called him a bunch today when I didn't. It's Anton spoofing my number, ghosting my number, making it look like I'm calling Scotty when I was asleep earlier. I just woke up and saw it in the chat and grabbed a screenshot. Right? Man, see, they just keep on stacking it because they need people to shut up. It's contract work. Right? If you don't shut up, you get compounded lies made up about you. But when you swing back with maybe some LARPage, you know, making them look stupid, right? And using comedy, oh my gosh, oh, this guy's a liar. Oh, he's lying about us. You guys are the ones that fucking lied first. Scotty doxed my phone number first, so I doxed his. Oh, now Cox is calling me and hanging up and leaving messages. No, dude, you motherfuckers are doing that to me. I can prove mine, and I do. I disprove these pieces of shit over and over and over again, but they'll compound the bullshit just like it's a Denise Mad Cow stream. Seriously.
Yeah, some of my...
Oh yeah, and PEdward here. See Kim way against Denise Mad Cow. Way against Denise Mad Cow, right? They can't stand the Denise Mad Cow. But he can say hello to her on CP Sam's stream, right? CP Sam that'll plant some nefarious porn on you if you start trolling him. We got the clip on that, right? That's okay. He likes Denise Mad Cow, but these cows don't for some reason, right? And I guarantee he'd get on his freaking knees and get tonsil boxed by old Denise Mad Cow, just like freaking China would get on his knees for Denise Mad Cow. Same thing with Fellowmon. Seriously, man. Oh my gosh, this is
My
good
vicious
shit.
neighbors were walking down the alley, and they were anyway. One of the trucks was like broken down, so they were going to fix the truck, whatever, push it back.
These chick
And
trucks.
so I was, you guys okay? And
These
right,
chick
and then I was
trucks.
saying goodbye to them and just starting to drive off, fast. The phone rang, and it was fucking Aaron, and he was playing some like weird East Coast accent guy saying,
Oh God.
and I just let it play. I was like, whatever. And then he kept calling back, and I was like, I was listening to MMA talk radio stuff, so I just put that I put the two phones together. I was like, listen to it.
Oh my gosh.
Yeah,
Sure,
it's
They kept
about
hanging up.
time the trolls troll each other. Anton trolling Scotty is me. Seriously, I was asleep during that time, and see, it's Anton. He wants people to fight, so seriously, he ghosted my number because I saw the other day he ghosted somebody else's number, calling me somebody else, and yeah, it's. Ooh, big troll tactics. I got better shit to do than try to troll people at that level.
Because I don't think I was giving him this reaction that he wanted.
That's so immature. That's like not even middle school, younger than that.
But he's probably recording. And
They're the ones that side with Spamton, by the way.
Of course.
But I want to figure out how to record him back, so I need to work on that. But I was driving, so it was like bad timing. I need to get proactive with that voice recording thing.
Right.
Because last time he did it, he was like editing out my part and shit like that. So I can be like, this is what really happened.
Yeah, he has this thing for commenting on commentary over videos. So it gets a little confusing when there's like 7 of the same person talking. You're trying to figure out what's going on.
Yes.
I played into that. I have a stream of,
Yeah.
he's streaming my stream of him, streaming you, and then
Yes.
I've been there.
I've seen those too. You got to stream. You have to stream the stream of stream.
It's an inception moment. If you go
It's
3
the thing
levels,
to do.
you start losing people. They can't make their way back from the mark. I
Right.
think that's what happened to Aaron. He went too many levels and now he's stuck.
Now he's stuck, like in that brain zone.
Yes.
Maybe he put too many rocks in his ears. I'm thinking.
Colloidal silver. Maybe.
Yeah, whatever those rocks are. He talks about putting in his ears and.
It's so funny when losers try to keep track of your life, but they can't get it right.
Sungite or thermite, I don't know.
Whatever it is, I don't know.
Shungite.
I think he put too much in his ears and it got stuck up in his head somewhere.
Well, he did allegedly take this RF. He says he was disabled from the Coast Guard because of an RF attack.
Is that antenna stuff I've heard about?
Yes. So he claimed, I don't know how much truth, but so he says he can't have kids.
Okay.
But I think it also may have.
God.
That's what I was saying too. I was like, at least he can't procreate. So there's that.
And he's told people that?
Yeah. So at least he, virtue signaled and victimized himself.
Oh, okay.
And that's why he can't have a job and shit.
So the antenna attacked his balls?
Allegedly.
Okay. Wow. Oh, yeah. Woo.
I think it, if it affects his balls, it might as well affect his brain too. And,
It must have gone right from the balls to the brain.
So there may be some sort of.
And that's why he puts a bunch of words together and then goes live with it and talks about it for 24 hours.
And I don't like to do hearsay, but since he does that type of shit to me,
yeah.
I'm not going to be nice. James D said that he used his military connections. And again, consider the source. But James D said that he used some sort of connection to look into Aaron. And Aaron was booted for mental reasons. Out of the fucking Coast Guard. And again, that's just hearsay, but it makes
hearsay,
sense.
Yeah.
Yeah.
That's what Aaron does. He puts out hearsay 24 hours a day and makes stuff up.
But you've seen how he's kind of degenerated and where he's kind of at now, so.
He sure has degenerated.
Wow, that's good. Narc on each other to go ahead and look that type of stuff up on somebody's medical history and mental history on enlistment when it's there's ratings there for medical reasons. See what I'm saying? Wow, you get hit by RF from an antenna, there might be medical reasons there that also affect in mental reasons too. See what I'm saying? But they can't go that deep and want to spread that type of shit. And wow, man, wow. Incredible, right? Oh man, a veteran that's got some medical issues that may turn into might, and this is what happens in the VA, is they much rather try to label you mental than taking care of you from physical or medical reasons. That's been the goal at the VA for a long time. But these fucking losers, they haven't served their country, wouldn't know shit like that because they're that big of fucking losers. Anyway.
Been listening to him for months and months and months and months and months now.
Yeah, isn't it time for you to DDoS somebody, Angela?
Oh,
You've been up
well,
here
no
for a
one's
while.
called to cry to me yet, so.
Okay, nobody's crying to you about being DDoS yet?
Not yet.
DDoS.
No, I'm waiting for my bat phone to ring over there in that other community, and then I'll go fix it all. Yeah, don't worry. I've got my phone right here just in case.
Right, okay.
Yep. Thanks for keeping me on my toes, though. Yeah. My special bat phone I have. So if anybody needs anything fixed, I have a special bat phone, and you guys can cry to me, and then I just go fix it all with my bat phone. Okay? That's what's put out on the interwebs.
Oh yeah. By the way, when they take people in the military and they clear them, right? They clear them in the beginning and you get cleared to go into the military and you're given a clean bill of health. and you get put through the fucking meat grinder and you come out with medical and mental issues, whose fault is that? Right? Because before the military, man, I was winning awards and doing really well in skiing and hiking and fishing and doing all the cool shit on my way to a good career. And well, you know, all of a sudden I needed college money. Needed to go to the military to go get college money so I can keep becoming successful in my life, right? But that doesn't matter. These people, when you get put through the meat grinder after you get a clean bill of health, and you even get mentally evaluated to go to some positions in the military, and to be able to go there, oh, you get a clean mental bill of health too, right? All right, you fucking losers.
You guys know I have those abilities from what I'm told.
Yeah,
I
I was hoping he would come back.
Everybody's
We got the crew all back together. You know, he got the audience he wanted.
I know. I
Where
want
are
to hear.
you, Aaron?
I want to hear what he has to say.
You know what's funny is this piece of shit right here, CP suspect that changed to my picture right there, because he's so jealous because I have teeth and he doesn't. But that guy blocked me from his channel and panel and chat real quick, right? And doesn't dare come to my panel at all, right? He's not going to click on my link, right? But we need to go to their little dumbed down little corner of YouTube. These pieces of shit. Look at that. Changing over my picture. Oh yeah. Oh yeah. Docs the city there, PEdward. These fuckers are pathetic, dude, and desperate. Wow.
Pay attention now. He's
Right now.
live crying that we owned him.
Oh no, the definition of being owned is when you talk so much that nobody else can get a word in edgewise. I figured that out. I figured that out over the last.
Yeah, just like when I first got onto his panel, right? I was ready for a conversation, had some bullet points to go to. Then he lets on Kim and they both back and forth real quick. Can't even, whoa, I'm not going to be able to talk here. Okay, let's start trolling then. Let's go to troll mode. Right? Wow, incredible. We'll go back to that. We'll go back to that beginning. But here, let's do it now. Yeah, let's do that now. Oh, this is a blast. This is so much fun.
If you play a stream detective, I'm going to put you backstage. If you play a stream, I'll put you backstage.
You're such a weak bitch. You think like you're gonna get porn bombed or something. Oh, you do it.
No, I said if you play a stream.
Dude, shut up. Shut up for a second. I got a whole list.
No, I want you to play any of your streams unless you play the zombies.
No, I got a whole list of comebacks for you. Just written down, dude. I don't need to explain anything. Oh, you don't care. Oh, you don't care that I can swing back at a lot of your bullshit right on your own
I
stream.
told you, I'm gonna go probably.
You don't want that. You don't want the smoke, but this is a smoke spot, right? And you're pretty much sizzled right now. You're all smoked up.
No, I'll smoke one right now for you, bro.
Yeah,
Or you being a faggot and you
don't
lie.
even-
You
This
say
is
that
you.
you want the Eagles to fall off the net.
Go on your loop, little bitch. Go on your loop. Go on your loop, ladies.
You're so out of control.
Go knit a poncho for everybody. You're not gonna do. I got a whole list here of comebacks I can tear you guys up with, but you better do this. Dude, I don't want to hear from you, ladies. Call the cops on people. Kim, start calling the cops on people.
So that's Kim that has to say that if she doesn't like you, she's gonna overtalk you. See how that works. Let's do a part 2.
I
I was hoping he would come back.
Everybody's
We got the crew all back together. You know, he's got the audience he wanted.
I know. I
Where
want
are
to
you,
hear.
Aaron?
I want to hear what he has to say. He's got all the attention now. He's
Right now.
live crying that we owned him.
Oh no, the definition of being owned is when you talk so much that nobody else can get a word in edgewise. I figured that out. Over the last week or so.
Okay, I was wondering about that getting
Yeah.
owned stuff that they keep
Yeah,
talking about.
that's when you run your mouth so much that
Uh-huh.
nobody else on the panel can get a word in edgewise. That's owning.
Oh, okay. Okay. So, yeah, I've been really trying to figure that one out, Nick.
Yeah.
So
In my
what
opinion.
What were we watching before? Were you watching Ryan and did that?
Well, it's a recording of Aaron reporting Ryan.
Yeah.
Right, Scotty?
Yeah, it looks like he's watching. I can turn this. Let me play with my go, but and then you can see he's recording a video. I think of his computer.
There's his little screen recording to the right hand side. That's how you know Aaron is.
So yeah, so he's recording the computer of watching Ryan, and then he jumped around and does a bunch of dumb stuff on here. So
he was only live for like 24 hours straight the other day, right? Like a week ago.
Well, yeah, he was jumping on everyone's panels and then restreaming on his own show.
Oh.
That's what he was doing, and then started restreaming streams. It's all quite interesting.
now he accuses me of streaming for long periods of time, but I obviously don't sit there the whole time. And
No,
I argue that
exactly.
he does more streaming than I do, as far as like.
Well, yeah, you have your stream going. People can come in the chat. and
He's just pissed that I can run an elaborated automated stream and not have to sit there. See, these guys think I'm just sitting there, right? When all he can do is put on some bears beating each other up in the background with the Proud Boys beating each other up with Antifa with Kim, right? Definition of a Proud Boy, once again, these guys, perfect example, talking to the Proud Boys in the past, right? The rancher definition of the Proud Boy, the castrated bull that doesn't realize he's castrated but still running around like he's top dog. Okay.
Please, and watch the bears.
Right, watch the bears.
Oh, tell PEdward what Aaron said today about how we're all just here to wait for the bears to fight and all that.
Oh yeah, we're doing magic. We're doing evil spells to make we want the bears to fight.
Can you believe that?
And we were just hoping that they fight, and we want the baby eagles to fall off the nest.
Yeah, they actually did.
The mother went missing, and it's our fault.
Yep.
We did some Harry Potter shit.
Can you believe that?
Well,
Yeah, because a mom did go missing last.
yeah. See how they downplay it? No, the mama bird died, got killed after these witches were spell casting that they wanted baby birds to fall out of the nest. Seriously, it's some sick shit what these people are doing. It's no bullshit.
Time they were showing the eagles, and a dad literally had to take care of these babies because the mom was missing. It was actually very sad. And everybody
We're
was
blaming Kim. It's Kim's fault, basically.
Oh no, don't say that to Kim.
I was kidding.
Better not.
Well, maybe I'm the asshole here, but I wouldn't.
It's always my fault, Scott.
I know, right?
See, she's getting better at taking it.
I'm nothing else. It's Kim's fault. Kim did it.
I won't say the date, but it is Kim's birthday week. So I think everybody should wish Kim a happy birthday.
Happy birthday! No, I was just texting Kim like, oh my god.
Oh.
Yep.
Wait a minute. It's
He's got the high pitched Valley Boy voice down. Valley Boy.
Time.
Yeah, so we have to, are we gonna do the honorable? Nick's gonna get fall down.
Oh my God! No.
We're gonna talk about Bigfoot.
I think that was Kim's last birthday.
Yeah, it was.
We usually do streams on that day.
Yes, that's right.
I answered you, Scott.
I could go get a bottle of whiskey.
Yeah, I think they got drunk.
No,
right?
no, not tonight.
And you had
That's
a beer, I think.
So,
Probably.
Maybe impending stream shit show pending.
Maybe.
Yes.
And remember, if whatever happens after midnight and if we're drunk, doesn't count. And
Right.
you can't be held
It doesn't
responsible.
count. It doesn't count.
Good, 'cause I don't remember.
No.
I remember it was.
Oh, Soror's Christian LARP expired. You know, Mike has explained it fucking a million times since I've met him on YouTube. And if you weren't around for that, then too bad for you. How's that for an answer? Nebula G? What the fuck is Nebula? That's funny.
Isn't it like a space term?
Nebula? So I'm from space? People say
Final
the
frontier.
weirdest shit. I'm Spamjula G. I'm Nebula G. Nebula G. Pastor Gitter knows into all kinds of others' business.
Oh no.
Uh-oh. Oh no. Like, what kind of business? Right? What kind of business?
Ugh.
I want to know.
Man, all I can say is I couldn't imagine being tied to an Amazon redhead like Spamjula G, right? Trying to peddle her high school picture like it's current, like dude, she does not look like that today. Like the Leatherface action that she got looks like a freaking cheese grater on her face. Just saying, she needs almost like a Bondo job. Nate, we need, do you know somebody that's good in auto body? We need freaking Spamjula G's face freaking Bondoed up real quick.
Kind of business. Yeah. Rut-row.
Funny, all they can do is come in here with socks. They don't have balls enough to speak for themselves and use their name.
Nope.
Nah. Never.
It's funny because it's their own crew trolling them, by the way.
Yeah, whatever. Yeah, it's obvious you're not like Soror.
No, exactly. I was a Christian for 1 week. It didn't last. Well, you know what? We don't owe you any explanation about anything, so how's that?
Right?
Yes, Kim.
Scotty's Christian LARP had a good run. What do you think about that?
Oh yeah.
COVID killed my killed my faith. I need to get back my faith. I've backslidden.
Well, maybe the Soror's Christian LARP expired can help.
I'm gonna give him a wrench. Maybe that will.
Oh,
if I give him
that
a
might
wrench,
help. That might help.
I'll get
Oh
back.
yes, give them a wrench.
Yeah. Oh yeah.
I think Michael will like to fight with him. So
We party down.
That white.
See?
TRD. Stop.
This is equal opportunity. Equal opportunity over here.
Losers.
Yep. Nebula. It just reminds me of a nebulizer. Nebula. Or is that a Greek goddess they're calling me? Yes, that's what it is. Oh, well.
I just want to note, though, Aaron, we played your stream that you said I wouldn't play the other day, but I kept putting him backstage because he was playing antics and playing like music and shit and streams when he comes on.
Oh.
Like I warned him, I said, Aaron, it's Friday night. I have to work in the morning. I'm not gonna do a shit show right now. If you want to talk, we can talk, but I'm not gonna yell and play these fucktard games with you. And also we want to see the zombies. When Zombie said I was a suicide troll, and Aaron made a video about it. And Aaron's hoarding the evidence. He won't give it. He won't release the evidence. and I said that I would play his clip if he played my clip that I wanted, but he wouldn't do it. That's what I mean. You can't negotiate with him. He's not reasonable. I try to be nice to him.
Wait a minute.
Bad. I can't.
Wait a minute. What happened to Fellowmon giving no credit, no quarter once he's got evidence on you, but he's got evidence on Scotty being intimate with his students? That's the clip he will not answer for. Yeah, see, I don't make deals with fucking weirdos like this. I'll just keep putting them on blast.
The family members, you guys. I mean, the sister. I don't know if she's complicit in his behavior. You know, if you can hold her accountable. There's some sort of accountability, though. He lives. Someone needs to take that bull by the horns, and I don't know what they say after that. But.
I don't either. It's just about that, though. Yeah.
And just know, because Aaron has taken him kind of into a weird place, and I think any doctor that analyzed their relationship would not approve of Aaron's influence on CNN with the type of videos he engages in and the talk and stuff like that, the subject matter. Like Aaron's at least smart enough to say, like, in my opinion and stuff like that. Like CNN just says crazy stuff. And, he's clearly not all there, you know.
Yeah, something's. I don't know, but yeah, he's riding on Aaron's coattails.
Yeah, and he has been. Like, that's for years. He's been interjecting himself into anything that Aaron says. He goes.
Interesting how that works.
And I've been kind of watching him since 2019.
Yeah. So. Interesting. I just didn't.
But did you hear this week? Now he's like, "I'll knock you out, Scotty."
It's gonna knock you out now.
Yeah.
Shit. Whoa. Gone to a different level now.
Yeah, he's gonna ride the bus down.
Ooh.
The short bus?
Well, no, probably the city bus or the Greyhound, you know, something like that. He'll make videos documenting. So.
Oh, I'm sure he will. We'll know. We'll all know.
His journalism.
Oh yeah.
Have you seen the journalism part?
No. He doesn't say he's a journalist, I know.
No, people. It's pretty funny. People are like, "Why are you recording me?" And he's like, "Journalism." He's like, he goes, "I'm a journalism."
I'm a journalism?
And they're like, "Who do you work for?" And he's like, "Myself."
No way.
My story. It's pretty bad.
I'm a journalism.
My story.
I like her.
I'm gonna tell you about Mark Connors, this guy, and then I'm gonna tell you about this Spambula G, and then I'm gonna tell you about Ken, and then I'm gonna,
Never heard of before, and I'm gonna mix them together.
Mix it all. That's right, Nick. 100%.
No, and he says horrible things about FM. And I think that, like, he's been slowly kind of keeping the kids close, but I think he fell off. Now he might be off to the races about me next. So
he's been on everybody, so you know. Guess it's your turn, Scotty.
Yeah.
Tom, can I get a wrench?
I'm the real peepin' Tom, bitch. Spampton is gonna
That is true. Hold on. Did the CNN doxing people again? Probably.
I don't know about that.
See, this is why you probably shouldn't dox people with CNN. Then they want to dox you back. Is that Mr. Jones?
I could have missed. Let me see.
Mr. Jones! I think it's Mr. Jones. The LARPed out? Is that
Yeah.
password?
Let me look. Because you know of a backbone, which means of special.
Yeah. Oh, by the way, you asked somebody to eat all.
Oh, I better.
Angela and I work for Google. We're Vegas shills. Set here, making millions.
I am subbed. So,
Yeah.
it's possible.
I do believe it.
Might be. Yep, he's got the punching thing. He's got the little black heart.
With this phone.
Yep.
Angela, get out your back. Time to eat all.
Okay, I'm gonna get ready. So if your stream starts flickering, that means I'm doing it. Oh, don't do it to Scotty's? Oh.
Yeah, not to Scotty.
Oh.
It'd be funny if you did.
Okay, okay.
No, there's somebody else you gotta go eat all.
Oh shit, let me go look.
that's allowed under the Constitution, because the Constitution only says that the Senate will decide.
Because it kind of feels like you were
And we'll see very early on how close they are to 2/3.
It'll be very interesting. It'll be interesting to see. I'm guessing it'll be our same 6 that voted wanting to kick out all the charges. I bet they're among the ones that will be against this. And I don't know.
It could
we'll
be
see.
16. It could be 16-14. It could fail on a 15-15 vote, but or we could have more than that. So.
Well, and you can also have a situation where people don't want to telegraph.
Right.
Where they're going to vote.
And they would refuse to vote for this because they don't want to show, and so they would say, well, I don't mind having 2 votes. Let's move along with the trial. If you're the defense, I wonder how you feel about this. If you're the defense, you probably would like to leave the 2 options in place where they could let the voters decide to bring them back if they chose. But if you're the prosecutors, you want him barred forever.
Yeah. Well, so we're still, the big question is, and it looks like we're going to get to her, Laura Olson. We're going to get into, and I'm basing that on this clock situation that feels like we're going to have enough time. It's going to be tight, though.
It's going to be tight, right.
Testimony's going to be short.
And they're going to have to really, the prosecution's going to have to be very expeditious with her, right?
Right. Very much so. In order to, but that goes to what we were talking about earlier. To have such a critical witness, it's a shame that it's going to have to happen in such a truncated period of time.
You wish, if I could wave my magic wand, that Dan Patrick would give some additional time, because this is so critical. This is really an important trial, and this is a key witness, not because she's the mistress or was the mistress. It's because she can speak to a couple of things: how she got the job with Nate Paul, like how this comes to be, how does this happen, and also, the allegations, specifically so much, a lot of what Missy Carey was testifying to, that's Paxton's former chief of staff, this issue of how, the security details and the hiding of the affair.
Stuff in the newspaper, but you know that there's been an allegation that General Paxton had a secret email address?
I believe you mentioned that to me on the call the other day, yes.
And you and I know that the reason he had that Proton address, that email address, was because he was traveling to China.
That is correct.
And the reason and that was something set up for him by the IT department at the Office of Attorney General.
That is correct.
And that email address was to prevent the Chinese from hacking into his into his email, right?
Correct.
Okay. And other people in the office had that same type of email address, didn't they?
I don't know how many others, but yes.
Okay. You remember the suggestion of burner phones?
Miss Epley mentioned it earlier, but yes.
Yeah, it was, and I know you probably haven't been reading the newspaper, but let's just go ahead and get this out of the way. If a burner phone is a phone, a plastic phone that you can buy at a convenience store with a certain amount of minutes, and when it's over, you break it and throw it in the trash. General Paxton never had anything like that, did he?
Not to my knowledge, no.
He never had any burner phone, did he?
Not under that definition, no, sir.
Okay. you told the House you could not speculate as to what relationship Nate Paul had with General Paxton. Isn't that right?
I stated that I believe that they were friends, yes. But I wouldn't speculate beyond that.
Yeah, that's all you know, right?
Yes.
One thing you do know, that you never were in the presence of General Paxton when he and Nate Paul made any kind of agreement. Isn't that right?
That is correct.
I mean, let's be clear. They've been throwing around this word conspiracy for literally a week and almost a half, and you were the man who was with General Paxton more than anyone else, and you can say definitively, you never saw Nate Paul and General Paxton reach any sort of agreement whatsoever. Isn't that right?
No, sir.
Is that right?
For the conversations I was privy to, that is an accurate statement. Yes, sir.
Okay. You don't have any actual knowledge that Nate Paul ever did anything for General Paxton other than buy a lunch. Isn't that right?
That is correct.
Let's be clear. The man that was with General Paxton more than anyone else is testifying under oath that you have no evidence, no knowledge that Nate Paul ever did anything for General Paxton other than buy a lunch. Isn't that true?
That is correct.
Now, you have seen some speculation in the newspaper and the press, haven't you?
Prior to this trial, yes.
Yeah. And I want to, and I'm not picking on you, Drew, because I think you can tell that I'm fond of you and I like you. But I want you to know that this whole idea of the house renovations, everybody says it came from you. Do you know anything about who paid for General Paxton's home renovations?
Not directly, no.
All you have is one stray comment, right?
Across multiple instances, yes.
And you were concerned about it and you went and raised it with your boss, right?
That is correct.
And he was very clear with you. That is not what's going on here. Isn't that right?
That is what he stated to me, yes.
Okay. When you interviewed with the house managers, did they ever bother to show you the receipts, bills, payments related to General Paxton's house renovations?
No, sir.
They are in evidence. Did you ever go with General Paxton and Senator Paxton when they went to Home Depot?
No, sir.
When they went to Lowe's?
No, sir.
When they went to a different Lowe's?
No, sir.
Were you ever with them when they were pricing sinks and countertops?
No, sir.
You did say in your testimony to the House that General Paxton's, I don't want to use the wrong word, but he's close with his money.
Yes.
I don't want to call him cheap because he's my client, but he pays attention to what he spends.
The word I would use is frugal.
Frugal, good word, okay. You believed, based on what some people have told you or maybe what you read, that General Paxton got granite countertops?
That was what I read in one news article, yes.
Okay, let's let that sink in. And when you read that, and when you connected it to the statement you say you heard, you thought, well, there it is. General Paxton got granite countertops paid for by Nate Paul, right?
No, sir.
You still didn't believe that, did you?
No, sir. In terms of the timing, I had already made my statements to the House committee, and the article that I read and am referencing now, I believe, came out after that.
Okay, and I'm not talking about that. I just want to make sure that at some point in time, you believed that General Paxton had gotten granite countertops, right?
I'd heard that. I don't think I believed that. No, sir.
Do you believe it now?
No, sir.
Let's pull up, Eric, if you will, Attorney General Exhibit 371. You told us you had been in the kitchen of the Paxton's home in Austin.
I was.
And that's in Terrytown here in Austin?
That is my understanding what the neighborhood's called, yes.
Okay. Can we pull that up, Eric, please?
Objection, Your Honor. Is this already in evidence and he hasn't established the relevant time period, whether it was before or after?
I've already said this is in evidence, Your Honor. It's AG 371. Overruled. Now, This picture, sir, was taken a few days before this trial started. Do you see the countertops?
Objection assumes facts not in evidence.
It's already been proved up, Your Honor. We'll do it again.
It has not been proven up. It is a photograph, and it depicts exactly what it purports to until or unless he lays a predicate for someone who can say when it was taken.
If I could keep going, Your Honor, we'll do all that. Sir, do you see the kitchen, the Paxton kitchen there?
I do.
Do you see the countertops?
I do.
Are those the same countertops that you saw when you were in the Paxton kitchen?
Prior to the renovation, yes.
Okay. Do you realize that that's the same countertops as they exist today?
Objection, facts not in evidence. He doesn't have a predicate for that, and he's testifying to the Senate.
Your Honor, this has already come into evidence of the current picture of General Paxton's kitchen. It's already in evidence.
Mischaracterization of the evidence, Your Honor. The photograph is in evidence, but what it depicts has not been established, and Tony Busby does not get to, no matter how hard he tries, establish the time frame in which it was taken.
Again, sustained. Is this how the kitchen looked when you were in it?
Prior to the renovations, yes.
Okay. Do you see the countertops?
I do.
Do you see the stove?
I do.
Do you see the cabinetry?
I do.
Okay. Do you know how often the Paxtons went and priced new stoves, new countertops, painting the cabinetry? Do you know?
Objection assumes facts not in evidence. We don't know that they did that at all.
I'm asking him, Your Honor. How can I establish if I don't ask him that?
Overruled.
Do you know how many times they did that?
I do not.
Wouldn't it be unfair to the Paxtons to suggest that this picture here
Objection to relevance is the way it's phrased, Your Honor.
Let
It's
him finish his
inappropriate.
question.
Do you know whether the countertops that we see in this picture, do you know whether they've ever changed?
I do not know if they've changed now.
Okay. In evidence is exhibit 346 to 353. You mentioned Steam Clean as one of the contractors, right?
Yes, sir.
And you had to deal with them?
I believe I was copied on email correspondence.
Okay. And did you know that there was more work that the Paxtons wanted beyond what Steam Clean was going to do?
I wasn't that involved in the detail of the STEAM team.
Okay. Did you talk to us about how you had some involvement with an insurance adjuster?
The involvement being that I showed him the home? Yes.
And the insurance company was USAA?
I believe that's correct.
Let's look at what's in evidence of AG Exhibit 410, second page. Just catch the first page first, Eric. Can you confirm with me, Mr. Wicker, Drew, that the date of this correspondence from USAA is September 16th, 2020?
I can.
And let's turn the second page. Do you see that the policyholder is Warren Paxton, your former boss?
Yes.
Okay. And you see there's a claim number there?
I do.
And do you see this explanation for the benefits and the payments and the additional payments that are laid out there?
That's what it appears to be, yes.
And how often did you hear General Paxton complain about how slow the insurance company was on his claim?
Objection, Your Honor. What's good for the goose is good for the gander. That's hearsay.
Exactly. We've been hearing from General Paxton all trial.
He's our party opponent, Your Honor, not his own. He cannot proffer statements for KenPaxton on his behalf from the stand. We get to use them against him. He doesn't get to offer them for you.
Sustained.
Do you see here it says $32,000 total cash out to you for all other covered repairs? Do you see that?
I do.
Did you ever have any involvement in trying to convince the mortgage company to release that check to the Paxtons?
I don't recall that now.
Okay. Did you understand that there were more repairs being made that KenPaxton was claiming were covered from a different contractor?
Objection assumes facts not in evidence and counselors testifying.
Did you know? Sustained. Did you know that there was a different contractor doing some of the work in the Paxton's home?
Objection, Mr. Busby. That's twice the judge has sustained the objection to facts not in evidence.
He just testified to it in direct that he dealt with Kevin Wood. That's in evidence.
That's because it was a direct relationship based on his rational perception of the facts.
Did you deal with Mr. Wood? Did you see Mr. Wood at the home?
I did deal with Mr. Wood, yes.
Did you know that he was doing repairs and renovations to the home?
Yes.
Did you know that he was in fact the second contractor that's being referred to in the USAA docs?
No, I've never seen these documents.
Objection, assumes facts not in evidence. He's introduced a second contractor when all we know is the first and Cupertino.
I'm trying to figure out how it would be that Nate Paul's paying for repairs when in fact USAA is paying for some of them. You have any idea about that?
General Paxton expressed to me that he was paying things out of his own pocket as well as insurance.
Exactly. You knew that, for instance, the sink that they put into the home, you know that sink was replaced, right?
Objection, assumes facts not in evidence.
I'm asking him, Your Honor, how can we put it in evidence if I don't ask the witness? Overruled. Silly objections. You know that they were trying to replace their sink, right?
No, sir, I do not know that.
Do you know what the sink looks like now?
No, sir.
Do you know who paid for the sink?
No, sir.
Your Honor, we're going to offer AG Exhibit 433, which is all the pictures.
Objection, Your Honor.
That Angela, let me offer the exhibit first. All of the pictures that Angela Paxton had from her phone, all of these, where they were at Lowe's and Home Depot, pricing repairs to their home that they paid for out of their own pocket.
Objection, Your Honor. Assumes facts not in evidence.
Excuse me, Counselor. Let him finish. Okay. You have plenty of time to object.
With an affidavit from Senator Paxton herself, establishing that these are records that they keep, that they kept, and she confirms that they are what she say they are, and they're non-hearsay. They're mostly just pictures.
Your Honor, Mr. President, if I may respond.
Exhibit 433, all the pictures from Angela Paxton's phone.
I'm not calling Senator Paxton's credibility on this issue.
Excuse me 1 second. Let me ask you, do you object?
I do.
What basis?
I am not calling the affidavit itself into question. What I am saying is there is inadequate information in that packet to establish it as relevant. For example, there are about 300 pages of what looks like scrolling online shopping or photographs from catalogs from Home Depot and Lowe's. They have no point of relevance. You don't know when the pictures were taken or by whom. So while she can establish they are her records, we do not know what they imply. There's nothing to show us what they fairly and accurately depict or when it was taken.
That's what the affidavit does.
Mr. Busby.
The affidavit specifically does what she claims it doesn't do.
She does not claim the time frame or when the pictures were taken.
Right here, Your Honor.
Can I see the affidavit?
You may.
Further, Mr. President, I would point out that their business record affidavit has not been on file for 14 days, and no metadata is included, which would have been easily provided if they'd done a Celebrite dump of the cell phone. One other point of order, Mr. President. The defense has not followed the rules established by this body in order to have a senator testify, which is de facto what is happening by affidavit. I want to encourage everyone to realize I'm not questioning that she signed what she believes to be a valid affidavit. It's that it is not in compliance with the rules, and it does not tell us what it purports to depict.
Your Honor, our mission here, this is Article 10, our mission here is to find the truth. And they have alleged that KenPaxton and Angela Paxton, a member of this body, were bribed, that someone else paid for their house repairs. The documents you have in your hand directly contradict that and in fact prove the opposite. Those are proved up by affidavit. The pictures fairly and accurately represent pictures they were taking when they were pricing at Lowe's and Home Depot. They also have pictures of the house itself as it was undergoing renovations, and I'll compare those pictures with the pictures of the home now to demonstrate that all the things Angela Paxton wanted, like a new sink, she got.
Objection, Your Honor. Counsel continues to testify on behalf of his client. It is inappropriate. I ask that we approach and that the testimony be stricken and the senator's asked to disregard. I am not attacking a senator here, but he has to follow the rules of evidence because this is a court and we follow the rules.
Come on up. Come on up.
Go ahead and take our bites. Victor, so talk to us. I mean, this, what should they do here?
Well, what's interesting here is what's good for the goose is good for the gander. Mr. Busby did plenty of objecting, and he's getting a fair share of that back in return. It appears that the foundation for the admission of this exhibit is not squared away, and that's what the discussion's about right now.
I mean, if you want to say the rules got to apply to prosecution.
He promised in his opening statement to show all these pictures of them shopping at, Lowe's and Home Depot and whatever. But I mean, the pictures, if they're Angela Paxton's pictures, they had to be arranged for them to be introduced to them.
It's sort of like what we talked about earlier today with the misstep by the House. It's critical. You got to make sure you dot your I's and cross your T's so that it comes into evidence and/or that you can proffer what you want to proffer when you want to proffer it.
Yeah.
And are these just photos that could have been taken at any time? How do we prove that these relate to?
Well, and they're talking about metadata. I mean, I feel like I've heard more about metadata in this trial than I've ever had in my entire life.
But metadata is pretty easy on phones. I mean, you can see, anybody can open up and see when a photo was taken and where it's geolocated. I mean, it's not that tough.
And metadata is so important to any case, particularly one that's document intensive, whether it's electronic documents or even a document that appears to be a printed page. If I can have your page here.
Sure.
I've had cases where you tell the jury that there is an immense amount of data that exists under that document that establishes a number of critical facts, and this is what the House managers are talking about right now. How do we know what this is and when it was taken, et cetera?
Right. We have to believe, and I'm kind of come from the school of trust but verify, right?
Right.
And so.
Otherwise, it's just a document, it's just a piece of paper, but without the characteristics or the qualities about the document, we don't know many things that are critical to what's going on here in these proceedings.
There's a vociferous case being made up there by someone. I can't see that.
Epley's talking. Erin Epley's talking.
Okay.
Yeah. Erin Epley, I looked up her LinkedIn page. She is a former federal prosecutor. She's an adjunct law professor at University of Houston Law School. By the way, I'm a graduate of the University of Houston. Go Cougs. So she seems to have a pretty solid. I mean, she's done a great job. I've been really impressed with her.
She's a worthy opponent of Busby for sure. She's given it back to him what he's been given to her.
Maybe we got a new superstar attorney here, and it's a woman.
It looks that way.
Remember what Busby is trying to get at here is kind of is not a proven premise. Anyway, it's like the House would like you to believe that there was some payment for the kitchen countertops or for the remodeling. But all the witness can really testify is that there were emails and discussions about who was paid for it. He can't prove who actually paid for it.
Right.
That's exactly what the defense is trying to say, is that you don't know who paid for that. You don't know, do you? So.
Well, I mean, he started off his cross-examination was very effective use of the other side's witness to establish the lack of evidence for the impeachment allegations. And it was moving pretty swiftly, and he was doing a good job in that respect. And we've got Meyer down here, and if you're a trial lawyer, you want to make an impact and finished. And he was making an impact, and now we're sitting here losing the effectiveness of that impact because of the quagmire that we're in.
Well, and he promised in his opening statement, he said we were going to see hundreds of pictures.
Well, and hey, again, guys, TikTok, this gets us closer to Laura Olson. Every single bench conference we're having here is, the way I understand it, is not.
Out of this, and he actually owned a car. He's one of those guys that drives the cop car.
Yes. The ones they
That
get
guy.
rid of. Yeah. Yep.
I know law enforcement.
Yep.
It's kind of like Aaron, which pretends he's a doctor slash fucking detective slash
Yep.
lawyer, which
Right.
is none of those things.
No, he's not.
Not a single one of those. No,
Nope.
not at all.
It's interesting.
Yeah. It is.
Now, Mr. Jones 3 is here. Wait, so is Lark Mr.
Oh,
Jones
boy.
3?
Okay, let me click with my powers. I'm subscribed to him too. It is the same one, yes.
Same
Yep.
person.
Yep.
Oh, you got the I forgot you got the Silicon Valley film.
Hey, I thought if you changed your name, you couldn't change it again for like 9 days or something like that. That's what Merrick said.
Losers sure are plugged in.
Well, I think there is a limit on how much you can change it.
Yeah, because you used to be able to change it all the time. Yep. Yes, Mr. Jones, I'm subbed. Yep, I already checked it out. I know. See, Mr. Jones, no, I already have all the details. He knows. He knows what's up.
I heard you were working on your spreadsheets the other day.
I was. I was. I got so many sets of them done you wouldn't even believe.
Now I assume that was for your business, but now it's I forgot the YouTube shilling.
Boring.
Yep.
I got 6 bullet points right here. Yeah.
And then Edward came right up and got on here, and Aaron never came back.
I can't believe I thought he would at least try to fight with Edward.
No, he won't. See, that's the thing. Nope. He will not get on a panel with Edward and fight him.
Well, because when you do, you get blocked from just by showing up. It's an insta-ban with Edward. That's what happened. Went at him. He insta-banned me, saying, "You're not gonna come over here and fuck my shit up." Right? Well, you did.
He does.
He does it through other people. He won't go directly at Edward.
No, it's because I'm banned on his channel, and I wouldn't want to go on his panel anyways because he's a slimy little black-toothed bitch. He's slimy. He's a meth head. You guys hang out with meth heads and crackheads. I don't. Wow.
He never has.
Never
He will
ever.
not panel up with Edward.
Yeah,
Because he knows
she's a lying, redheaded witch bitch that is losing really bad. And this is what it looks like to be a fucking loser right here in a whole group of them surrounded by CP suspects.
get owned. Even more so than he's already gotten owned today.
Right. Right? Yeah. A woman abuser and a young child, a mental abuser is going to own me by over-talking me. Okay. Oh, my God. Yeah, these guys are such fucking lose-bags.
It's like really, like his getting owned stuff.
Uh-huh.
Yeah.
Wow.
Well, I just got him to admit that he can't provide the evidence.
No, he I'm not. It's still over your head, Scotty. Even if I tried to explain it to you, you wouldn't get it. You would overtalk me anyways because you guys are fucking already owned. Already trashed. Already fucking stupid. Already fucking idiots. How further do we have to go?
Exists.
Lesbian.
Out there. So I'm like, where's the Brady violation on Mouse's case? And he can't show them.
Oh my God. Oh, I can.
Well, we just, there was people that showed the proof of JD's conviction stuff and all the court record. And he's helping that dude and hanging out with that dude and being a protector.
Wow.
He's protecting.
Right. So, Angela, Nick, and Ed helped protect the girl that lied about Tommy, CPP Tommy, that she was raped by him.
they helped protect that woman too. Then it came out later that that girl that lied about Tommy raping her, she lied about it on purpose, right? That's Ed's friends, right? Isn't that amazing? Wow, it's okay for these guys, and that girl that actually, said that she was raped, yeah, on the verge of major depression and suicide. That's these guys' friend. Wow, huh?
For that guy, one night some people wanted to fight with him, and Aaron would keep him backstage or kick him. And then when JD left, then he brought him back up on stage, which is like a total yak to the bitch move.
Oh man! Oh, letting a guy tell his own story for 5 minutes uninterrupted. Oh man, right? And even if he was incriminating himself, oh man, you can't let him do that, Scotty. You can't let people incriminating themselves by just letting them talk, right? You got to overtalk them. That's this whole crew. You stupid fuck.
Gatekeeping.
Right.
That's you, faggot.
No. I don't
Who's
need to
Spud? Where's Spud? Who's Spuds?
Spud is an Australian guy. That he's a cool guy. He's a fun guy.
Okay.
But Patrick goes over there, so I think and Simon too. So they kind of and Aaron I think too. So they kind of go through by association. I don't think.
Wow.
He's like a hippie guy from Queensland, which is kind of like Australia.
This is
just like stream.
This is
like
exactly why I don't like to hang around crackheads. The guilt by association, right? Oh man, I go to Spud's chat room every once in a while and listen to his streams. Oh, we're all guilty for some reason. We don't know what it is, but we're all guilty of something. Wow, crackhead logic, huh, Scatty? Scatty.
They sing and party and shit.
So he's a regular person on YouTube.
Yeah.
Okay.
But Patrick goes over there, so fucking. He's on they make fun of Patrick.
Okay.
Hold on, let me read the chat.
That's funny.
Oh yeah.
It's funny if you're a CP suspect in meth head, huh, Angela? It's funny then. Yeah, it is.
Okay.
Oh yeah.
Spud, and then Simon goes over there. So Simon fits in. A bunch of
Got it. Okay.
unruly
I guess I've not.
Australians.
Not been on that. Not been on that one.
Oh, she hasn't.
Well,
wow.
Patrick. Yeah.
Woo, man, one little tiny corner of YouTube that Angela hasn't been spying on. Okay, wow.
Yeah, he's the one that thinks. The other day, he was the one that was going around saying that they were owning a bunch of people. I think.
Right.
Yeah.
This is what he does a lot.
Well,
that's not like something.
Wow. So, they just the hypocrisy with these guys, right? Owning is when you can talk over on other people, right? So in the drama LARP troll community, that's all they do is talk over each other, and that's owned. Wow, right? So if that you want to be a part of that, they must be, hey, by these guys' logic, they must be part of the drama troll LARP community because they can talk over other people. You know what I'm saying? Incredible, these guys. Wow.
Right. Okay. Got it.
But no, we're hoping that he comes back around. I think he just went to. He used to not like Aaron. I found him fighting with Aaron. That's how he came across because he's from he used to fight with Tony.
Okay.
And
Yeah.
now he's fighting with Aaron. So that's when I came across his YouTube presence. And,
had to try to make friends with him because of Fellowmon.
He's kind of been like persona non grata around here.
Okay.
So, but he comes in. I give wrenches and they
see Tetro is kind of like me. He, once he figures out that there's crackheads and CP suspects, white knighting for each other, and they're a bunch of fucking losers, and all you can do is talk over each other anyway, and you're a bunch of fucking trolls, he doesn't go back. See, I'll go back for a little bit more, capture some aftermath after the big train wreck, and them, trying to clean up for the CP suspects. See what I'm saying?
But allegedly he's done. Quitting.
Oh. Okay. Okay, this time.
He always says, I'm out, but then he'll come right back.
Got it. Okay.
So he might even be listening right now, but he's not commenting.
Okay.
Unless he's in the silent. But I don't have any problem with him.
Probably not even
he's
watching.
Trying hard, And I criticized him for going into there and trying to white knight for Aaron on that handicap fireside stream.
Yeah. You teamed up with them.
He does that kind of around here, but I was like, for you to go over there and try to defend Aaron with that was quite naive.
Naive is the one that Scotty's the one that has to have a cat lady handler that's a dog
Mr.
lady.
Jones is Truth Hurts, because there's a Truth Hurts and there's a What's Truth, and then there's a big old long name, and I see you guys calling somebody Pat.
Patrick is
See, I don't know why they have to have it so figured out. Is this contract work? Do they get in a Discord once a week with the feds and trade information for them for their little shekels? I'm just thinking that's the way it looks. You know what I'm saying? Their little Fed kudo treats. Oh, we gotta get this figured out for our Fed handler for Tuesday and get ready for our Discord meeting so we can trade our info with our Fed handler. Seriously, it's the way it looks to me, man. I don't need to figure it all out. I'm too busy for all that shit. Wow.
What's Truth is a Canadian guy.
Okay.
Flat Earth guy.
Okay. I mean, I've been around them for a while, like in chats, and I've seen them around and all that, but I always get the whole thing confused because then there's somebody.
Angela, you're a loser.
Okay, so the Pat guy is who?
That's Truth Hurts.
Okay, alright.
Slash Petro slash.
Oh.
He's got a lot of different aliases.
Okay.
But yeah, I think Truth Hurts is one of his main monikers.
Okay, that's why I get them confused because I think they changed their names or something sometimes, right?
Yeah, I don't think Patrick's allegedly not his real name, but he says that he was going by Patrick for a while. So
Yeah.
So you see Patty.
Yes.
That's a troll account of Patrick.
Got it. Okay.
See, what's going on in the background? That must be Kim in the background monitoring other streams. See, that's it. That's what the cat slash dog lady handler does, is make sure there's no other streams that Cox might be going on to start slamming us and start talking about us, because we're going to have to bring it up.
Well, Nicola, sometimes I'm a little late to the party. What's wrong with that? And
Angela reminds me of one of those babies that takes forever to kick out, right? Because she just doesn't want to come out of her warm little safe space in the little cave, right? And comes out like freaking already 200 pounds out of the womb. Here I am. Oh, God.
what? Better to ask than assume.
I'm trying not to start a fight with Lisa. Lisa might start a fight with me. But as of now, we're at a and Urban too. I was doing so good with Urban the other day until fucking Aaron came in and fucked it all up. Not that it matters. It's fine.
Right.
But yeah, Aaron comes in, says a bunch of dumb shit, and distracts with changing the topic, and then blames you for moving the goalpost.
Yeah, the goalpost word.
But it's like that's what he does. He blames you for the the stuff that he does.
I know, Simon, she is a genius. She knows everything about me. And she loves to talk shit to me on a regular basis.
Oh, so I was going to go. If you guys know Warbot, I guess he was. He made this video about Patrick and was assuming that Patrick was me. The Scotty Karate guy was the guy making fun of Dunya and stuff. I'm like, for the record, that was not me. That was not Scotty Karate. So I went over in the comment section there to clarify that. And I was supposed to be fair, I was supposed to go back and bring him. I think Fellowman has a bunch of interesting videos. And I was going to share, so I haven't done much.
So here's this crew, Patty, straight out of Juvie, at Crying Pat with 1 subscriber. That's awesome, you little sock account, you. Come talk trash to me in your real account. Let's try that, pussy.
Wow, that's so tough, Spamgela. Wow.
If anyone, guys, please don't block the sock accounts, please, Simon. Especially Simon. Simon, you're not that cool.
None of those guys are cool.
Oh, Lesbian Lake wants a wrench.
I know, I'm trying not to take offense to that account.
Do you know that account?
Sort of. It's a sock account.
Oh, okay.
But I'm pretty friendly to the sock accounts, but I'm not that drunk yet to give discrimination.
You mean, it's Fellowman?
So are they making fun of Lisa?
Well, yeah, of course we're making fun of Lisa Lake because she trashes them. So anybody that owns these people, all of a sudden you got a sock account made about you.
So Lake?
I think so.
I just get that info for Lisa.
Yeah, discriminately give out wrenches.
Oh, it says Lisa Fake. So are they making fun of Lisa Lake?
No, not at all.
I think so.
Oh.
That's what I've heard, yes.
Right. Yeah, because that's not nice.
Right.
And you know me, I'm so nice.
Yeah, he's got to be nice to people. That way he can kind of gain your trust a little bit. And you tell him some things about yourself, and then he uses it, twisting it around, uses it on his show for clout for Kim.
Oh, we'll have a good time, baby Nicola. Don't you worry. We'll have a real good time.
CNN gets a wrench over me. Oh, damn it. That is a good point. Then again, you guys, someone will block CNN. Better to give him a rope, you know? Okay. Hopefully Lisa's not mad. If Lisa's mad, sorry.
We'll have a real good time.
Go, PEdward Defense Force!
With my icon on there.
Now, see, no more wrenches till...
She likes to get her tonsils boxed in her face. Go, PEdward Defense Force!
Guys, calm down. Calm down.
They're coming to a town near you.
That one's been around for a while.
With their star, now. Mr. PEdward. He got the CP suspicion. And Kim's gonna get the shoulder to cry on. And the PEdward Defense Force coming to a town near you.
And they took a picture of my face and made it the icon and tells me I need lotion and all that shit.
Yep. The cheese grater effect.
Sorry, Shizzle. It turned into a shit show again, sort of.
How's it going, Shizzle?
Aaron came on and then he rage quit. And then he left us waiting for a fight.
No, they didn't want to go through my bullet points. And I had better shit to do. So, see, that's what they do, is they waste your time on their bullshit little loop and don't get right down to the beef of it, right? They like the scraps. They're like the dogs off the side of the table that are gonna fight any little piece of fat or scrap that you throw at them. See what I'm saying? So then once it gets down time to get after the beef, right, they're still sitting there waiting for scraps. That's how we work it around here. Once again, the puppet effect, right? If you pull the string too far on the puppet, it will break the puppet, right? Just like the Matchbox car, you pull it backwards, okay, and it winds up, and you let it go, and it goes forward just a little bit, right? It just kind of goes right a little bit. But if you pull it back too far, then it breaks and it doesn't go forward at all. So you don't want to break your chew toys here with too much information. I thought I would stick to one simple thing, right, to see if they were interested in knowing the definition of a Proud Boy, right? He definitely wasn't interested in my 6 talking bullet point loop that I had prepared for him. And really interesting the way these little puss bag space-fied communist piece of space trash, have really nothing. Wow, besides this every once in a while. You get together and do this every once in a while. For the public, right? Once they get their whole loop work down after like 6 months, like Velomon, right? He might panel up after 6 months after he's in the background trying to get his loop down, practicing in his lines in the mirror. Seriously, these guys more than likely practice their lines in the mirror.
On panel, even Edward, and
you mean PEdward?
he ran.
Yeah, Aaron's.
You mean PEdward, the CP suspect, right?
Nemesis
Right.
came to fight with Aaron, and then Aaron ducked to smoke.
He ran. He ran.
I don't need to sit and fight with meth heads that want to overtalk you, and they're not going to get the points anyway, right? You guys don't get my talking points, but you like to listen to me, but then take everything that I say and twist it around again. This is fun. It's awesome.
Yes.
Oh,
He took his word salad and left.
That must be Angela. It must be Angela maybe monitoring another stream, making sure people aren't talking about him.
I feel bad fighting a chicken though, so I don't really want to fight someone. I don't want to shoot a man that turns his back,
Yeah, you don't want to do that.
Yeah, that would be horrible.
Yeah.
Then don't talk shit about their family and say you're gonna put their little girl out in the corner of the street and whore them out. I mean, I think that's what happened there. It's obviously not in the court case record, but you guys need to turn it around any way you want. Call people murderers that aren't, Oh my gosh, that's amazing. Even if he is a murderer, hey, it's he did time, 10 years for manslaughter, and when you roll up on somebody and they start running because they know they dumb fucked up instead of stand up to you, you might just get shot in the back for shit like that. I mean, I'm just saying, right? You say that you're gonna pimp out or whore somebody's daughter, okay? You're gonna probably get rolled up on. And when you start running instead of face off, right, and you start running, you might just get shot in the ass or the back. Because that's sometimes what cowards do, is get shot in the back as they run. Right? Oh, man. It doesn't matter that Lavoy Finicum got shot in the back to these people, even though they were diehard Bundy Ranch people at one time, right?
That was
infiltrating.
absolutely horrible.
Whether the pictures are going to come into evidence is going to be the focus once we come back from the lunch break, and that's what that break was about. I mean, that's what the bench conference was about before the lunch break.
Well, and they're probably still discussing it.
Perhaps that's right.
And it's kind of a what's good for the goose is good for the gander thing, because they've made the prosecution wait till 3:53 before they can put Laura Olson, KenPaxton's former mistress, on the stand to answer questions.
Right.
And so they're basically saying, well, the defense has to follow these other rules too.
So it's
I mean,
not
they didn't say
funny
that out
you
loud, but
say
that's
that.
how I feel like.
No, but it's more than how it feels. There actually is the most important precedential authority for a lawyer in a courtroom is the vaunted case of Goose v. Gander, which says if you do it, it's going to turn back on you. And many times I have quoted that case, Goose v. Gander, say, Judge, what's good for the goose, good for the gander. You ruled this way for him on this instance, so I got it coming too.
Right, they're saying if you want to bring these photos in, you got to authenticate when they came in, and there was also this 14-day rule and the metadata thing and
Right.
all this stuff. And so, I mean, how do do they come in, or should they come in?
Well, when you throw rocks at somebody, you can't live in a glass house. So if you're throwing rocks at somebody because their procedural house is in order, you got to make sure your procedural house is in order as well.
And apparently their procedural house was not in order.
Well, we had a lengthy bench conference and we went to lunch, and here we are at 106. So there's something awry.
Well, and there is peril for the defense in this, because the defense wants to bring in all these photos that they say Angela Paxton took, Senator Paxton, in Lowe's and Home Depot, of tiles they were looking at and countertops and everything. So the defense wants to introduce all those into evidence. Well, the prosecution, if those are all introduced, the prosecution may ask, to call Senator Paxton to the stand. They may ask her to testify, about everything she knows and everything else she knows about this case. So, there's the defense may or may not experience some blowback on this.
I've had a couple people with questions in the chat, and guys, if y'all are following the chat, I'm trying to keep up with questions, but there's a lot going on. People are asking, is Laura Olson the woman in the white dress? Yes, that is Laura Olson. One of our photographers got that footage.
She sure has gone to and from the chamber a lot.
Yeah, there's the video again. Yeah, that's Laura Olson. One of our photographers got this footage this morning. This was right around the time they announced that they were going to call her to the stand, and then of course we saw a flurry of activity, and then they announced that they didn't meet the 24-hour deadline and that it was going to be 3:53 before they could call her to the stand.
And she was a chief of staff to Senator Donna Campbell, who's a member of the jury. She worked as chief of staff for several years and was eventually terminated by Senator Campbell, but moved to Houston. And
why was she terminated?
Well, she was terminated when the relationship with the Attorney General was discovered.
Oh, okay.
Supposedly.
I see.
But she moved to Austin and went to work, allegedly, according to the House prosecutors, went to work for Nate Paul.
Interesting. And apparently, and according to testimony we heard earlier, I can't remember from who, I believe, or maybe it was Busby that said it. A lot things are running together in my head, but it was revealed earlier that she's still working for Nate Paul.
Right.
That was during one of the first.
That
might have been during Mateer's testimony that we heard that.
She still works there. Well, I think during the opening statement, Busby said she still works there, an honored employee and doing a great job, and glad to have her.
Well, you have a better memory than I do.
I think that was in opening statement. Busby rolled a lot in that opening statement.
Somebody's asking, Chris wants to know how much time does the House have left? I don't know exactly. They were at a little over 5 hours this morning, and they were a little over 9 hours for the defense this morning. And they seem to have been, pretty. They seem to be, not counting like all these bench conferences and some of these various things against the House. So I don't know exactly. I mean, I'm guessing 3 hours, but that's a complete guess on my part.
Guess.
I mean, I'm throwing a number out without really knowing exactly, because I have no way to know exactly how they're calculating time.
3 hours, 2:45, something like that.
But I know if I'm a member of the House prosecution team right now, I'm going, whew, every minute that we don't come back is another minute we get closer to this.
And the reason we're saying this is because they didn't list Laura Olson as a witness until 3:53 p.m. yesterday. Is that right?
Yeah,
so
3:50. Yeah, I mean, I shook my head.
3:53 p.m. today.
Yeah, and we've talked about this, but I have seen, and I think, Bud, you've watched a lot of the trial, and I've watched pretty much all of it, except for the point. I was watching yesterday during McCarty's testimony, but it was late. But there's been times along the way where I just thought they could have managed the clock better. If you have a limited amount of time, you got to be more judicious.
It's paramount.
Well, there were a couple of days where it seemed like a domino game in Hallettsville. It was just guys sitting around jawing, and nothing. I mean, no progress was made, and the testimony wasn't valid. Victor, I stepped on you.
No, you were making the point that I was about to make.
Well, you can go ahead. We got plenty of time, Victor.
When you have a clock, you have to manage your time effectively. I was telling you, Tanya, when we were getting a cup of coffee, that that means you have to think about what your proof is, what's necessary for your proof, what are your most persuasive points, and you have to order things effectively. And one of the cardinal rules under clock management is to avoid redundancy. And I think we saw that earlier. It's coming back to bite the house managers.
Yesterday, late in the afternoon, was where I really felt redundancy, where I just went, why?
The banker, followed by the banker.
The banker was fine. That wasn't very long. It was, because I think the banker was there to establish that some foreclosure sales did get affected, right? That was what they were trying to do there. And Joe Brown, that's Joe Brown. They put Joe Brown on the stand. He's a former U.S. attorney out of the Eastern District.
Basically, all he testified, he said, I thought there was something fishy. And that summed up his testimony.
Well, but I think his testimony was to establish that there really was a competent, qualified person to do this and not Brandon Kamek. I mean, if you were going to select somebody, if you're the DA or you're the Attorney General, Victor, and you're going to select somebody to be a special prosecutor or an outside counsel, do you pick the guy with no prosecutorial experience, or do you pick the guy who's the former U.S. attorney?
You pick the person, if they're choosing between the two, you're picking the person with U.S. attorney experience. But even beyond that, there are special prosecutors who have been criminal defense attorneys, but the key is that they are criminal defense attorneys. They know the criminal process and can walk through its administration effectively.
You're looking for somebody to investigate the whole federal government and the DPS for $300 an hour. You know, I'm not sure how you're going to get. Of course, then they didn't wind up paying the bill.
No, they didn't. I mean, what does that, Victor? What does it tell you that they didn't ultimately pay Brandon Kamek? Told him he had to eat the $14,000. Wow. That's what Brent Webster told him, or that's what he says Brent Webster told him.
It's unfortunate for that lawyer. However, I can turn it on that lawyer as well, that when you have an engagement, it's incumbent upon the lawyer to set the terms of the engagement. And what we are allowed to do in the legal profession is take an advance payment or a retainer. And this is a good example of why that is a very prudent practice. Because you don't want to get too far out in front of your skis, get so far down the road, you're over $10,000 in legal services, and it's not going to be paid. That's not a situation you want to be in.
They took him to Starbucks, he testified. Then they told him he was fired. They told him he wasn't going to be paid, and then they tried to leave him there. And he didn't even have his car there. And I wanted, did they even pay for his pumpkin spice? I mean,
I don't know. I mean, I kind of felt sorry for the guy. I was like, God, you know, he came across to me as very honest, and a little too trusting.
Well, he was the babe in the woods that they looked for to carry the ball on this, to be, I hesitate to say naive. He didn't seem naive. He just seemed inexperienced. But they were looking for someone who would be daunting enough to take on the whole federal government structure and state investigative force, and just go out and challenge everything about constitutional government and the state law enforcement all at once, please, and get some subpoenas out.
Victor, somebody came to you. Attorney General Paxton came to you and said, I want you to do this thing, or hire you to do this, and they put you in contact with the attorney representing one of the parties, in this case, Michael Wynn. And you get a list, and among the people they want you to subpoena are lawyers that are involved in the lawsuit involving Nate Paul. They want you to subpoena records for federal magistrates, federal bankruptcy judges, U.S. attorneys, FBI agents, the DPS, the Texas State Securities Board. What are you going to do?
I'm telling them perhaps you should go talk to someone else.
Talk to Brandon Kamek?
There are red flags going up all over the place.
Yeah,
it's not something that you see in the ordinary course. To serve an array of subpoenas on the types of institutions and bodies that you're talking about.
I have never. Have you ever heard of such a thing?
I've not.
That's what makes it so stunning. It's like everybody I know that's in the legal system is like, what? They wanted them to do what? But you had to find some young, inexperienced attorney who had to consult with someone on how to file a subpoena because he'd never done a grand jury subpoena. He'd never been a prosecutor. And he gets pressured from Michael Wynn, and this is his testimony, to let Michael Wynn go along with it.
I think your word is right. Stunning.
Stunning. Go ahead.
Well, I was going to bring up too, I think it's pretty stunning. I didn't realize that being Attorney General of a state required 4 telephones, required to have required a separate secret Proton email account, a separate account on Signal that couldn't be found anywhere, traced, and required to have an assistant who gave you the use of his computer at times to write and send emails on, because that way they were under his system, and required the assistant's phone as well to use to make calls that you would then delete the whole call record from. I just didn't realize that those were in the job description for Attorney General.
It's unusual.
It's unusual. I think that's why we're here.
Okay, so now we got a live look up in the Senate chambers because folks were saying, oh, they're just chatting and what's going on in the Senate. Well, if you can see, guys, folks out there, there's not a whole lot of activity in the Senate. We do not see Dan Patrick. He has not come back. The senators apparently still enjoying lunch. I think isn't that Busby? That's Busby right there. Yeah, that's Busby. Some of the House impeachment managers are back, but we don't see just a whole lot of activity going on in those Senate chambers.
There's not a juror in sight.
No, the jurors are still, and that's another thing that's unusual, is normally in a criminal trial, you don't ever see the jurors. I mean, you wouldn't show footage of a juror in a real criminal trial. In fact, if you would like to go to jail, because the judge would put you in jail for doing that, but it's just a whole different, it's different. It's a political trial.
These jurors would like to be on television. I think 6 of them will be running for re-election in 2024. They'd like to be on television.
Let's talk about, lots been made of Johnny Sutton, Victor. I mean, we keep hearing from, these whistleblowers that they don't have an agreement, the written agreement with Johnny Sutton. He's a former U.S. attorney out of the Western District. I forget which one. Is it Western? And that they don't know how much they're going to owe him, and a lot is being made of that. How much of a problem is that?
Well, there should be a lot being made of that. As lawyers, we exist under ethical rules and rules of professional responsibility. One of the most important ones for client representations is that you have your engagement terms set out clearly and simply so that a client knows up front, is apprised what the terms of the engagement are, to include whether there's a fee and what are the terms of that fee. Even in pro bono engagements, we have engagement letters setting out what the terms are so that it's very clear and the client knows exactly what they are responsible for, what the lawyer is responsible for, etc.
About half of the Senate are lawyers themselves. How do you think they feel about this, the case where the people testify and have this one uncertainty surrounding them of, well, who's their lawyer? We don't even know how much he's making.
Well, it's hard to speculate. There are any number of things that could be going through their minds. It could be processing it the way I'm processing it, or they could be thinking, well, perhaps he's a busy lawyer and he just is pretty lax in the administration of his practice. Perhaps they could be blaming an office assistant for not getting the letter out. But ultimately, it's the lawyer's responsibility to make sure that the terms of the engagement are established.
It feels like by not having this, they've left themselves open to that question.
Right, and it is the defense is going to seize on any opportunity like that to cast aspersions or to create doubt.
And the dot that some are trying to connect online is that Johnny Sutton is part of the Ashcroft law firm at this time, which at one point had a contract with George B. Bush's, General Land Office to secure land along the border to build the wall. Johnny Sutton was not one of the lawyers who worked on that contract. It was with 4 other lawyers with a law firm, but he is affiliated with the same law firm.
Yeah, and I suspect that based on kind of what we've heard in testimony that, Sutton was friends with some of these guys. He's Penley is a former federal prosecutor, and so they, but you still open yourself up to something by just not, it's a dot in your eye and crossing your T thing, and you just feel like you should have expected that Busby's going to ask about it. You're going to get asked.
Right. But here's the thing about it. In the eyes of the defense, he's a Fed. And they're trying to convince the jurors and the public that the Feds are all crooked. And the Feds are all running a big conspiracy to get KenPaxton. So it's all the Feds, the Biden FBI, and then the unpredictable, renegade DPS, and that it's all the Feds that are really out to do all this because KenPaxton has lashed out so effectively at the Biden White House. What they leave out when they talk about this is that Greg Abbott sued, when he was Attorney General, he sued Barack Obama's White House 31 times. Suing the White House is something Texas Attorney Generals do, like eating cereal in the morning. It's not unusual for Texas to be opposed to a Democratic White House. We're always.
It's kind of par for the course.
Well, it's par for the course. We're always in direct opposition to a Democrat in the White House. And the next Attorney General, the interim has already been suing Washington, and the next Attorney General, whoever they may be, will be suing Washington if the Democrats are in the White House. That's what Republican AGs do in Texas.
Victor, we were talking earlier about this kind of legal clinic we're seeing play out. Are they going to play this in law schools? I mean, is this going to be, would you play if you were teaching?
I would. There's a lot to be gained here from seeing 2 experienced lawyers, and we're talking about the examination, particularly of Drew Wick, to see these 2 legal stalwarts going back and forth on the rules of evidence, to see the lieutenant governor getting consulted about the rules of evidence. Regardless of what the rulings have been, what we have seen from the lawyers is what we see in courtrooms, but particularly from the prosecutor, we saw a really good understanding and application of the rules and the nooks and crannies of the rules, including exceptions to hearsay. And frankly speaking, arguments that things weren't hearsay, they were not hearsay under the Rule 801E.
But it felt like some hearsay got in, some didn't.
Well,
some stuff that was supposed to come in didn't come in. I was like,
flip the coin.
Sometimes it seems that way in legal proceedings, that things should go one way and they go another way. It seemed that early on in the examination, the lieutenant governor was a bit rocky on the hearsay rule. He seems to be getting some good counsel, and I seem to have seen some rhyme or reason to some of the rulings as the examination headed towards lunch break.
Victor, you said that these lawyers are putting on a good school, but I think that in many cases, particularly the defense, is trying to school the lieutenant governor and trying to teach him to do things their way, and to tell him over and over, as Busby said, that's not the way this works, that's not the way this works, and shouted it at Lieutenant Governor Patrick. And it seems like that sometimes the school is directed at the judge.
Yeah, it seems that way. Something I want to point out as well regarding what we're seeing in this legal clinic on the rules of evidence is that in an actual courtroom where you have a jury sitting in the box, a jury of that aren't politicians or senators, you want to be very judicious in lodging objections because it can get tiring and can turn a jury off. Now, there is an instruction that comes from the court in every trial that the lawyers have an obligation to assert objections. You're not to hold the objections and the assertion of objections against the lawyer. You're not to read anything into my rulings, whether I sustain or overrule the objections. But in real life, when it comes down to it, particularly if a lay jury saw the barrage of objections that they're seeing right now, it would not be good for the asserter of the objections, particularly if they're not being sustained one after another, time and time again.
Right.
Victor, where do the closing arguments go from here? I mean, aren't the two cases laid out pretty clearly? I mean, the prosecution just says, okay, we've proven that there's, bad administration in this office. The law requires delinquencies or maladministration. Particularly in the handling of the outside prosecutor, the open meetings case, the MIDI. I mean, certainly they can say, look at all this. There's some maladministration of some kind here, some poor handling. And then the defense just stands up and says, look, they didn't really prove any of this. And they've just got a lot of people guessing, and a lot of people who didn't really see anything happen. KenPaxton didn't get anything. Nate Paul didn't give anybody anything. Nobody's proven that. And, why are we all here? I mean, is that the way that this goes?
I think that's exactly the way it goes. And I think it's going to come down to what is the definition and meaning of maladministration. Is it a mistake? Is it a lapse in judgment? Or is there something beyond that but short of high crimes and misdemeanors?
Well, and as Bud pointed out earlier, the Texas Constitution doesn't use the words high crimes and misdemeanors. It uses delinquencies or maladministration.
Right. This was the Ferguson v. Maddox in 25, the Supreme Court.
Oh, the Supreme Court decision. That's not.
Yeah,
so
there's no definition at all in the Constitution.
Oh, in the Supreme Court. Okay.
Right,
okay.
and
The Constitution does not set out any requirement for removal.
So, and that's the issue. We know what a high crime is. We know what a misdemeanor is. We also know what a mistake is. But what's going to get mushy for these senators, I think, is without any direction from the lawyers or any argument that fills in the blanks, what is maladministration?
This case that I'm citing in 1925, we know that Governor Paul Ferguson was impeached and removed. That was the
Can you
last
walk people
big
through what happened in that
statewide case. Well, I don't remember
It
all
had
the
to do with
intricacies of that. It was selling pardons and quite a few other accusations. But he was impeached and removed, and then Ma Ferguson ran and was elected. I mean, they were populists that were very popular with the people, regardless of what they'd done in office or who they'd upset in Austin. They were very popular with the people, and they were the voice of the little people. And so Paul was removed, Ma ran and won in his place, and so the Fergusons were right back in office. Paul tried to come back and run in 1925 and filed, and it went to the Supreme Court on whether he could file to run again, and he was questioning whether the clause in the Constitution saying you can never run again, whether that applied, and the Supreme Court eventually held that it did apply, and the Supreme Court wrote in the best definition we have, nobody is accused of a crime. The question for the Senate involves, these are the words, delinquencies or maladministration. The court wrote, and I'm quoting now, the wrongs need not be statutory offenses.
Mm-hmm.
Have they proved maladministration or delinquencies?
And that's the question.
That's the question. The case almost set a standard that allows some political judgment because there is no definition of what it is. That's why I said, is it a mistake? Is it a series of mistakes? Is it a certain amount of mistakes that demonstrates that the administration is not just not the most astute, but that there's something awry? What we do know is that it doesn't have to be a statutory violation. It doesn't have to violate the law per se. Perhaps it's just the appearance of running a ship that's not quite right.
Victor, you've struck exactly at the concerns about Texas impeachment law, and they were borne out in the Paul Ferguson impeachment. when presiding at the impeachment trial was Lieutenant Governor Bill Hobby, presiding over the removal and impeachment of the governor. Of course, if the governor were removed, he would become governor. So he was the judge over a trial that would eventually see him take over the governor's office. And so that conceivably could happen again, and that you could have the lieutenant governor presiding over the impeachment of the governor when the lieutenant governor has this to gain.
Right.
Okay, so folks, Jay, you want to bring that back up? That was the live look. So right now, I'm going to have Jay bring that live look back up. As you can see, still not all the senators back at their desks. Well, that's John Whitmire, right? Out of Houston, that just passed by the camera.
Gosh,
yeah,
he's
so
aged.
but we're definitely not. This Senate is definitely not back in session, and I am guessing, Victor, that they're still back there trying to hash out this legal question about this affidavit. But it also places us about 2 hours and 20 minutes out from.
That's exactly
from
right.
Laura Olson.
Maybe the senators are hanging out till 3:53. Maybe they're.
Well, I was going to leave that to the political analysts, but that did cross my mind that there could be some Democratic senators who are,
taking a long lunch
or stuck in traffic.
Yeah, but I think if that was the case, I think that Dan Patrick would they might send out the squad cars for him. So I don't think they'd play around about that.
It is 2.5 miles to Polvos, I saw. So if everybody went to Polvos, there might be some traffic on Congress coming back. Apparently, everybody at Austin goes to Polvos.
I feel like I want to go to Polvos the next time in Austin. I feel like it's a great place. I feel like the food is really good. I mean, and I've never been to Terry Black's. I feel like I should go to Terry Black's.
Terry Black's is
really good.
Open here in Deep Ellum.
Why haven't I been there?
Yeah, it's across from Pecan Lodge.
Oh, I've been to Pecan Lodge. Pecan Lodge is great. I love Pecan Lodge. Okay, so I had a couple questions from folks in the chat. It's hard for me to keep up sometimes because the comments are rolling so fast, and so I try to write them down when I see them. Somebody asked, what obligation does Lieutenant Governor Patrick to follow the recommendations of the judge who is sitting beside him?
Oh, so.
But does he have to follow those recommendations? I don't think so.
I think it's just purely advisory. It's very clear, however, that whatever she's saying, we don't know if he's following the advice or not, but it seems to me that he is at least listening to and considering what the advisor is saying.
I mean, it feels like he's really trying as much as he can as a lawyer to do the right thing.
It appears that way, which is why I said earlier in this broadcast that whether he's an effective judge, meaning he's the best judge on ruling on motions or objections, is a question that could be debated, but it seems to me that he is demeaning himself as a judicial officer.
You know, I wonder how she's passing word. You see her whisper in his ear sometime, but sometimes he speaks without her saying. You wonder if she has a playing card that she's flipping over, or what the signal is.
Sustained, not sustained.
Yeah.
I mean, or maybe he feels like he's kind of getting the hang of generally of the hearsay thing.
That could be it.
Yeah.
We're waiting on the ruling about evidence. So
yeah, we are. We're still and that's. I feel like that's what the delay is they're trying to decide how to rule on this, right? I mean, if you were advising him, do you think they're going back there consulting with maybe, I mean, I know this is not an appealable thing, but maybe they're consulting with appellate attorneys or something, or I don't know.
It could be.
I mean, it's hard to say.
We were waiting on the countertops. It's
Exactly.
all about the countertops. So we want to know whether we can see pictures of the countertops. Can we see Senator Paxton's pictures?
Okay, Jay's
going
gonna
to have the metadata.
Jay's going to put the countertops back up.
Bring back the countertops.
These are the counter. This was
okay.
That was shown at a press conference.
These are the countertops that were in the Paxton home. Busby held them up at a press conference and said, "See, they didn't even change the countertops. These are not the granite countertops." Well, the House didn't allege that they bought the countertops. The House alleged that they discussed buying the countertops, and that the guy doing the remodeling said he was going to have to ask Nate about that. So nobody ever said they followed through and bought the countertops. So These are the countertops. This is the Attorney General's kitchen. It's been widely discussed, and the question isn't whether those are nice, fancy Italian marble countertops or anything like that.
I mean, they're not bad looking countertops. I mean, they're okay.
They're a little dated.
A little bit, yeah. Victor, what did you think about the fact that this contractor refuses to come testify?
You know, it's one of the things that we have in our jurisprudence is the ability to refuse to testify. And in the criminal context, at least, when it comes to what we can read into that against you, we're not to read anything into it. So perhaps you could say he has something to hide, but somebody might say that's pretty prudent to keep yourself out of the crosshairs and to exercise your constitutional right to refuse to participate.
Bud, maybe you know the answer to this, but one of the producers is asking me, does Paxton have to be there for the verdict? Do we know? Does he have to be there? I don't, I mean, it felt like I'd have to go back, I need to go back and read the rules, but it mainly addressed that he had to be there for
the start. I don't think that the rules required him to be there for the verdict, but I didn't read, you know, and we should explain these rules, this trial, this removal trial, I call it, trial in the court of impeachment, is being conducted under a long set of rules, debated and voted and passed privately by a Senate committee chaired by Senator Brian Birdwell of Granbury. And they set out all the rules for how everything would be conducted, including some that are stricter than what the Constitution calls for, such as the level of proof that would have to be, beyond, without a doubt, and instead of beyond reasonable doubt or something like that. So there's this long set of rules. So now they're debating, exactly what the rules say about admission of evidence, and I don't know where in the, what it says in the rules about Ken Paxton's presence. I don't think so, because really, legally, constitutionally, Ken Paxton is
The
not
Court of
on
Impeachment
trial.
of the Texas Senate is
All right, we're
now
back.
in session.
Okay, we're back.
Oh my gosh, that took so long. I was coming back in the studio.
All rise. The Court of Impeachment of the Texas Senate is now in session.
I was gonna play a music video or something, like, oh my gosh, this is dragging on. What the heck is going on? Thanks for sticking around, a few of you. Kind of an important case here, you know, especially if we get to see the mistress on stand. Holy crap!
Will the parties come forward?
This is not a lie.
And that's all I got to say about that.
I've got doxes on all you bitches.
I doxed her ass. Okay? Technically it was fellow man first in a chat, but I went on a chat friggin' saying her whole name. You know? And that's when you guys would have picked up her talks, you know, you're all listening that night. You know, and, like, she accuses you guys doing it. It's like so weird, and she's sticking to that story. You know?
I know, it's weird. She'll say, like, I put the number, I put her here. She said a bunch of times, like, the only thing I ever did was maybe put, like, 3 letters. That's it. 3 letters.
Yeah. And if Renee can hear, she says that you two doxed her for me. Okay? I doxed her ass. Okay? Technically, it was Fellow Man first in a chat, but I went on a chat freaking saying her whole name, you know? And that's what you guys would have picked up her talks. You know, you're all listening. You know, like, he accuses you guys doing it. It's like so weird that you stick it to that story. I don't know, gosh, don't say like I put the number I put the number right.
Say that, you said that, you said that, say that, you said that.
Members of the jury, we have some resolution between the parties on the issue when we left that they're going to work on and bring that issue back up tomorrow. So I think both parties have come to an agreement. Recall the witness. You're still under oath. Please be seated. You did an excellent job of speaking loudly in the mic, so continue. Mr. Busby?
Yes, sir. I want to make sure we're all on the same page about what we're attempting to do here. Eric, would you mind putting in front of our senators Article 10, please? Drew, help me here a little bit. Article 10 alleges constitutional bribery. Do you see that?
Yes, sir, I do.
It says in the second paragraph, specifically, Paxton benefited from Nate Paul providing renovations to Paxton's home. Did I read that right?
Yes, sir, you did.
You understand that's the allegation being made, right?
Yes, sir.
Now, you had told us about a conversation you heard at the Paxton's Terrytown home, right?
Yes, sir.
It was you, it was General Paxton, and it was a gentleman named Kevin Wood in the kitchen, correct?
That is correct.
Now, of course, you've told us all that you never saw Nate Paul at General Paxton's home, true?
That is correct.
And you knew that the Paxton's home had water damage, right?
Correct.
And you knew Kevin Wood was the contractor, right?
That is correct.
And you knew that the Paxtons had decided to do some additional renovations at the same time they were fixing the water damage, right?
Yes, sir.
And you say you were in the kitchen with General Paxton and Kevin Wood, and they were talking about redoing the countertops, right?
That is correct.
And the mention was that Angela wanted granite countertops, right?
That General Paxton and her had both decided they would like granite countertops, correct?
And you said that at some point, the cost of that was mentioned to be $20,000.
Yes, sir.
Okay. And you can't tell us here whether the Paxtons actually got these $20,000 countertops, can you?
No, sir.
Now, one way we could figure that out is for all of us to go to the Paxtons' home right now, couldn't we?
Yes, sir.
And Your Honor, we could right now, if the court would allow it, get on a bus and drive over to Terrytown and look at the Paxton's countertops. Could we do that, Your Honor?
Objection relevance, Your Honor. You can bring in photographs if he chooses to that were taken at a current time period.
I'm going to overrule. You simply ask a question of something I could do.
Yes, sir. And we may make a motion in that regard, but maybe we can fix it in this way, Your Honor. We had previously looked at an exhibit put into evidence by the House Board of Managers. Let's look at House Board of Managers 703. And Eric, if you would, turn to the 4th page of this exhibit that's in evidence. We can see here, can we not, that Kevin Wood has a email that's sent on July 4th, 2020. Do you see that?
Yes, sir.
And he attaches some pictures of the home at that point in time, right?
I can't see that, but I do see that there are attachments.
Okay, now let's turn over, Eric, if we could, to the page Bates stamped 29672 within that exhibit. And pull that up so everybody can see. And try to bring that picture up so we all can see it, Eric. All right, now we can see what that kitchen looked like as of July of 2020, can't we?
Yes, sir.
I want you to look very carefully at it. Can you see the stove?
Yes, sir.
Can you see the countertops?
It's a little bit grainy, but yes.
And that's how the house looked when you were in that kitchen with General Paxton and with Kevin Wood, isn't that right?
It was mostly covered up by renovations, but yes.
Now, so this is, we'll call this the before, okay?
Yes, sir.
This was the before, the suggestion that we're going to make those countertops granite, right?
Yes.
And we're going to redo the cabinetry, right? That's another thing you mentioned.
Yes, sir.
All right, now let's go back, if we could, to the picture that's in evidence and marked as AG 371. And bring that up. Eric has the most stressful job in this trial. No pressure, Eric. Okay. Here we have a picture of that same kitchen. Is that true?
It would appear so, yes.
And you see the same countertops that you saw in the previous picture, don't you?
It would appear so, yes.
And you see the same cabinets as in the previous picture, right?
Again, it would appear so.
So the question is,
I'm going to object, Your Honor, to relevance. I don't believe this is in the packet that we're referencing. Mr. Busby could cite me if I'm incorrect.
I've already said this is in evidence at AG 71.
Overruled.
The question is, when was AG 371 taken, right?
Yes, sir.
Because if this picture was taken on August 22nd of 2023, then anybody with any common sense would know that nothing was done to the cabinets or the countertops, right?
That would be correct.
May I approach the witness, Your Honor?
Yes, you may.
Before we testify about it, just confirm with me that what you've been handed, which is now...
Objection, Your Honor, to publishing a document that's not in evidence that he has not attributed for the record.
I have not published anything at this point, Your Honor.
The picture is on the screen, Mr.
That's the picture AG 371. This is something different.
Overruled.
Now, take a look at what I've handed you, AG 1051, and would you confirm with me that the picture you're holding in your hands is the same picture that we see on the screen, which is AG 371?
It appears so, yes.
And do you see the exhibit you're holding in your hand has, in fact, the date and where the picture was taken?
It does.
Your Honor, we offer AG 151.
Have you shown it to the defense?
May I see a copy and the date that was referenced?
It's coming to both of us. We'd like to have one. Okay.
Give a
We'll
copy to the
them
other
first.
side,
Give it to them
please.
first. And you can give us a copy. Sir, you can give us a copy. Oh, that's the only one you have.
You have another copy?
Mr. President, I don't want to stave off his direct, but cross, but I think that I can clear something up if I could take Mr. Wicker on a brief for Dyer. I think he's been misled as to the date and time of the photograph he had originally identified.
Again, Your Honor, I'm asking this witness if he has now the date the picture was taken on a cell phone, the exact same picture that's already in evidence. It's not very hard. We're going to get to the truth here.
Overruled.
Tell us, sir, the date of the picture you have in your hand.
It states that it was Tuesday, August 22nd, 2023 at 4:50 p.m.
And where was the picture taken?
It says Austin, Terrytown.
Your Honor, we offer AG 1051.
Do you object?
I do, Your Honor. Objection hearsay. He hasn't established a proper predicate to make it relevant to this trial. It doesn't have an address, and Mr. Wicker cannot say that he fairly and accurately depicts something that he's actually seen.
Overruled.
Now, Eric, please publish for the ladies and gentlemen of this distinguished jury the picture of the Terrytown Paxton home that was taken in August of this year. Do you see there, sir, that the cabinets have never changed?
It would appear so, yes.
Do you see there, sir, that the countertops have never changed?
Mr. President, I'm sorry. I must insist. He's provided metadata, but without any source for it. I am not trying to impugn his character, but this is a court of law, and he has to establish the predicate for the information that's contained below. He has not done that, and he intends to rely upon it. It is hearsay.
It's in evidence already, Your Honor. You've ruled on it. It's in evidence.
Your Honor, with all respect to Mr. Busby, he's misleading you. The photograph is in evidence. The information contained beneath it is not. That's what he's asking you to do now.
Again, we can look back with the court reporter. I offered 1051. The court allowed it.
In that case, Mr. President, it is fully within your discretion to correct an error. I am not conceding that it is admitted, but if it were, in light of the fact that he cannot establish that anything beneath that photograph is true and he intends to dance upon it, I would ask that the court help correct that issue.
That picture, Your Honor, as you can tell, is the same picture that's in evidence. The only addition to it is now we know exactly when the picture was taken and where it was taken.
Which establishes the exact issue, Your Honor. There is no one here who can establish whether or not this picture was in fact taken August 22nd, 2023, and any 12-year-old can create that graphic on a computer.
Your Honor, this lawyer is suggesting that me, an officer of this court, has somehow doctored a picture when I've offered to go over to the home right now and look at the kitchen and it'll look exactly like that. Why would somebody who has an obligation as a prosecutor to find the truth try to prevent the truth from coming out? This is in evidence. The picture's in evidence already. The court's allowed now the picture in evidence that shows when it was taken. I would allow.
I am not trying to impugn anyone's character. I am acting as a prosecutor and a rule follower, and I expect to do that here so no misimpressions are left with the court.
This is allowed in evidence.
Thank you, Your Honor.
Overruled.
Now, you care about the truth, don't you, Drew?
Yes, sir.
You want the truth to come out, don't you?
I believe it has to.
Yes, it's important, isn't it?
Yes, sir.
And now we see that the picture of the Paxton home, we can see that there were no work done on the countertops, can't we?
Yes, we can.
We can see that there was no work done in the cabinetry, can't we?
Yes, sir.
Pretty clear, isn't it?
From those images, yes.
Accusing someone of bribery for accepting granite countertops and new cabinetry is a very serious allegation, isn't it?
I would agree.
And you understand that Mr. Paxton, General Paxton, has no obligation to prove anything, right? He's being accused
Yes, sir.
He didn't have to prove anything, does he?
Yes, sir.
But we've proven that the countertops were not altered in any way, haven't we?
The countertops appear to have not been altered.
The cabinets have not been altered in any way, have they?
It would appear that way, yes, sir.
And in fact, we've created a comparison picture. It's exhibit 1052, AG 1052. May I approach? Can we agree, Drew, that 1052 that you're holding in your hands is a picture? The one on the left is the one we just looked at, right?
Yes, sir.
And the one on the right is the one we looked at from Kevin Wood, right?
That is correct.
And they're side by side on this exhibit, true?
That is correct.
And we know the one on the right was taken in July of 2020, right?
Yes, sir.
And we know the one on the left was taken years later, August 2023, don't we?
Yes, sir.
We offer 1052.
Do you have a copy of that? Would you please provide a copy?
To clarify, I see AG 371 and I see House Board of Managers 73 on 1052. Which one of these two photos is supposed to be 1051?
I'm not answering her questions, Your Honor. I've offered this exhibit.
Then I object to relevance.
This is a comparison, as I've laid out with the witness. He's established the relevance of this picture. It compares the one taken in years back in 2020 with the one taken last month. We'd offer it.
Overruled.
Would it be accepted, Your Honor?
What is the number again?
1052.
1052 is admitted into evidence.
Thank you, Your Honor. So can we agree, Drew, that your concerns now have been put to bed, at least with regard to the countertops and the cabinetry?
With regards to those two items, yes, sir.
I mean, now you're satisfied, right?
Yes, sir.
Okay. Now, I want to show you some other documents and evidence. I mean, it shouldn't be that a friend, a family member has to prove their innocence, should it?
In a court of law, my understanding is that they're supposed to provide evidence to answer the charges. The answer to your question is no, you're innocent until proven guilty.
Yeah. AG Exhibit 332. Thank you, Eric. This is a invoice. Can you tell us all the date of the invoice?
The date of the invoice is September 1st, 2020.
And the invoice is from whom?
Cupertino Builders.
And I just want you to keep that date in your mind, September 1, 2020. Can you do that for me, Drew?
Yes, sir.
All right, Eric, go to AG Exhibit 410. Can you see the date there on this USAA claims correspondence?
September 16th of 2020.
So here we are 15 days after that invoice that we saw previously.
Yes, sir.
And turn the page, Eric. And we can see as of that time, the claim being made with regard or with USAA is being administered.
Yes.
Okay. AG 428. Drew, this is a document that's in evidence from the state of Delaware. Do you see that?
I do.
And do you see it's a document related to Cupertino Builders?
I do.
And can we agree that that's the same entity that we saw in the September 1, 2020 invoice?
Yes, sir.
And would you look at the very bottom line that gives us the date that that company was incorporated in the state of Delaware?
It appears that the filing was April 16th of 2020.
So what we know is in April of 2020, Cupertino Builders was incorporated in the state of Delaware.
Yes, sir.
And we know that months later, it issued an invoice to the Paxtons for work on their home.
That's correct.
Go back to the invoice, please, Eric. Go back to AG 332, Eric. I just want to look at this invoice that was issued September 1, 2020, okay? Turn to the second page, Eric. Do you see the total amount invoiced to the Paxtons for the renovations of their home?
$121,000, 817.
You have a pen with you?
No, sir, I do not.
Drew, would you do me the favor of writing down the amount of that invoice on your Post-it note there? $121,617.
Yes, sir.
And we know, of course, that Cupertino Builders was a Delaware corporation as of the time this invoice was issued.
That is what it says.
Let's look now at AG Exhibit 48. And turn, Eric, if you would, to the bait stamp EBT 184. These are some text messages between General Paxton and a guy we might hear from in this case named Chip Loper, all right? And could you pull that text up, Eric? We saw that invoice was due on September 30th, 2020, right?
That is correct.
And now we have a text from General Paxton to his blind trust, or his trustee of his trust, instructing him to make a payment, don't we?
That is what the text message says, yes.
And confirm with me, if you would, that the amount that Chip Loper, the trustee, is being instructed to pay is exactly the amount that's on your Post-it note that you just wrote.
I can confirm.
Say it again.
I confirm that.
Exact, right?
Yes, sir.
Eric, bring up AG Exhibit 47. So what we've seen so far, Drew, is we've seen an invoice that's due on September 30th, right?
Yes, sir.
We've seen a text from Mr. Paxton to his trustee instructing him to pay, right?
Yes, sir.
And we know those amounts are the same, true?
Yes.
And now what we have in front of us is a bank statement from Prosperity Bank, right?
That is what it says.
And would you please confirm with me, go to page, we're looking at AG 47, go to page 116, EBT 116. And would you confirm that the day after Mr. Paxton, General Paxton, sent the text to his trustee that a wire was made from Mr. Paxton's account of $121,617?
I can.
And is that the same number that you wrote on your Post-it note?
Yes.
And let's go to AG 333. Do you see here that this is another record from a bank, BBVA?
I do not see BBVA. Oh, yes, I do. Okay. At the very end.
Business Choice Checking account?
Yes, sir.
And can you confirm that that account received a wire in the exact same amount as you wrote on your Post-it note?
Yes.
And it matches to the letter, to the penny, the amount of the invoice
Yes.
and the amount of the wire out of the Paxton's account?
I don't see where this says that this is the Paxton's account.
We saw the previous Paxton's account. What we've seen is the invoice, the wire out, and the wire in, haven't we?
Yes.
Okay. When you raised your concern, because, I mean, that's what you raised it first with some of the folks in the office. Is that how it went?
I sought advice from a trusted individual who brought me into the office first, yes.
Is that Brickman?
No, sir, that was Mark Rylander.
Okay, so you went to Rylander and said, look, I heard something that sounds a little weird. What do I do?
Yes.
Because you didn't know what to do about it.
No, sir.
And what he told you to do, hey, just raise it with General Paxton, right?
His advice was that if I was comfortable raising it with General Paxton, then I do so, and that I also informed Blake Brickman as my direct report.
Okay. And he told you that your understanding was just wrong, didn't he?
That is what General Paxton said, yes.
He also told you he appreciated you bringing that to his attention, right?
That is correct.
And you accepted that, didn't you?
Yes.
And it seemed logical, didn't it?
I still had some questions, but yes, I did take it at face value.
And he never told you not to tell anybody, did he?
No, sir.
I mean, he never said, hey, keep it on the down low, Drew, did he?
No, sir.
He told you specifically, Drew, I'm paying for these renovations, but I appreciate you sharing that with me, but that is not what this is, right?
Yes, sir.
And you took his word for it, didn't you?
I took his word for it.
Now, you don't have any personal knowledge about any relationship General Paxton may or may not have had with anyone named Laura Olson, do you?
I've only witnessed them together the one time.
So you don't have any personal knowledge about their relationship other than you saw a woman come out of an elevator, right?
I saw Laura Olson come out of an elevator, yes.
Okay. Now, these trusted people you mentioned in the office, you were talking to them often, weren't you?
On a daily basis.
Y'all were friends?
Yes.
Did you know they took General Paxton's name off the letterhead?
I don't know what that's
Objection, Your
referring
Honor. Facts not in evidence and proven to be false in the course of this trial.
Sustained.
Did you ever discuss with them taking General Paxton's name off his own letterhead?
No.
Objection, Your Honor. Question calls for hearsay, and it's facts not in evidence.
Sustained.
Now, just so we're clear, you are not accusing or providing any evidence that General Paxton did anything wrong in this case, are you?
The only evidence that I bring to the table is what I overheard and what I've reported. That is it.
Pass the witness, Your Honor.
Your witness.
Thank you. Mr. Wicker, you sometimes ran personal errands for General Paxton, is that right?
That is correct.
When you did that, were you advised which service you were using, the campaign fund money or work money? Did you have to attribute where money was spent or your time was spent?
I wasn't compensated for most of those services, so no, I was not.
Okay, thank you. The second, because Mr. Busby asked you extensive questions, you told us that the damage was in the bedroom, correct?
Yes.
And did you see actual renovations anywhere in the home outside of the bedroom?
Yes.
Is it fair to say if you knew people were looking into your countertops and your cabinets, you might choose at that point not to get them upgraded?
Objection, speculation, Your Honor.
Sustained.
Okay. Do you know, in the course of working with the adjuster and looking at Steam Clean and those groups that work for the insurance side, or let me do this differently. Do you know that payments were made by insurance?
I do not know that firsthand, no.
But we've all taken as a given, I think, through the course of talking to Mr. Busby, that more further renovations were done, correct?
Yes, and that's what the document said.
Okay. I want to clarify something else, and I'm sorry to put you on the spot. When Mr. Busby was showing you pictures of the kitchen, do you have an independent memory now in regards to what those what the countertops looked like, or are you taking his word for it?
To the best of my recollection, those were the countertops.
I do not want to lead, so I'm going to ask you a question only because of a prior conversation. The answer doesn't really matter, but I want to clarify. Didn't you say redo the granite countertops when we first spoke? Meaning what was being changed may or may not be granite again?
That was a mistake on my part, and as I mentioned to both you and Mr. Busby, I had to amend that statement to be more consistent with other statements made to law enforcement.
I see. So you've already had a conversation specific about this with Mr. Busby?
I did.
Okay. Have you and I had this particular conversation?
To the best of my recollection, yes.
Okay. And so when you made that correction for yourself, it's not because you were lying the first time, right?
No.
Okay. What is the most relevant part of that conversation with Kevin Wood? The renovations, which we know took place, which people only know about because of you, or the state of the cabinets and countertops?
Objection, Your Honor. Leading, number one, and number two, I don't think it's appropriate to ask the witness what's most relevant. That's the court's job.
I think it made the point. It's okay. I'll move on.
Sustained.
Thank you. How many times did you hear the phrase, "I'll have to check with Nate"?
3 times.
Over the course of one day or multiple days?
In the course of one conversation.
Thank you, sir. Do you have any question then that on 3 different occasions, the response to a question directed at Kevin Wood about financial impact of renovations was, "I'll have to check with Nate"?
That is correct.
Since you've already spoken to Mr. Busby, let me ask you a few questions about that. How did your conversation go? Did you call him or did he call you?
Whenever we were in preparing for this trial, every effort was made whenever the House team reached out to offer the same thing for the defense. And it was in response to that, in preparation for this testimony here today, that my counsel and I both reached out to Mr. Busby's team to have a conversation prior to me taking the stand.
It's an honorable and fair thing to do. Had you made prior efforts to speak to Mr. Busby or Paxton's team?
My legal counsel had, yes.
On your behalf?
Yes.
And at any point until the last week, did they take you up on that?
They did not.
He asked you a lot of questions about whether or not you overheard an agreement between Nate Paul and Ken Paxton. Do you recall that?
Yes.
Do most people who are working together stand on top of a mountain, hands on their hips, and say, "I'll do this for you if you'll give me X"?
Objection, Your Honor. That's an improper question. Leading and
Sustained.
I mean, come on.
Do you understand that law enforcement and this investigative body can use circumstantial evidence to determine whether or not there's a conspiracy?
I'm sorry to interrupt. Objection, improper question. Speculation.
Sustained.
Yes, Your Honor. Let me do this differently then. Do you have any memory of when the Paxtons moved back into their home?
This would have been probably August, September timeframe, if I had to guess.
Okay. May I approach the witness, Your Honor? For the record, I'm showing him what's marked as 698 and not in evidence as a document to refresh his recollection. Mr. Wicker, do you recognize that?
I do. If you can just give me 1 second to read.
Yes, sir.
Can I get a copy of that, Your Honor?
We'd like to have a copy.
I mean, in candor, there are multiple copies over there, but I don't have them. May I take his and pass it around?
Yes. Give it to the defense first. We'll stop the clock for a moment. Are you ready?
I am.
You can resume the clock.
Since we do have a copy for everyone, I'm going to change course, actually. This is a text message that's included in 698, which is a set of documents provided with a business records affidavit, which have been provided to defense, and they've had notice of it for over 14 days, at which point I would move to admit 698.
I have no objection to this, Your Honor.
The court will admit Exhibit 698 into evidence.
And would you publish? Thank you, Stacy. Who is this a conversation between?
This states to be a conversation between myself, Mark Rylander, and Jeff Mateer.
What is the date?
It appears to be July 19th of 2020.
Okay. And do you see any reference to when the Paxtons might be moving back into their home?
It appears that it was around that time frame. So judging by the context here, he had been storing clothes at the AG's office, and we moved those back around that time frame.
Okay, so fair to say then the Paxtons' home was at least renovated enough for them to return to it in the middle of July?
Yes.
And would it surprise you to know that nowhere in those Cupertino records is there an invoice or estimate at any time during June or July?
I did not see that.
Leading, Your Honor. I'm going to have to object to leading.
Sustained.
Next, let me ask you. Let's turn to item 683, which is already in evidence. And Mr. Wicker, I'm sorry to take advantage of you since you're on the stand, but I need to recap a couple of things Busby went through. Tell me, if you would, the date on this document.
September 30th of 2020.
This document has been admitted as what we refer to as the cease and desist letter. So notice to Brandon Kamek to stop working. Are you aware of that time frame in the office?
I am.
And do you know that Brandon Kamek reaches out to KenPaxton to let him know their problems?
I learned this later, yes.
Okay. But does this email corroborate what you heard?
Objection, Your Honor. I'm sorry. He just said he heard it later. That's hearsay. Now she wants him to corroborate hearsay with something else. Improper.
Sustained.
Okay, let's look at the document itself. September 30th, cease and desist letter to Brandon Kamek. Let's look at item 130. Do you see the date on this letter?
September 30th, 2020.
Is that 1:30? Oh, yes, ma'am, please. Sorry, Stacy. Thank you. Do you see September 30th referenced on this document as well?
I do.
And in the records provided by Esther Blind Trust, this is the first conversation about payment to Cupertino. Would that surprise you?
I was not aware of Esther Blind Trust, so I'll take your word for it.
So, but September 30th, Brandon Kamek is notified that there's a problem. KenPaxton finds out, and the first thing he does is tell the Esther Blind Trust to send $121,000 to someone else.
Okay.
I'm going to turn your attention to item 223. I think this is also not in evidence. So do not yet. It is in. I got thumbs up from the side. In that case, will you pull up item 223? I'm going to have you scroll down, Stacy, to the return. Do you recall General Paxton being out of town at the end of September, early October, as the whistleblowers are coming forward and law enforcement is being notified that they're concerned he's accepting bribes and misusing the office? These questions are no different than the way he phrases them.
If I could, without being interrupted. Your Honor, this is outside the scope. I just want to flag that for the court. I'm going to let her do this because I want to talk about a few of these things that are outside as well.
It is outside the scope, but he's not objecting, so he will be able to do the same.
Yes, Your Honor. If it would have been helpful, though, I took extensive notes. Mr. Busby opened up all of these doors for me. Yes, sir. Thank you.
You're both out of scope, okay? You're both free.
On October 1st, do you know where General Paxton was in regards to the office? Did he come in?
No, ma'am.
And I'm going to have Stacy scroll down a little. Are these texts between you and Jeff Mateer?
Can you scroll up? Yes, yes.
And what is it that you understood on October 1st was happening with the general?
I really didn't have an understanding at that time.
Did you think anything about the fact that he wasn't there or didn't want you to let people know what he was doing?
Objection, Your Honor. Leading, and he's already said he doesn't know.
Sustained.
I'm going to read from a document because it is in evidence. Says he has a lot to do out of the office and that I'm to tell anyone that asks that I don't know where he is. Is he telling you to lie?
I don't know that he's asking me to lie, just to state that I don't know where he is.
Stacy, if you would please turn to Exhibit 131. Pause for a moment. In the upper left-hand corner, do you see that this account is affiliated with the Esther Blind Trust?
I do.
The same organization that was being told to make payment the day before by text, according to the documents and evidence before you.
Yes.
Do you see, scroll down for me. Do you see that same $121,000 payment, $617, being made as it was requested by KenPaxton?
I do.
And do you see who the recipient is?
Cupertino Builders, LLC.
Miss Stacy, if you'll pull up 703 for me, please. I'd like to see page 21. All right, Mr. Wicker, do you see who is supposed to be the count holder on these documents? It's under business choice checking, specifically choice.
Cupertino Builders, LLC.
And do you see the first line in the transaction sheet?
It shows an incoming wire in the amount of $121,000, 617.
Consistent with Cupertino being paid for remodeling or doing work at KenPaxton's house, if that's what he has alleged, correct?
Yes, ma'am.
Let's turn to page 3. These are the same records that include Kevin Wood, the contractor who you personally met, who helped facilitate whatever upgrades KenPaxton might want, a person whose email address suggests he is Nate at World Class, and an individual named Raj Kumar. Is that correct?
Yes, ma'am.
Stacy, may we see the face of the business record affidavit? Do you see before you that the business records we've been referencing and that are already admitted belong to Cupertino Builders?
Yes.
Would it surprise you to know that, as Mr. Busby pointed out, it's when they were in Delaware and before they opened a Texas affiliate? Would you have any reason to be surprised by that?
Objection, leading, Your Honor.
Sustained.
Do you also see that the individual otherwise referred to as Raj Kumar is in here named, I'm gonna butcher it, frankly, on the second page? Narsima Raju Sigaraju.
I do see that.
It was a valiant effort. I saw your smile. Next, Stacy, may we see page 16? Is this the same invoice Mr. Busby showed you a moment ago?
It appears to be, yes.
The same invoice that he splashed in his press conference for representation of General Paxton?
Objection, Your Honor. Improper question. She's talking about a press conference? I mean, that's not proper.
I'm going to sustain, rephrase.
Stacy, if you would for me, please turn to page 22. Now, Mr. Wicker, in all of the records before you, if there had been payments or estimates or supplies or timelines or communication in regard to payment in any way, in regards to KenPaxton and Cupertino, don't you think Mr. Busby would have pointed it out?
Objection, Your Honor. Leading.
Sustained.
Then the very last thing I would like to ask you is this. In regards to the document, the invoice we had just looked at, this document is the metadata that was provided by Cupertino. It is already admitted into evidence. Please tell me what date that invoice was created.
October 1st, 2020 at 7:50 p.m. Central Standard Time.
After the whistleblowers, after he knows that you're aware of the renovations, after a cease and desist, after directing payment, only after all of those things does he get the first piece of documentation that would in any way credit that it was valid.
Objection leading.
Sustained.
I guess I'll end where the defense began. There are no coincidences in Austin. But the next piece, I think...
Objection to the sidebar.
We've had a lot of sidebars in this
a little bit of sidebar.
trial. I'll give you a sidebar. They've had a few.
One sidebar.
Overruled. You're even now on sidebars, okay?
The very last piece, I wish I could have ended there, but I need to get in the Uber records we discussed yesterday. The court had already said that they could be admitted after extensive arguments between both sides. I just failed to offer on the record for their admission.
Go ahead.
House moves to admit item. Sorry. 700.
700 will be, we've already settled that, right? 700 yesterday. Okay, 700 will be admitted into evidence.
Your Honor, can we be heard on that? I think we have, I didn't know this would not be the right witness for this, but can we be heard on those records?
We spoke extensively and the court ruled yesterday.
Your Honor, we saw, I apologize.
I'm going to object to using the time, and may we approach?
Okay. We'll stop the clock for a moment. Approach.
Okay, Victor?
This is some exciting testimony. I'm enjoying what I'm seeing right now, and it's particularly genius and very, very effective. When you take a phrase used by the other side, you throw it back at them in context, right when you're supposed to smack them. That was pretty good.
That was really good. Well, because we were sitting here talking about it. Like, I'm sitting here going, they're going to say it. They're going to go, there are no coincidences in Austin.
She stepped up and she
We've been
delivered.
talking about that up here. We've been saying, they're going to circle back and say that, they never did get the renovations. They just said they had to talk to Nate about the reservations. It was all Nate. And then you get to the money being drawn out and the money matching up exactly the same date. And we all sat here and said, there are no coincidences in Austin.
What we saw here and what the prosecutor highlighted is circumstantial evidence. Something that I wrote down was, quote, I'll have to check with Nate.
3 times.
3 times. That was effective testimony to the point about whether there was a quid pro quo. Sometimes in a court of law, judges use the example to explain what circumstantial evidence is. I can be inside of a courtroom, but if I see somebody walking into the courtroom with a dripping wet raincoat and an umbrella in their hand, I might not see the rain, but I can fairly infer or deduce that it is raining. That's in essence what the prosecutor's doing here with the quote, I'll have to check with Nate.
How powerful is it that there are, based on what we're hearing, that there are no invoices, there's nothing prior to October 1st of 2020 on this? I mean, the timeline, because the whistleblowers go to the FBI on September 30th, the cease and desist letter is occurring September 30th, all these things are occurring, and so the next day, suddenly we've got an invoice and we've got a payment.
It's certainly coincidental.
How much do you have to prove that something actually changed hands? If you're proving suspicion of it, is that going to be enough to sustain an article of impeachment?
And that's the question. So when we talk about circumstantial evidence, it's the strength of it that really matters. Is the quote, I have to check with Nate enough? Maybe not, but when you put it together with other things that seem to coincide and it comes together as a body, then the prosecutor has an effective argument that I have proven that it rained outside even though he didn't see it.
Yeah, I still feel like the defense is going to say, KenPaxton didn't get anything. You can't prove that he got anything. There's nothing that he was given at all. There's nothing that Nate Paul was given at all. So all these things happened. He's a supporter and a chum. He's entitled to do this as Attorney General. I still think that the defense is going to make all these arguments effectively enough for some of the Senate.
No, I believe that's exactly right. In any public integrity investigation, that is or a trial, that's the angle that the defense should take. And we can already see that that's what they're going to do in closing argument, because they've made some of those points through speaking objections.
Right, and we are 1 hour and 22 minutes from when Laura Olson can be put on the stand. Now, we don't know that will happen at 3:53, but that's the soonest that they could call her.
Right.
So, based on what's happened today, we're going to hear from Laura Olson. This is going to happen.
I believe so.
I think we're going to see her. So.
And I think they're going to have enough time.
Call your cousins, call your relatives, and say, get on the live stream.
Yes, get on the YouTube, watch
get your popcorn ready.
That's right.
I mean, this is going to be some, interesting viewing. I mean, I don't, it's like if you had, I've said this before, if you had told me at the beginning of the year when they reached the settlement that we would be here, right? And then if you had told me not only would we be here, but we'd be hearing from the woman who is at the center of, of all these allegations involving Nate Paul and KenPaxton, I really wouldn't have believed it. I mean, you cannot. Okay, yeah. This is video from this morning. That's Laura Olson.
When she thought she would testify.
Right. Yeah. So this morning, not top of the morning, they said, the prosecution said we call Laura Olson, and then all of a sudden, they're gathered around the bench, and we're like, okay, what's going on? And then we found out, they couldn't call her yet.
But you said, would we have thought all this when they settled, when they signed the settlement? Of course, the reason that we're seeing all this is because General Paxton asked the state of Texas and the taxpayers to pay the $3 million settlement to all these employees who were fired or resigned. So that the senators questioned it, the House questioned it, the House started pulling all these threads together in a 2-month impeachment process, sent the notes over to the Senate and said, we think there's enough here to have a court of impeachment. And that's why we're here today, questioning the Attorney General.
Well, and you had about 2/3 of the House Republicans, and in the entire
61 House Republicans.
And all of the Republicans in Collin County in the House voted for this.
Right.
I mean, that's extraordinary.
Right.
I mean, Jeff Leach and Fred Frazier, all these people, that's just, I mean, I remember the day it happened, I was blown away. I had gotten the sense from political types like Jason Whiteley and yourself that, it was looking like it was going to happen, but I just didn't think it was going to be by the numbers.
Right. Collin County is not locked up tight as tight as people thought. But of course, they would say that what they were saying is not that he should be removed, but that there was enough to have a trial. And that was what the House sent the articles of impeachment over. They sent 20 articles of impeachment. We're only considering 16. There have been 4 that have been set aside that can be considered by the Senate at a later date. So we're considering 16 articles of impeachment. The House prosecutors need only prove 1 in order to sustain the impeachment.
Yeah. Well, I don't know. Do you think we wrap up testimony today?
If we do, we'll be here past 5 o'clock for sure. But
oh no, I think we're going to be here past 5.
Yeah, it could happen that we see it wrap up today.
If you were the defense, do you put some people on stand?
Based upon what I've seen, I think that they will probably stand on their cross-examinations and try to wrap up their case of doubt and close an argument.
Yeah. I mean, I don't know. I feel like that it's going to be it wouldn't surprise me to see opening statements either tomorrow morning or tomorrow afternoon.
Yeah, I agree.
I mean, closing statements, sorry.
They have a long list of political enemies that they could potentially call as witnesses, and they have some time left on the clock.
Well, because we could see a situation where they can put witnesses up, but there can be no cross.
Right.
Because there's more time on the clock for the defense than there is for the prosecution. So you could see that situation.
That could happen.
So you have you have the defense and all the closing, and so you have Tony Busby able to eat up a lot of clock.
Possible.
It's possible.
And we don't know exactly where the clock stands. We know where the clock stood this morning. We don't know where the clock stands at the moment. I mean, it's kind of hard because, we've had a lot of like this where we're looking at this live look and seeing them all gathered around. How much more do you think that Erin Epley is going to do with Drew Wicker here, Victor?
Well, she's done a very effective job on redirect. And this happens a lot, and I'll get to your question. This happens a lot where we see, I'm not calling her lackluster on direct, but the cross-examination comes and that fire and passion comes out and you really start smacking it on redirect. That's what we saw there. I would think that she's probably just about done based upon the rhythm I saw.
But she brought the rapid fire energy that both addressed the clock problems and woke the Senate up.
Oh yeah,
So,
they were awake.
It got us awake, and we were like, "Whoa, okay, this is good stuff."
She brought a tremendous amount of energy and attention to the prosecution.
So, if you're Busby, how do you undo this, or can you?
Well, I think he did an effective job on cross-examination, which is what the prosecutor stepped up to on redirect. I think he probably has done just about everything he can do with this witness. And again, he did an effective job on highlighting some defense themes and or the lack of evidence or the allegation of the lack of evidence through what to me is a very credible witness. This witness is very contemplative and circumspect, and what he says or what he testifies to, these senators are probably going to believe.
But again, as Bud pointed out, you don't have to prove a crime here.
You don't.
Well, he is. He's saying that this is just all suspicion. He keeps asking them, "You didn't see anything, did you? You don't know this happened, do you? He didn't get anything, did you? You don't know that." He says, "You don't know that. You don't know that."
But we know he got a lot of love from the AG's office.
Right.
Whether you can prove that's there's no doubt that Nate Paul got a lot of special attention from this Attorney General's office. That's not in doubt.
Yeah, whether it's the foreclosure on the courthouse steps, or just seemed like Nate Paul was a very important citizen of all the voters in the state of Texas. It seemed like Nate Paul was a very important citizen of the state of Texas.
I wonder. So we're now. I don't know. My math is not all that great, but we're obviously closing in on 353 here. Who do we put up? Because presumably they're going to finish with Drew Wicker. Who comes up next? We haven't heard from Blake Brickman.
Right.
They're not going to. I don't know if they're going to put Don Clemmer. Don Clemmer was the person that was dealing direct with from the Travis County DA's office. I don't know. I'm not sure who the interim witnesses. Do you think that maybe? Well, they're not going to take a break yet.
Well, you never know. Sometimes in courtrooms there are mid-afternoon breaks. So after this witness, they could take a break.
It looks to me like the jurors are all standing around and taking their.
So maybe this is their break.
Taking their lollygag break. So we'll.
Well, they're kind of all waiting to see what's going to happen here. Let's see. Let me pull up the Senate feed and take a look at that. Yeah, right now you still have all these lawyers kind of gathered around trying to figure out, what to do.
There's one fellow there on his phone chatting it up.
Yeah, exactly. They're just all. Let me ask you this, Victor. We haven't talked about this. We've asked some of our other legal experts. What do you think about the decision for KenPaxton not to be here?
Well, I can see it both ways. On the one hand, it could give the impression that he's feckless regarding what's going on and could care less. On the other hand, it could be that they don't want him to be judged based upon expressions or the lack thereof.
Okay, they're back in court. Let's take a listen.
Court will come back to order. Court will come back to order. Where were we? Ms. Epley, were you up here? I think you were. So when we last left, and you can restart the clock, you were asking to admit 700.
Yes, Your Honor.
There was an objection. We've looked at the two documents. I had ruled that in yesterday. We see that they are similar, and so 700 is admitted into evidence.
Thank you, Mr. President. Pass the witness.
Eric, would you do me the service of putting on the screen what's in evidence, House Exhibit 571?
Objection, Your Honor. I don't believe this document has been admitted.
We offer 571 if it's not in evidence.
I'd ask that he take it off the screen,
Yeah,
Your
take
Honor.
it off the screen for now, Eric. We all know Eric,
We love Eric.
and everyone knows Stacy.
It's actually in evidence, I'm told.
We're checking. You don't have it? We'll check. Is this the House or AG's?
House Board of Managers Exhibit 571.
That is, Ms. Epley, it is in evidence according to our records.
Thank you, Your Honor.
Very good. Thank you.
All right.
Pull it on the screen, Eric, and make it big. And make sure you capture the time and date of this text. Get the date too, Eric. I'm gonna need somebody to confirm the date. Penley 5. As we're getting this date, can you see there that there's a text sent from Jeff Mateer to General Paxton where he tells the general that yesterday each of the individuals on this text made a good faith report of violations of law?
I can.
Do you know what date that was done?
I do not.
Okay. If this text was sent on October 1st, because we know they went to the FBI on September 30th, that means they were sending this text the day after, correct?
Yes.
On October 1st, 2020. Makes sense?
Yes.
So on October the 1st, 2020, Jeff Mateer, along with several other individuals, sent this text to General Paxton, right?
That is what it appears to be, yes.
Now let's look back now, if we could, Eric, at the date and time that the general instructed his trustee to wire the money to pay for his home renovations. You heard the suggestion, I'm sure, Drew. You heard they suggested he only did that because he knew that his people had went to the FBI?
Objection, compound. I don't understand the question.
Overruled.
Yes. You heard that suggestion, didn't you, Drew, that the general learned that a few of his subordinates went to the FBI, and therefore he hurriedly sent a text to pay for his house repairs? You heard that?
That was the insinuation in the last line of questioning, yes.
That's what she was insinuating, wasn't it?
That is what I understood, yes.
But the truth is, if we look at AG Exhibit 48, and we go to EBT 184. Could you just tell us all, so we'll be clear about how the timing actually was? What was the time and date of when the general instructed his trustee to pay for his home renovations?
September 30th.
And that's also the same date that the invoice was due, right?
That is what the invoice said was due, yes.
Okay, and can we agree that September 30th, 2020 is before October 1, 2020?
Yes, sir.
Now, when we talked previously, I failed to ask you something that's real important. First, did these folks, how many times did you interview with these folks over there to the right?
I've spoken with them 3 times in preparation for this.
Okay, and the only reason you spoke to me is because you felt it would be fair to let me have a chance to talk to you as well after you talked to them.
Anytime they reached out, I reciprocated and extended the same offer.
Okay. Did they ever show you any of the documents I showed you today?
Not to my recollection, no.
They didn't show you the bank wire showing that General Paxton and Angela Paxton paid for their renovations?
Not to my recollection.
They didn't show you the text message to the trustee instructing the payment?
Not to my recollection.
They didn't show you the document showing that the wire was actually received by the contractor?
Not to my recollection.
You ever wonder why they didn't do that?
Objection, Your Honor. Question calls for speculation.
Sustained.
There was a suggestion that you delivered some kind of document to Nate Paul. Remember that suggestion?
Yes.
You said it was a manila envelope?
Yes.
You had told us that you picked up an envelope from Vassar that had a CD taped to it?
I don't recall that it was taped.
It was inside of it?
No, sir, it was on the exterior.
On the exterior of the envelope?
Yes.
You know for sure you didn't deliver that envelope to Nate Paul, don't you?
Not that envelope, no.
Okay, let's be clear. Whatever Vassar gave you that was checked out, you didn't check anything out, did you?
No, sir, there were signatures on the document, but I don't recall checking anything out.
Right. Vassar gave you something that you gave to the general, right?
That is correct.
And that particular document had a CD on the outside of the envelope.
That is correct.
And that certainly was not the envelope delivered to Nate Paul, was it?
Objection. Question calls for speculation and lack of foundation based on Drew Wicker's previous testimony.
Sustained.
Did the document or the envelope that you delivered to Nate Paul, did it have a CD on the exterior?
It did not have a CD on the exterior.
Okay. And just so we're clear, you never met Nate Paul in the dark of night in an alleyway and delivered anything, did you?
No, sir. It was in the afternoon.
In the light of day?
Yes.
It wasn't a secret at all, was it?
No, sir.
You did hear some conversations between Nate Paul and General Paxton, didn't you?
Yes.
Let's focus on what you heard. One of the things that was discussed was whether the raid by the federal agents.
Objection. Normally I wouldn't mind, but since I tried to elicit this exact testimony and don't want to waste the senator's time with a second redirect, I must object to hearsay.
She already asked this question, Your Honor. I'm just clarifying what she asked this young man.
I did ask it, and he objected despite me being absolutely certain it would come in. And at this point, he doesn't have the same exception because KenPaxton is not his party opponent.
Sustained.
Sir, you know that the focus of the conversation was whether the raid was just. Isn't that true?
Objection. Question calls for hearsay.
Sustained.
You know that the discussion that they had was whether the FBI had followed the rules, right?
Objection. Question calls for hearsay.
Sustained.
You know that Mr. Paxton, General Paxton's discussion was whether the feds had violated the law. Isn't that right?
Objection. Question calls for hearsay.
Again, Your Honor, we've heard, he talked all about what KenPaxton has said, and I'm entitled to explore that, exactly what was said.
He successfully shut down this entire line of questioning, whether he should have or shouldn't have, and he shouldn't be given the latitude now because he does not have an exception to hearsay.
Overruled.
You know that what your boss was saying was whether Nate Paul had been unfairly targeted, right?
In the discussions that I was privy to, Nate Paul did most of the talking.
Whether he had been unjustly targeted, right?
That was the concern that he expressed.
Because you know sometimes the legal system gets politicized, don't you?
Objection, relevance.
He was asked this by the Board of Managers, Your Honor.
So, overruled.
You know that sometimes the legal system gets politicized, don't you?
Yes, sir.
And Mr. Paxton, General Paxton's concern was whether there had been a miscarriage of justice. Isn't that right?
Objection. Question calls for speculation.
He said it in his own words, Your Honor.
He can't say that in his own words, Your Honor.
Sustained.
Now, you knew that General Paxton had some distrust of DPS, didn't you?
Objection, relevance, and hearsay.
Overruled.
You knew that, didn't you?
I did.
You never heard General Paxton say he was going to do anything for Nate Paul. Isn't that true?
He never stated that he would take any action directly on his behalf, no.
Now, there was some suggestion about something that you delivered in a manila envelope, right?
Yes, sir.
Was it like this one?
Yes, sir.
Just like this?
Very, very similar, if not the same.
You don't know what was inside of it?
No, sir, I did not look.
You have no evidence to offer about what was in the envelope?
No,
Objection,
again, I
asked and
did not.
answered.
You do know, of course, that it was a couple of pages at most, right?
What I stated was that I do not recall the thickness of the document.
Was it this thick?
Again, sir, I do not recall.
You can't say that it was anything near this thick, can you?
I can't
Objection,
say
Your
that.
Honor. Inconsistent with his prior testimony, he's mischaracterizing the evidence. Mr. Wicker used his fingers to show roughly, 2 centimeters to an inch in thickness, which is consistent with what is in Tony Busby's hands.
I appreciate all the speaking objections you ask us not to do, but I'd like to finish up so we can get on down the road.
Overruled, go ahead.
Now, could it be, let me ask you, did you ever exchange texts with Nate Paul?
I don't recall any text exchanges, no.
May I approach the witness, Your Honor?
You may.
Would your text refresh your recollection?
If there are any, yes.
Now, you got a chance to look at the document without testifying what's in the document. Does that refresh your recollection?
Yes.
Okay. You had told us that that packet, not a packet, the manila envelope you delivered was sometime in the summer, maybe even the fall, right?
No, sir, the testimony that I provided was summer.
Summer, June, perhaps, right?
Yes, sir. Earlier in the day, I stated that it was likely May or June.
And that text you had that you were exchanging with Nate Paul was in June of 2020, isn't that true?
Yes.
And you exchanged texts with Nate Paul before you delivered an envelope just like this one, didn't you?
Objection, Your Honor.
I'm asking the man a question. I'm entitled to an answer.
Overruled.
You exchanged texts with him before you delivered an envelope just like this one. Isn't that true?
Objection, Your Honor. It assumes facts, not evidence. Drew Wicker has been very clear about the timeline, and Mr. Busby.
Overruled.
Didn't you?
I don't recall whether or not this text message occurred before a delivery or after.
Can we agree that you were texting Nate Paul about Dick Weekly?
That is what the text messages show, yes.
Can we agree that you delivered to Nate Paul information about an event Dick Weekly was holding because Dick Weekly was trying to get Nate Paul to donate money to Texans for lawsuit reform?
No, sir.
You don't remember that?
No, sir, I do not.
Can we agree that that text that you're holding in your hand confirms that you were texting information about Dick Weekly to Nate Paul?
It does.
Your Honor, with that, I pass the witness.
The briefest of redirects, please, Mr. President.
Get one.
You're back up.
May I proceed?
You may.
Is the conversation you had with Dick Weekly, if it existed at all, something that would have to be delivered by hand to Nate Paul?
No.
What was it? What was the construct of the conversation?
The conversation that I'd had with Dick Weekly was with General Paxton on his Dick Weekly's back porch, in which we were engaging in a fundraising conversation. I do not recall Nate Paul having been mentioned, and if it was any information tied to TLR, I don't see why that couldn't have been sent via email, if that's the question.
So completely made up in regards to this, to your knowledge?
Objection leading, and also, Your Honor, I'm just curious, if we're going to keep questioning the witness, you're going to get extra turns like this?
You'll get one more cross and then we're done, because this is the first time we've gone to 2 redirects and you'll have a chance to recross. But I thought the lateness of the trial would allow it. I think you smiled knowing I'm sustaining his objection.
I did. Thank you, Mr. President. Do you have any reason to think that this story Mr. Busby has told you has anything to do with that manila envelope?
Objection leading.
Do you?
Sustained. Try another way.
Thank you. Did you ever need to deliver an invitation from David Weekly to Nate Paul?
Not to my knowledge.
Pass.
I mean, yes, sir. The truth is you don't know what you delivered, do you?
That is correct.
Pass the witness, Your Honor.
Are both of you, can we dismiss the witness? Excuse the witness, rather?
I think must have yes.
Subject to recall. Okay. You're excused, subject to recall. Thank you. Mr. Harden, who should we have the bailiff bring in?
I'm sorry?
Which witness are you calling?
Mr. Blake Brickman, please, Your Honor.
Bailiff will bring in Mr. Blake Brickman.
Mr. Busby, are these your documents up here? Is any of this yours?
Mr. Harden, as we move forward, we're going to break around 3:30 for a short break, just for planning purposes. Raise your right hand. I do solemnly swear or affirm that the evidence I give upon this hearing by the Senate of Texas of impeachment charges against Warren Kenneth Paxton Jr. shall be the truth, the whole truth, nothing but the truth, so help me God. Please be seated. Speak close to the mic and speak up. Mr. Harden, you're on the clock.
Thank you. State your name, full name, please.
James Blake Brickman, but I go by Blake.
How are you presently employed?
I work here in Austin at a venture capital firm.
I'm going to move pretty fast with you here, but I don't want you...
You need to move closer to the mic.
Yeah, you need to come through. I'm going to move pretty fast here with you, but I don't want you to speak fast. I'm just explaining to you, I'll they'll come kind of hot and heavy, okay? Would you give me an idea of where you grew up, your college, and your jobs before you got to the AG's office?
I grew up in Dallas, Texas. I went to Vanderbilt University, and I went to the University of Kentucky College of Law.
And when you finished, and during the time that you were going to school, did you go to law school at night school?
Yes, sir. I was the chief of staff for United States Senator Jim Bunning in Washington, D.C., and I went to night law school during that time.
And then did you work for another politician before you came back to Texas?
Yes, I was Governor Matt Bevin from Kentucky's chief of staff from 2015 to 2019.
My memory is that Governor Bevin was considered a pretty conservative governor, was he not?
He was probably the most conservative governor in the country.
Is that the history of your public employment?
It is.
All right.
Senator Jim Bunning was also known as the most conservative senator at the time. Rand Paul took his seat when he retired.
All right. Now, when you came back to Dallas, what year did you come back, and how did you end up at the AG's office?
I came back in the end of 2019. I interviewed for a position as Deputy Attorney General with Jeff Mateer and Attorney General KenPaxton in December of 2019 when they personally recruited me to come back to Texas.
And did General Paxton himself interview you and ask you to come back and come?
He did. I met with General Paxton in early 2019 in Austin. And then after Christmas in 2019, he offered me the job when we had lunch at Campese's in Dallas together.
I have Attorney General Exhibit 170.
I move this closer.
I think it should be either right after or right before that, Stacy. I didn't have the page number. Thank you. Would you read that, please, out loud?
This is a message from General KenPaxton to me. And
Dated what date?
January 11th, 2020.
Is this right before you started, or had you actually started?
This was 2 weeks before I started, so.
Go ahead.
I got a text from both Tommy and Doug Deason, both singing your praises. I think highly of both those guys, so you keep good company. I'm looking forward to your coming to work with us. You're going to fit in great and be a tremendous asset to our team.
And that is that, with that kind of endorsement, is that the way you began working for for Attorney General Paxton?
It is. Tommy Hicks is who he's referring to, who at the time was the co-chairman of the RNC and a very close friend of Donald Trump Jr. Doug Deason is a conservative philanthropist in Dallas who is well known in the Republican Party.
All right. Now, when you began, what was your position?
I was in charge of policy and strategic initiatives, but because I had not waived into the Texas bar, my title initially was not Deputy Attorney General because I did not waive in until about June of 2020.
All right. When was the first time that you heard the name Nate Paul?
Sometime in either late March of 2020 or early April 2020.
And without going into what was said, did you have a conversation with the young man that was called the Body Man?
I had a conversation with Drew Wicker. Drew Wicker came to me.
And where was Drew Wicker's position in relation to you?
Drew Wicker reported directly to me.
All right. And was Mr. Wicker concerned?
He was very concerned.
And did he report to you his basis of his concern?
He did.
And what did you tell him?
Objection, hearsay.
That's fine. We'll just move right along. Did you give him some advice? Just yes or no?
Yes.
All right. And later, did he inform you that he had followed through on that advice?
Yes.
Objection, Your Honor, hearsay.
All right. Did you become aware ultimately of who it was that he was concerned about?
Attorney General Paxton was meeting privately with a man named Nate Paul without his security detail present and without the meetings being on his personal calendar, on his official calendar.
And was Drew concerned about him periodically getting rid of his security detail?
Your Honor, I'm sorry, I object. We heard from Drew Wicker. This is hearsay.
Sustained.
My only question was, did he relay his concerns about that matter without telling me what they were?
Yes.
All right. Now, I want to move now to September of 2020. Over a period of time, without going into detail, had you become familiar with and heard the Nate Paul in connection with other matters on several different or multiple occasions?
Yes, sir.
Objection, leading, and hearsay.
That's not leading. I've just asked whether he did. He could have said no, or he could have said yes.
Overruled.
Thank you. Now, by the time we hit September the 29th, what was your state of mind as to what your concerns were about Mr. Paul?
I was extremely concerned about Mr. Paxton's conduct. My office was about 5 feet away from Attorney General KenPaxton's office. And what I saw over the course of those 3, 4, 5 months, the summer of 2020, I was very concerned that Mr. Paxton was breaking the law.
I want to go, if I may step away to get an exhibit, but first I want to ask you about your relationship up until the summer when you started having concerns with the Attorney General. Was there a particular occasion back in the spring in which the Attorney General sought to praise you?
Yes, sir. Attorney General Paxton and I had a very good relationship for the first few months I was in the office.
All right. May I step over here, Your Honor? May I approach a bit, witness, Your Honor? Now, would you identify the exhibit I just showed you, which is obviously a book, and what exhibit number, just for identification purposes, is it?
It's Exhibit 705.
And what is the title of the book?
The book is called Scalia Speaks, about Antonin Scalia, Justice Scalia.
And where did you get that book?
Attorney General KenPaxton gave this book to me in front of 40 or 50 of the most senior employees in the Office of Attorney General in May of 2020.
When did he give, in May, that's what I was going to ask you. Did he inscribe it?
He did.
Is the inscription in the first page?
It is.
What did he say?
Would you like me to read it?
Yes.
Blake, I am so grateful you joined our team at the Texas AG's office. You have been an amazing addition. I'm confident that you will continue to make a difference for our office and all of Texans. Blessings, KenPaxton.
Thank you. How would you characterize whether that is an accurate description of the way he talks to and about you up through the month of May of 2020?
It was accurate.
All right. Was there a particular event that you'd been involved in on behalf of somebody that led him to be giving you that book and an award?
Yes, sir.
What was it?
This was early May of 2020. And if you remember, that was at the very beginning of the COVID pandemic. And there was a situation in the DFW Metroplex where I'm from, where there was a hairdresser named Shelley Luther who was put in Dallas County Jail because she violated a stay-at-home order so she could provide for her family.
How did that involve you?
I went to Attorney General KenPaxton and said, sir, this is wrong that this is happening in this country.
And what was his reaction?
He said, well, what can we do about it?
And you said?
I said, you should speak out about this. This is wrong. Use your bully pulpit, and he did.
And as a result, what was his reaction to that?
He did several interviews. He was on Fox News talking about this. Tucker Carlson even praised him in early May of 2020. So he was very happy, and this was my idea.
And of course, there were other public officials that then also spoke up around that same time, correct?
There were many others after the fact, yes.
All right. And so as a result, what was the Attorney General, of you having suggested that to him and it turning out well, how was his attitude toward you as you entered June of 2020?
It was great. That's why he gave me the book. He had never done this before, is what he told the entire staff. He had never made an award like this ever before.
All right, now let's go to September the 29th, September 30th of 2020. You said you had become concerned. You expressed some of those concerns. What was the focus and what was giving rise to it for you personally of September 29th and 30th of 2020?
I witnessed Attorney General KenPaxton do brazen things on behalf of Nate Paul. He abused the entire office of the Attorney General of Texas to benefit Nate Paul. And it got worse and worse and worse as the year progressed.
Were you one of those who went to the FBI on September the 30th?
Yes, sir.
And are you also one of those that has been colloquially called a whistleblower?
Yes, sir.
Well, when you went to the FBI, did you go with other persons?
There were 7 of the most senior staffers at the Office of Attorney General. We went together.
Now, there seems to be some confusion in some parts of the world as to what evidence is. Did y'all take evidence with you?
We did.
And what did you take in the form of evidence to talk to the FBI?
Again, this was the 7 most senior people in the agency. We took firsthand personal knowledge of KenPaxton's illegal, immoral, and unethical conduct to federal law enforcement officers.
You took yourselves?
Yes.
And would you describe the meeting as to what y'all did?
Sure. The meeting lasted several hours. I don't remember exactly how much, but we all went around the table and shared our concerns with KenPaxton's conduct.
Is that evidence?
It is.
Did you give eyewitness accounts of what you observed?
Yes.
Would that be just like an eyewitness account of somebody seeing a robbery?
Yes.
Sometimes the victims of robbery don't have any documents on them, do they?
Correct.
All right. But at the end of that time, had each of the 7 of you provided your evidence of what you believed was inappropriate and wrongful conduct by the Attorney General?
We did.
All right. And at that time, had you seen the grand jury subpoenas that were issued?
I had seen 1 or 2, but not all of them.
All right. And then, after that meeting, were you present when it was decided to send a letter to who did y'all send letters to? Let me put it that way.
We sent a letter to Greg Simpson, who is the head of HR for OAG.
Now, it keeps being this, I thought it was dead, but not, I guess not. It keeps being this suggestion that somebody removed a letterhead from a letter that you sent. Is that true?
I don't even know what that is referring to.
All right. Did you see, was a letter sent without General Paxton's name on it?
I believe the letter we sent had the Attorney General's crest on it.
All right. What was the practice there as far as letters that you had?
I don't recall ever discussing letterhead at all with any of my colleagues when we signed the letter.
All right. Did you have letters with regular letters that were printed and available with the seal but not his name on it?
Objection leading.
Did you?
Yes.
Your Honor, can we get a...
That was sustained.
All right.
Thank you.
Rephrase.
Thank you. Tell me what kind of letterheads you had there.
I mean, there were many different types of letterhead. I don't even recall letterhead being a topic of discussion at all amongst our colleagues.
Well, did any of y'all do you have any knowledge or evidence or any belief regarding whether somebody messed with the letterhead of a letter?
None at all.
All right. If somebody's tried to keep saying it and saying it and saying it, would that be true or untrue?
Not true.
Now, after the 30th, and then on the 1st, did each of you attempt to visit with the Attorney General?
We did.
And what was his response?
That he was out of the office and would not meet with us, but that we could email him our concerns. He said that back to us in a text message.
All right. So then, after it happened, there was some public releases. Some of Mr. Mateer resigned, and so, correct?
Jeff Mateer resigned on, I believe it was Friday, October 2nd.
All right. Now, what happened?
2020.
What happened with you after these events? Did you resign?
I did not.
And what happened? What was your circumstances going forward?
I showed up for work.
And when you went to work, what were the circumstances?
Monday, October 5th was the very first time I ever met a man named Brent Webster, who Attorney General KenPaxton had hired to be the first assistant. We had a meeting previously scheduled at 9 a.m. that morning about the legislative affairs team, of which I was involved with. The very first thing that Brent Webster did in that meeting to me was he threw me out of the meeting.
All right. And then what happened next?
I went back to my office, and Brent Webster came into my office with a woman who was armed and kept threatening me to meet with him.
What did you say?
I said,
Objection, hearsay.
All right, fair enough.
Sustained.
Fair enough. So did you have a conversation with him?
I did.
And did you have a meeting with him?
I told Brent Webster that
Objection, hearsay.
That's fine if he doesn't want to know. That's
Sustained.
fine. Let me go after that conversation. How much longer did you stay employed with the Attorney General's office?
I was terminated October 20th, 2020, so that would be 15 days.
Briefly, can you describe the circumstances of the environment for you there before they ultimately terminated you?
It was an extremely hostile work environment. They had, like I mentioned earlier, Brent showed up in my office with a woman with a gun. They asked me to take my cell phone to the car. They removed me from access to Attorney General Paxton's schedule, which I oversaw. They hired apparently another scheduler without asking me. They sent a letter to the entire House of Representatives in response to a request by Jeff Leach that they did not even show me before they sent out, even though I oversaw the legislative team. I could go on.
All right. Let me ask you this. Can I have 576 and 3350? I believe they're in evidence, but I want to check before you put them up.
We don't have 576 on our paper.
Matt, I think she's getting copies.
And what was the other number?
The two numbers were 576 and 3350. And I'll represent they are the letter that Mr. Leach sent, and the second exhibit is the response from General Paxton.
Let me give them a short moment to look at them. Any objection?
Just take a look, Your Honor, just a second,
Sure,
please.
take your time.
I guess no objection, Your Honor.
Admit Exhibit 350 and 576 into evidence.
All right, can we have 576, please?
Hold on, Mr. Harden, you offered 3350. Did you mean 350? Because what we received was 350.
Well, it was 350, I think. Well, let me look and see. Can I look?
Make sure. Sure. Go ahead. So it is 350. I overheard. So admit 350 and 576 into evidence. You may continue.
You, now, can you we won't go through the whole letter, but if we can, scroll up, please. If you look at it, excuse me, this is a letter October the 9th, is it not? You were still employed? Were you still employed or not?
Yes, sir, I was still employed.
All right. And Mr. Leach, at that time, did you know what his position was in the House?
Mr. Leach was the chairman of a committee that had direct oversight over the Office of Attorney General.
Got you. And in that capacity, if we scroll up, please, actually go to the next page, I believe it is. Thank you. If you could do the top of it, again, at October the 9th. Can we go up? We should scroll up just a little bit. This last paragraph. I'll publish it with you to make sure I do it correctly. Irrespective of that decision, by way of this letter, I formally request that you provide a written report as to what specific steps are being taken by you and your newly appointed First Assistant Attorney General, Brent Webster, to ensure that the effective operations of the agency continue in full force and effect, without delay, without interference, and without interruption. I would ask that such a report be provided to all members of the legislature within 7 days. Now, in the paragraphs before, what did Mr. Leach lay out for him before he came to that final? If you could just describe it.
Mr. Leach appeared to be concerned about the state of the Office of Attorney General in light of the fact that our allegations had been public at this time.
All right. And so was this an opportunity to ask the Attorney General to respond to those allegations that had become public? Is that right?
That's right.
All right. Thank you. And now, Stacy, if I can have 350, please. Oh, that's 350. Let me have 576. Pardon me? All right. Now, if you would, look at this letter. Do you recall this letter?
I do.
And in this answer that he gives, how many pages? Scroll through it, please. Does he respond in any way specifically with Chairman Leach's request for an explanation and ideas as to what's going forward to correct it?
No, but he does lie to Representative Leach and the other members of the House.
Can you point out where it's untrue in what he said?
The very first line, he says that we made false claims. We did not make false claims.
All right. Anywhere else? Do you take issue with anything else?
On the second page, the second to last paragraph, Attorney General KenPaxton says, OAG's regular business is moving forward at full capacity. That is 100% false.
All right. You're talking about the condition of the office after y'all left.
That's correct.
All right. I want to move on, but my one question to you is, anywhere in this letter that you read, does he really address Chairman Leach's questions?
He does not.
Okay. Now, what was the occasion exactly? How were you terminated? What were the circumstances?
Brent Webster, who was the first assistant at the time, called me into his office. There was another woman there named, I believe her name was Shelley Gustafson, and he asked me if I would like to have severance or if I wanted to be terminated. And I told him, Brent, I've done nothing wrong. I'm not going to resign to take severance. So he terminated me.
All right. Now, at some time after that, did you and 3 others of the senior staff file a lawsuit?
We did.
Any attempt to settle that lawsuit? And if so, when?
There was no attempt to settle the lawsuit prior to KenPaxton's in 2022.
I want to ask you that. What date, approximately, or what month did y'all file your lawsuit?
It was sometime in mid-November of 2020, if I recall correctly. November of 2020.
All right. When you filed that lawsuit in November 20, you were about a year away from the election, were you not?
2 years.
2 years away from the election, excuse me. And during that period of time, what happened with the lawsuit?
Attorney General KenPaxton tied up our case for 2 years, making the absurd legal argument that the whistleblower law does not apply to him. He filed what's called a plea to the jurisdiction, which effectively stopped discovery in our case for over 2 years.
So, as of the election of November 22nd, had there been any discovery or ability to legally lay out the evidence or allegations in your lawsuit?
No.
Now, once the election in November of 2020 was over, or 22, excuse me, how was it that settlement conversation started? How did that get started?
Sometime in late January of 2023, so earlier this year, KenPaxton's lawyers called our lawyers and said that they would like to discuss settlement and mediation. So the idea of settlement...
Stop. It's just great. He's about to jump up. I want him to save his energy.
Thank you.
So he, at the time that they initiated settlement discussions, had there ever been any settlement discussions prior to that?
No.
Had there ever been any indication while the lawsuit was pending and the election was in the future, during that 2 years, was there ever any indication or suggestion that about a possible settlement?
Never.
Right. Do you know of any circumstances that changed and led to their reaching out to you to discuss a settlement?
KenPaxton was reelected.
Was he reelected without knowing anything, without the public being told any of the real facts and so in the discovery with depositions or so?
I would say it's even worse than that. I think KenPaxton lied to the public for 2 years about our case. So not only did we not have discovery, he did the opposite and lied to the public about our allegations.
Let me ask you, if you can, then what I want to do is to go to Exhibit 460. I want to move to introduce 469 and 470, but I first want to ask a couple of questions about it. With the original settlement that everybody's heard a good deal about, was there a proposal that you actually personally, individually held up from reaching a settlement?
I did not go to the mediation. I never.
Hold on. We're going to try to do this in a question-answer way. So, was there a suggestion of a mediation sometime in February?
Yes.
All right. And who all went to that mediation?
My other 3 co-plaintiffs went: Mark Penley, David Maxwell, and Ryan Vassar.
And out of that mediation, did the 3 of them reach a settlement?
They did.
And what was this amount that they settled for?
$3.3 million.
Why did you not go to the mediation?
Because I did not want to settle the case.
Why did you not want to settle the case?
Because I wanted to be vindicated for what happened to me and my colleagues, and I did not want to settle the case. What happened to us should never, ever happen to any other public servant in Texas.
Non-responsive at this point.
All right, let me move on. Moving on. Now, when you did you have conditions for money? Is there, how much money you wanted or anything?
No, sir.
Did you even give them a figure?
I never gave them a figure.
What happened after the mediation when 3 had settled and the Attorney General had settled? Did you see pressure or response or any attempts to pay you more money to get you to settle?
Yes, what happened is the parties came to me and said, okay, Mr. Brickman, what would it take?
Your Honor, I'm sorry to object. These are Rule 408 settlement discussions, number 1 and number 2.
Your Honor, I move to introduce Exhibits 469 and 470.
Was there any objection? I don't believe there was. Or
I need to see those.
Or we need to see those?
If these are Rule 408 settlement discussions, that would be my objection.
Do you have those exhibits in front of you?
I do.
For the record in the court, they're not in evidence yet.
I have 470 and 469.
Yes, sir. I move to introduce.
Same objection. Not only are there hearsay, but it's protected communications under Rule 408 settlement discussions.
Your Honor, there's nothing protected by these. These documents have already been public in numerous ways.
That's the trial is here in the court, not in the public. And in this court, Your Honor, these are inadmissible.
That's fine. The objection is invalid, Your Honor. These are documents that now been published.
Give me a moment.
Sure.
Give me a moment.
I know.
We looked at 408. We sustained the objection.
Pardon me, Your Honor?
I said, we looked at 408. We sustained the objection. I believe that was your objection.
That was my objection.
Rule 408.
Yes, sir. These were not, though, for the liability of the claim. I believe that's what we're speaking about as far as 408. These statements show what he himself, they offered him. If you look at
Your Honor, I'm object just to relating what the documents say and renew the objection that's already been ruled upon.
I sustained it. Move forward.
Well, did you have conditions for not agreeing?
Objection, same objection.
He has a right to tell what his objections were to settling.
Hold on. Just
here's my problem.
You're talking over each other. I can't hear, and that means they can't hear. So what was your response to his objection?
I asked him for what was his response to their offer. This is an outward offer. This is not a mediation offer. None of this has to do with mediation now. They settled in mediation, and now the lawsuit's still pending. He rejected it. They came to him with the proposal.
Your Honor, again, he's relating what he...
Hold on,
Mr. Busby, hold on.
This is the problem with the eating up the time, Your Honor. This is a really spurious objection.
I'll give him 2 minutes back here, okay? So, your objection is, Mr. Busby.
Rule 408, textbook, this is improper, not admissible.
We just used up 1.5 minutes on an objection that has no validity.
You need to restate your question.
Sure. What were you making demands on them for whether you would ever agree to consider settlement?
Same objection, Your Honor.
Don't tell me what to do. No.
Overruled.
All right. Now, the answer first would be yes or no, and then, depending on that answer, I'll ask you the next question.
Could you please ask the question again?
Sure. Did you make demands on them that would have to be fulfilled before you would ever settle?
I did.
Same objection, Your Honor. That's Rule 408.
Your Honor, this is what he said, what his conditions were. I can even ask it, what were your conditions that you demanded before you ever settled?
Your Honor, Rule 408...
Mr. Busby, we agreed with you on the
Thank you.
first 2 objections on 408, not on this one. Overruled. Go ahead.
Thank you.
Is the question, what were my conditions to settle?
Yes. What were your conditions before you would agree to settle?
I told KenPaxton in the Office of Attorney General that I would settle for 3 things.
Hold on, everybody. Let him speak, please. He's in
Sustained
charge.
on that one. Go ahead, rephrase. I sustained that objection. Rephrase it.
I wanted to know what your conditions were, not what you told them. Okay? Hold on. That's the basis of the objection. What were your conditions before you would ever agree to consider settling?
I had 3.
What were they?
KenPaxton apologize for calling us rogue employees and admit that we did what we thought was right, was the first one.
That's number 1.
The second one was the Third Court of Appeals had ruled in our favor that the whistleblower law applies, and I wanted him to agree not to move to dismiss that.
In other words, you had a winning opinion on intermediate court level, and you wanted an agreement that they wouldn't challenge that agreement, that ruling?
I did, because I wanted future Texas public servants to know that the whistleblower law applies in this state.
All right. And what was your third demand?
That Attorney General KenPaxton remove a disparaging statement where he called us rogue employees that was on the OAG website.
In response to that, instead of those conditions, where you offered more money if you wanted that instead.
Objection, Rule 408, Your Honor.
I'll sustain that objection.
Were you offered more money?
Objection, Your Honor.
Well, I was offered...
Wait a minute. He's got an objection on the table.
Objection. Sustained.
Well, ultimately, were you willing to consider yourself, your own state of mind? Were you willing to consider more money instead of those 3 objections? Those 3 objectives that you had?
I was not.
All right. And was that communicated to the other side?
It was.
Now, ultimately, does Exhibit 470 set out this ultimate settlement that was pending, that is being considered by the House? Is that actually a document that has been presented to the House of Representatives?
It is.
So is it the settlement that is actually under consideration that the House, instead of paying right away, launched an investigation of?
It is.
So is that a public document?
It is.
Again, Your Honor, in all due respect, reoffer Exhibit 470, please.
Objection to 470?
Yes, Your Honor. It's as you can see, it's a mediated agreement proposed, which falls under a privilege, as the court knows. Moreover, it's hearsay.
Your Honor, excuse me, go ahead. I'm sorry. What I was going to say is that is tacked on to the settlement that occurred with the others. It was not produced by mediation. He never attended a mediation. He never engaged in a mediation process. What they did was they just simply put the final agreement on there once he agreed not to object, and they add on those 3 conditions that he required in order to represent the whole final settlement that affected everyone.
Okay, hold on. Mr. Harden, is this a public document?
Yes. I say that, make sure I'm not overstating that.
Yeah, make sure you're not overstating that.
I'm getting, yes, it's being pulled off the internet, is it not? It's on the internet. And I would point out too, I think 482B points out that the court can admit one either way on your own if you think it affects some type of issue in the case. I can assure you that Mr. Busby will be talking about having sued and being settled on cross. That would be something that would come under that. Thank you.
Overrule the objection.
All right. Now,
The exhibits 470 and
thank you, Your Honor.
469 are in admitted evidence.
All right. Now, just to be sure the record's clear, you never participated in a mediated settlement, did you?
I did not.
All right. Now, I want you, if we scroll down and look at the bottom of this, scroll it to it. Number 2 says what?
OAG will permanently remove this press release from its website.
And that press release was what? Is that the one in which you, what was that press release?
This was the press release where Attorney General KenPaxton called me and my colleagues rogue employees.
Number 3?
Would you like me to read it?
Read it.
A recital in the settlement agreement will state, whereas Attorney General KenPaxton accepts that plaintiffs acted in a matter that they thought was right and apologizes for referring to them as, quote, rogue employees, end quote.
And then number 4, would you read that?
The parties will not ask that the Third Court of Appeals opinion issued October 21, 2021 be withdrawn.
And is that the settlement that is now still pending before the House for approval?
It is.
You can take that down. Now, I want to,
Mr. Harden, about how long do you expect to go? Mr. Harden, about how much longer do you expect to go? They've been on, jurors have been sitting for 2 hours.
I'm hoping to do about another 14 or 15 minutes.
Members, I think you can make it for another 14 minutes. Okay, I see nods from the jurors. Continue.
Thank you, Your Honor. If I can now, I want to move, there was an Attorney General report issued, was it not? That sometime in 21, setting out the Attorney General's side of what happened here?
In August of 2021, the Attorney General put out a report.
I believe Attorney General 127 is in evidence. I'm sure it is, but I just want to be certain.
It is. I put it in evidence.
All right. Now, would you identify the front page? If you read this report, can you just describe it for you in gentle descriptive language, please? Would you?
This is the report that the Office of Attorney General put out, clearing itself of wrongdoing.
All right. This was represented as some type of independent report, right?
Yes.
And then you discovered, based on public statements, it was actually prepared by Mr. Webster, the first assistant.
That's correct.
Okay. In this report, have I asked you just to take three or four examples of things that you disagree with? Have I asked you to do that?
Yes.
All right. What I wanted to ask you is, in this report, how would you describe your reaction to it as accuracy in terms of what happened in these matters involving Nate Paul?
I would call this report a whitewash full of lies.
All right.
And omissions.
Now, if I may, let's just go over to page 5 and do this real quickly. If I ask you to pick 4 or 5 samples, can you just do that for me? And would you look on page 5 and see as to the first claim? What is untrue about that claim? You see
It
where you
says,
are?
on 2 prior occasions involving Nate Paul's interests, the Open Records Division sided with the government agency against disclosing to Nate Paul. That is not true. There was an Open Records decision that took no opinion as to the release of the documents.
What about the second claim?
If you start with the sentence, most relevant here.
Your Honor, I'm sorry to interrupt this witness. This witness was not involved in the Open Records decision. He was not involved in the MIDI intervention, at least certainly not directly involved. And for him to go through and, without taking away counsel's time, and go line by line a report about things that he wasn't involved in, that would not be proper. So maybe with respect to the second claim, maybe he has some personal knowledge, but everything else, he has none.
That may be one of the more imaginative objections I've heard throughout this entire trial. What I would point out is, if I want to go through, he did have contact with the MIDI. Well, I just went by it because they've heard a million things about the MIDI kit. But all he's being asked is, are they true or untrue? He's got that wonderful art of screaming cross-examination. He can use every bit of it he wants, okay? But this issue here is simply, does he believe that is an untrue statement? He can challenge him as to what his basis is on cross.
Overruled.
Thank you. On this number 2 here, where it says A.G. Paxton's involvement is consistent with his predecessors and in line with his required duties and legal obligations as Attorney General of Texas. Most relevant here, the position taken by the AG in this litigation was adverse to Nate Paul and in support of a higher settlement amount to be paid by Nate Paul to the MIDI Foundation, as opposed to the prospect of continued and costly litigation that would disproportionately benefit the charity's court-appointed receiver and his lawyer. Is that a truthful statement?
It is not a truthful statement.
And had you actually had an occasion to be asked, Attorney General, to review the MIDI file at one time? All right. The third claim. This informal guidance letter regarding foreclosure sales written by Bangert was made in response to requests for disaster counsel advice from Texas Senator Brian Hughes during the height of the pandemic and not for the benefit of Nate Paul. Is that a true or untrue statement?
Objection, personal knowledge, Your Honor.
Object. I mean overruled, I'm sorry.
Thank you. Is that a true or untrue statement?
It is an untrue statement. The foreclosure opinion was for Nate Paul's benefit.
And in fact, the foreclosure opinion that said that foreclosures could not be conducted at that time because of the limit on people in the COVID situation, was that actually even totally inconsistent with what the Attorney General had just done recently?
It was this opinion was entirely inconsistent from prior opinions that our office put out. This was a time, sorry.
Are you familiar with a particular event some weeks right before the opinion of August 1st or 2nd concerning foreclosures?
1 month before this opinion came out, Attorney General KenPaxton held a fundraiser in Dallas outdoors, and a month later issued an opinion saying that foreclosure sales could not continue outdoors.
Can we go to page 6, please? Look at the top. Kamak legally and properly exercised authority delegated to him by both A.G. Paxton and the TCDAO. Kamak was designated as outside counsel for OAG by A.G. Paxton, and he was also knowingly appointed as a special prosecutor by the Travis County DA's office. Is that a true or untrue statement?
It is false.
All right. Would you tell the jury whether these that you've labeled untrue statements that we've just gone through for just a couple of minutes, whether they are typical of this report or unique to this report?
I'm not sure I understand the question.
Are there other misstatements in this report?
There are many other misstatements in the report. These are just a few samples of the misstatements in this report.
All right. Your Honor, I've got to get a couple of things together. Can I renege and we take a break now? I will be through shortly after you return.
Yes, before we break, could both parties come up for a second?
Okay, folks, that was pretty powerful testimony, I think.
Very strong testimony. The witness was emphatic regarding a number of things, particularly the impropriety of what he was witnessing. I noted illegal, unethical, not only illegal, not only unethical, but illegal, unethical, and immoral.
I mean, you think they saved this guy for last? Because he's angry.
Yeah, you know, and you can understand why, given some of the allegations being lodged against him personally. It opens him up to some cross-examination on what his motive is and how much his personal interest might be shaping some of his testimony, but he certainly believes what it is he's saying about the impropriety he was witnessing.
Yeah, but
he's swinging for the fences. He is trying to clean up any weakness that previous witnesses who are in the lower case might have left. He is, not only said illegal, immoral, unethical, but he said he saw brazen conduct. So
yeah,
I mean, absolutely brazen, a really good word you don't hear very often. And then, it was stunning again when they said, what happened next? He said, Brent showed up with a woman with a gun. I guess a man with a gun would have been, the same difference, but, Brent showed up with some armed officer from the DA, and that, from the AG, and that shocked him. And then you get around later and he talks about the foreclosures, and he, just gets in this little dig that the Attorney General himself had an open-air fundraiser a month before. He said that it was too dangerous to have foreclosures on the courthouse steps.
A goose gander kind of situation.
Yeah, he had his own gathering. So that was just a little dig. Everything that he said has been pointed. It's been sharp. It's gone directly at KenPaxton, and it'll be very interesting to see what the cross is like.
Yeah, and he, more so than the others, he comes across as just like, I'm not going to settle. I'm not going to do this. I'm like when he's called into Brent Webster's office and told, well, you can resign and get severance or you can be fired. He pretty much is like, fire me.
Right.
I mean, this is a guy who, it feels very much like acted on principle.
Absolutely.
And I know, actually, the whole thing about the settlement, I know that to be true, about that he was the holdout. He had conditions, and that's what they were talking about. He was not going to settle, and he wanted to make sure that should other public officials do as KenPaxton did, that they were protected.
Well, he wanted that whole bizarre statement wiped out off the website. The AG had posted this long
diatribe,
right? It was so uncharacteristic of a government website that it was
right.
Just this long vociferous attack. He wanted that gone and wanted an apology for it.
Well, and this is a guy who had not worked in the AG's office very long. He was kind of brand new to that office. Mm-hmm. And he talks about, officing just down from KenPaxton. You just have to wonder, his honeymoon did not last long.
At all.
That's pretty much an understatement.
And he acted a little surprised. He said, and there was another scheduler. I was no longer the scheduler. Well, after he raised these objections, but he was a little surprised that he was treated so harshly, but he got the boot.
He did get the boot, but just like the others, they established his conservative bona fides before they, launched into the testimony.
Right.
Every single one of these guys.
Right.
Okay, and there was question about this because is Rusty using up too much time with all this show us your Scalia book and tell us what a good conservative you are, and you know, is Rusty spending too much time, you know, not softening up, but just kind of doing the cushy intro on these witnesses?
I don't know. All I know is we are 3 minutes away from when they can put Laura Olson on the stand. We've been watching the clock all day long. So what we're expecting, well, to answer your question is, I think was definitely a lot of time wasted early in this trial.
Yeah,
right.
I think there could have been a better, more expeditious use of time, because Aaron Epley got a whole lot further, a whole lot faster, and maybe you're right. Maybe these senators needed a softer touch, but you know, you want to make sure that you have enough time to get through the key pieces of evidence, and it looks like we're going to get there, but it's going to be like, you know, like landing this plane, you know, kind of nose down, and you know, and then you run it where you might, I mean, we could see a situation where the defense puts up witnesses and there's no time to cross defense witnesses.
Mm-hmm.
That could happen.
That could happen. There's a very real scenario.
I think that is likely to happen.
You know, there was a time when, I mean, Texas is the West for sure, but in state court in particular, but when Rusty Hardin was coming up, it was the wild, wild West in terms of no clock management and judges giving you clear latitude to make your points for ungodly amounts of time, particularly in Harris County. But the new age of judges are really keen on putting lawyers on the clock. And you got to think whether Rusty is trying to hold back or hold on to how the practice used to be versus the way it is now, which is more of the speed and pace that we saw from Aaron.
Right.
You get to the Supreme Court, you have what, 12 minutes or something?
That's right. Well, you know, appellate advocacy and appellate litigation has always been a clock-based litigation in the oral advocacy context, but in the Texas state courtroom, particularly in Harris County in days past or years past, judges basically let you get after it.
I thought it was interesting. I saw on the camera the reaction of some of the senators, and I saw Senator Paul Bettencourt, who was firmly in Paxton's vote, you know, during the motions early on. He crossed his arms and, you know, rocked back in his chair. He was, you know, clearly uncomfortable with this testimony. And I wonder, we didn't get to see Drew Springer from Munster, but I would have loved to have seen Senator Springer when the name of his former opponent, Shelley Luther, came up. You know, Shelley Luther, the hair salon owner in Dallas, who battled against the order to close her hair salon and went on and rode that to national fame and eventual place on the eventual political career running for the state Senate. That Senator Springer, you know, defeated her, although it was a very expensive campaign.
Yeah, well, I didn't know that, because I guess I don't follow politics enough, but sorry, but I'm going to do better at following all the elections. But yeah, you know,
hairdressers in politics is a very
I do
important
remember
topic.
the Shelley Luther case. I just didn't remember that she had run against Drew Springer. So what do you think they're doing on this break, Victor? You know,
Well, this is typical of
they were talking about planning, so
in a protracted proceeding. When you're going all day, you typically have a mid-afternoon break. So I think everybody's probably just relaxing and stretching, particularly because we obviously are going to go past 5 p.m. today. So
I think they're doing the same thing we're doing. They're getting a cup of coffee and kind of settling in,
right,
and getting ready for the hurricane to hit.
yeah. Well, I'm waiting for right now. They're going to take me live on TV here in, I don't know, 10, probably 10 minutes, and so I've got my earpiece in, listening for them to talk to me about that. But we're of course continuing to chat, so it's just kind of extreme multitasking going on here. It's kind of weird to have one thing going on in your ear and then you're talking about something else. My just testing my ability to pay attention to two things at once.
Well, it's showing your talent.
Exactly. What does Busby need to do on cross with this guy?
Wow. So I think if I were Busby and knowing Busby's style, he's probably going to light into him to really show how motivated this man is to personally shape or skew his testimony to be particularly, he's going to try to show bias.
Well, he's going to try to rattle him.
He's going to try to rattle him, but he's going to go after him. He's going to go after him pretty aggressively to show the jury that this is a guy who you have to view his testimony through the lens of somebody who has an axe to grind. While at the same time saying these are his personal opinions, but they don't go to the issue of delinquency or maladministration.
Well, and I mean, Blake Brickman probably would say he's got a reason to have an axe to grind.
Yeah, certainly.
You know, and all of these guys had an axe to grind, but they would say we have an axe to grind because we were wronged.
Right.
Right.
Right. Right.
You know.
And the rejoinder by Busby will be, that's your opinion.
Right.
You don't know.
No.
Yes, he'll say you don't know. You didn't know. You know, you don't have any knowledge, isn't that right? You don't know. That's Busby's constant. He will, but he'll go back to and he'll produce some documents of how much Brickman loved Paxton and how much they're trying to, reflect, to make all of the whistleblowers and everybody involved look like these turncoats that undermined the boss, and so they're trying to show that Brickman was involved in this office mutiny, and so he'll go back and show how loyal he was and that he turned on him, and he'll make him look like that he led a mutiny.
Do you think he'll succeed?
Well, it depends to some extent on how aggressive he is and how aggressive Brickman is in response. I think Brickman, as edgy as he was on testimony, needs to be calm and cross and not try to go mano a mano with Busby.
Right, right. Because the more personal interest he shows, the less the more it diminishes his credibility.
Well, and yeah, I kind of feel like with this guy, you run the risk that he might reveal some more things that you don't necessarily want out. I mean, this guy strikes me as, this is not Mateer.
Right.
This is not Vassar. This guy is, he seems a little bit more like a political operative, than some of the prior ones we've had.
See, and that's the issue that I'm talking about regarding credibility. If what Busby is going to want to do is to have a very aggressive cross to show the jury that he's not a Drew Wick, for instance. This is a political operator, and you should view his testimony as such.
Well, the first thing he's going to do is say, tell us exactly what brazen, immoral, unethical conduct you have personal knowledge of. What do you know about it? What was brazen? What was immoral? What was it? Where did you see that? Did you see that? Do you know about that? How did you know about that?
But that might be a dangerous question to ask.
Well, I mean, he would repeat something that he's already said. He's already listed it all. But Busby's going to say, do you have any personal knowledge of this? Or did you just hear it? Did you just, hear it third hand?
Right.
Well, he was also, what did he say, 5 feet away? Mm-hmm. His office was 5 feet away from KenPaxton. Yeah. So he had a bird's eye view during this really critical period of what was going on.
Right. Well, plus you get into adding immoral in that set of immoral, unethical conduct, illegal, immoral, unethical conduct. Well, we're not here about immoral conduct. And so you make him sound like a moralizing employee who's got so upset over an affair that he started compiling a list of all these other things that were wrong.
And
so you remind everybody, morality is not in question.
And that's Busby's argument. That's going to be his argument, or whoever does the closing argument. This is not about morality or immorality.
Hold on a second. I'm going to talk to the producer. Yes, I can hear you. I can hear them in my ear. I got you. Okay. All right. So just, I'm talking to the producer, guys. Just let me know when give me kind of like cues on how far out we are. Okay, great. Thank you. So, sorry. How long do you think they keep him on the stand? Because, I mean, we're going to want to get to Laura Olson here pretty soon.
Absolutely. I would think that there should not be too much redirect, if any, of this witness. They've served their purpose, which is to fill some time with the witness who had some punch to him, to get them to the time that they can call the big witness for the day.
And how long do you think Laura's testimony goes? I mean, how long do they keep her on the stand? We don't really have any idea, I guess.
Well, the one thing that you pointed out that they have to be mindful of is if the defense decides to put on some witnesses, they want to save some time so that they have the opportunity to cross-examine witnesses.
And I'm going to add that if you are really trying to put on a show for the public, then you don't want Laura on the stand during a news blow.
Okay,
That's true.
Sorry, guys. I'm on our live feed. I'm listening to the show right now. There are 15 seconds for me. Okay. It absolutely is, because the issue here is this woman's name is Laura Olson, and she ultimately was employed by Nate Paul. Nate Paul is this friend and campaign donor who is at the center of these allegations that KenPaxton took favors and house renovations, and that KenPaxton did things on behalf of Nate Paul. And then also with Laura Olson, what I believe they're going to ask her is how she came to be employed by Nate Paul. Who suggested that? How did that happen? They're going to also want to, I think, ask her about. There's been allegations that KenPaxton kind of disregarded his security detail and in terms of how this affair got started. So there's going to be a lot of things that I think are going to come out, and they're going to have a lot of questions for her. And it's really going to revolve around this issue of how they're going to allege that he abused his office in order to have this affair with her. That's right. It tense, doesn't it? I don't even think begins to cover it. And part of what happened today was, first thing this morning, the House impeachment managers, they called Laura Olson. They said, we called Laura Olson to the stand. And then all of a sudden we saw lawyers gathered around the dais. And then it was announced that, no, we can't bring her to the stand yet because they had put her name on the witness list late in the day. So they had to wait until 3. The earliest that they could call her was 3:53. And of course, we're past 3:53, and so right now they're on a break. They've got another witness on the stand, but based on what we've seen, as soon as that witness is done, I believe Laura Olson will be taking the stand. Okay, guys. All right.
Double duty there.
That is double duty. Let me tell you.
Move back over
trying to.
My shoulder was in the picture, so I moved.
Your
over
shoulder.
a little bit.
Well, we're just kind of making it all work, guys. Yeah. So, I mean, I think her testimony is going to be explosive. I really do. I think I think she's going to be the last witness for the prosecution. Why would you put anybody else up after that?
I agree.
I think she is the one. Do you think they always plan to make her the last? Would we have seen these other witnesses but for what happened today?
That's a good question. It's a good question.
I mean, I think they would have called Wicker.
I think so.
I think Wicker would have gotten called.
Well, they wanted to start the day with her, so that indicates the tone that they wanted to set. So they've had to turn the day inside out.
Yeah, I mean, exactly. So they went with Wicker. And then, of course, now, and Wicker was a great witness. I mean, Wicker was, they started the day strong yesterday with Brandon Kamek, and then, of course, by late in the day, it became kind of a slog. But we really haven't had a lot of slog today. Today's been all pretty good.
Yeah, Drew Wicker from Prosper, was an excellent witness, and his conservative credentials were as good as anyone's, but also he sounded very calm, didn't sound like he had an axe to grind. He was a really calm, tempered witness, and he seemed like somebody who was really fair-minded.
No, he did. He seemed like he genuinely still liked KenPaxton.
Right.
Like that he was it's almost like you're disappointed in your father. That's how it felt to me.
Yet it was clear that he was very measured and circumspect in his testimony, and if you juxtapose his demeanor with the present witness's demeanor, you can see what I mean by how believability can be diminished by the amount of vitriol that you have that comes out in your testimony, because people start to think, how much is your personal dislike coming into and factoring into the testimony that you're giving. I thought Drew Wicker was a credible witness because it was clear that he's close to the Paxtons, but he was honestly answering questions and trying to be careful on both direct and cross-examination.
Which is why the whole thing, I think, about when this invoice is issued and when it is paid was pretty effective.
Right.
Right. In my opinion. I mean, but it's also the danger with Brickman, right?
It's true.
Because Brickman is angry.
Right.
And you can feel his anger.
You can feel it.
I mean, kind of righteous indignation, more so than we've seen with any. I don't know that I felt anger so much from any of the others. Did you? I mean,
no, the others were somewhat.
They were more paper pushery.
Except
for Maxwell.
They were portrayed as bureaucrats, and I think that was pretty well the way they came off. I think Brickman, on the other hand, seemed like he wanted to jump up out of the chair
and throttle somebody.
Yeah.
Right.
He seemed like he wanted to take some action. But even Wicker's great testimony. I mean, he was shocked when he saw Paxton coming out of the hotel elevator with another woman. And here we get back again to this question of, were you all so upset at morality that you started raising, that you started getting upset about everything else? Was it really the moralizing that led you to file all these other charges and put together all these other complaints? And are you taking issue just because someone had an affair?
Yeah. So a little bit of background on Blake Brickman. He was the former chief of staff to the governor of Kentucky, Republican governor of Kentucky, chief of staff to a United States senator. He law clerk to a federal judge, and he's also an advisor to an institute called the Cicero Institute. I've never heard of that, but it looks like it's probably a conservative-leaning group. I mean, just based on kind of where he is. So I mean, and actually a number of these whistleblowers are connected to conservative, think tanky kinds of things.
Consultants, lawyers, particularly the whistleblower. Let's see.
I think it wasn't
Bangert, who's with Alliance Defending Freedom.
And Mateer is with Liberty Legal, I think.
Liberty Legal here in Plano.
With Brickman, Victor, if you were going to cross-examine Brickman, what would you do?
I would really get after him, and
would you yell?
I might.
I mean, you don't strike me as a yeller, but
I might pound the table, and I might really try to yank his chain a little bit so I can bring that anger out even more. Because again, my view is if you listen to a witness who is particularly angry, you have to at some point start thinking how much is the anger misshaping or fusing into what should be truthful testimony, such that the testimony really is being shaped by the anger as opposed to a accurate memory.
And so would you, with a guy like that, so you want to elicit You want to get him spun
You want
up.
to get him spun up. You want to get him even more spun up than he is right now.
You want to get, I can't resist. You want to get the A Few Good Men moment. You want me on
Absolutely,
that wall. You need me on that
absolutely,
wall. Like, sorry,
absolutely.
for the younger folks, they may not know what that movie is, but that's one of my favorite movies of all time. You
can't
can't handle the truth.
That's right. That's right.
But, I kind of feel like, he's the kind of guy that you might want to spin up like that.
Right. Right. I mean, there's a region of the brain called the limbic system, and then the amygdala. If you get people out of their cortex, they make mistakes and errors, and that's what you're going to want to do with this witness.
I am really outmatched with Victor here. Victor seems to know a whole lot about everything. And, all I can do is
y'all
make
know
sports
more than I do. So.
No, you know a whole lot more about politics than most people, but the understanding how the mind works and how the brain works and how people's psychology works is important to what we do in the courtroom.
But I think that's one of the reasons why we took this approach with this live stream and having a legal expert and a political expert was because we realized, because initially I've done other trials like this. I did the Amber Geiger trial. She was accused of, or she was convicted of killing both of Jean back in, years are all running together for me now, like 4 or 5 years ago. And then of course I did the Aaron Dean trial. And so, and those were traditional criminal trials, right? And so we didn't have a political expert, but with this we realized we've got to have the Bud Kennedys and the Bernadines and the Katie Sherrotts, people like that understand politics, because that's not, I don't cover politics, not in a direct way. Usually when I cover a politician, they've gotten arrested.
That's right.
I mean, that's just the reality. They've gotten in trouble, they've gotten indicted, something bad's happening, or something bad's going to happen to them.
On television, this looks like a trial, but if you turn to the camera the other way, it looks like a political event. There are 31 senators sitting out there listening. I think 6 or 8 of them will be on the ballot in the primary in March. They're immediately facing an opponent, potential opponent, if they don't vote the way their districts want. They have to run for election. They'll get their check from the voters right away. They'll get their status check of whether they voted the right way or the wrong way. The rest of them are up in 2 and 3 years. But so it's very much about the election. It's very much about 2024, and for the senators, it's about getting reelected. It's about maintaining the favor of the lieutenant governor, who they need in order to pass their bills, and it's also about maintaining the favor of the governor, who needs to sign their bills. So.
And the governor has been very quiet.
The governor has been posting and tweeting about what a great conservative state Texas is, and then we'll hear from him about school vouchers later on. But he's just stayed out of all this, and intentionally so. But although some members of his campaign have clearly been arguing, at least echoing some of what the House prosecutors said.
Right, and it in a normal criminal trial, so we have this whole situation where tomorrow morning the jurors are going to vote on this motion this motion for reconsideration on whether or not to combine the votes for removal and the vote to ban. Have you ever, Victor, in your entire life heard of jurors voting on anything? I mean, that shows you just how different this is.
Absolutely not. So is the most I've seen out of a jury doing anything than receiving evidence is, we do have courts that do this in Texas. It's more frequent and common outside of Texas. We'll have jurors pose questions, typically writing them out and handing them to the judge to have those questions answered. But yeah, this is totally like anathema. We would not see this in a courtroom, to have the jurors ruling on motions.
And to reset, if people missed that was just a moment this morning, but the prosecutors moved to have the jury vote, and it would be only a majority vote on whether to consolidate the scheduled 2 votes as one. They originally, in their rules of the trial, had planned to have 2 votes, one on whether to remove him from office, this is a removal trial, and the second on whether to bar him from running for future office. The prosecution moved to consolidate the 2 votes into one. They can't vote on that until tomorrow. They'll have a decision by a majority vote on whether to cast something that has to be decided by a 2/3 vote. So we could conceivably see the House, see the Senate voting by majority to combine the votes, but maybe not make the 2/3 for removal.
Well, and again, you could have some senators that just don't want to telegraph how they're going to vote.
Right.
Right? I mean, because if you vote to combine, you're telegraphing what you're going to do.
Well, plus that also
Potentially.
that also takes a little bit of the protection away from the senators. You know, if you went to the voters and say, yes, I thought we should remove him, but I'm going to give the voters the decision on whether to ever let him run for office again. That it gives the senators a little bit of an apology tool to go back to the voters. This would take that away. I do think that they'll probably vote for it in a majority just to get this done, so they don't have to stand up one by one twice and cast their votes on essentially the same question. And you know, this is something interesting to point up. I've seen the questions about it today. If they do remove him and ban him from future office, that only applies to state and local office. That only applies to the offices created in the state of Texas. He could run for congressman, any congressional seat in the country,
Right.
because you don't have to be a resident to run for
Well,
Congress.
and Ted Cruz is coming back up for.
He could run for Senate.
Right,
He
is
wouldn't
it?
run
No,
against
it's Cornyn.
Ted Cruz.
Cornyn.
So he could run for John Cornyn's seat. He could run for, but I mean, the main thing, he could run against any congressman that crossed him or congresswoman. So it would not preclude him from running for office.
Yeah, and it's just going to be so fascinating. But we're going to know how each juror voted, which is also unusual. I mean, well, of course,
Absolutely.
they sometimes will poll the jury, but in a normal trial, the jurors just you wouldn't see them publicly. It's just
Standing
it's
up like at an elementary school, 31 each
Right.
standing up, holding up their hand,
right.
you know, and named at random and standing up and saying yay or nay.
It's kind of like again, it's sort of a quasi-criminal trial that we've got going on here, but it doesn't have. But obviously, we're not trying to prove criminality necessarily. You don't have to prove criminality. You can prove what was it?
Sustain the articles of impeachment is
Right.
what they're voting on, whether
Right.
to
But
sustain
it's
the article.
what was it? What was that term again?
Delinquencies or maladministration were
Right.
the words from the Texas Supreme Court.
Yeah. So it's not. They don't have to prove that KenPaxton committed a crime.
No, any criminal prosecution could be handled later by any agency that chose to see, any criminal investigation. Certainly there are some, investigations already underway, but this is not about investigating crime at all.
In your mind, Victor, do you think they end? Do they end with Laura? I mean, is she it?
I would. I think that's what's going to happen.
And do you rest if you're the defense after that?
It depends on what happens with the testimony of Olson and how that goes. I would think that a prudent defense attorney would say, you know what, I don't have the burden here, so let me, less is more. But who knows what's going to happen with the testimony and what they might have to do through one or two witnesses in light of what Olson says.
Yeah, that's hard to say. I could see if they've got 3 or 4 hours left, I could see them taking advantage of the fact that the House impeachment managers can't ask questions.
Yeah, that's right.
I mean, that feels like a real like something they would do. How effective did you think them walking Brickman through all the things that he thought was untrue in that AG's report? How effective did y'all think that was?
I thought that was pretty effective.
The AG's report hasn't been talked about much, and that was really one of the abuses of the Attorney General's power, was to write this long, outrageous personal defense and post it on a state website. It's not even cited specifically in any of the articles of impeachment, but it's not the kind of thing you would normally see a government post with public resources. I mean, these were, publicly state attorneys and a public website and a public resource that's appeared to be used for a personal purpose. That's blatantly illegal.
He also talked about how, because one of the contentions that KenPaxton has made is that, well, the voters voted. They knew about all this stuff about me, and they still elected me again as their attorney general. And what Brickman was testifying about was that because they made this, because Paxton's legal team filed tried to get it tossed based on this idea that that the Whistleblower Act didn't apply to public officials, elected public officials. And he basically said, look, they tied up our case for 2 years. And he said, he called it the absurd argument that the Whistleblower Act does not apply to him, meaning KenPaxton, and that stopped discovery. So he's like, look, the public couldn't have known about all of it because discovery got stopped. That felt like it landed to me.
That's right. Yeah.
I hope the senators knew that already, but they may not have.
You cannot assume they know all this stuff.
No.
That's right.
It feels like, because you'd like to think that they were paying attention to all of it, right? But not necessarily.
You never know.
Yeah, if it wasn't on Fox News, they may not have known.
Exactly. Well, and it doesn't feel like this would be the kind of these allegations would have been the kind of thing that would just get a whole lot of attention.
I don't think Tucker Carlson spent a lot of time on this.
No, not yeah. Anyway.
What do you think? We've been speculating about the schedule on this, and you were talking about the vote because we think there might be a vote maybe tomorrow. Do we still think that the defense comes back with witnesses tomorrow morning, and then do we get witnesses, closing statements, and a vote all in one day, or do we spill over into Friday?
I think we go into Friday. I just think we go into Friday because Busby and the defense team strikes me as people who will take advantage of if they've got a few hours on the clock.
Using every minute.
Using their clock.
Right, and so if we can stick a couple of witnesses up there, basically unopposed, but does Patrick give some time for a little bit of cross? That feels really, unfair if he doesn't.
No, that's been said previously that it might seem unfair, but not necessarily when everybody up front knew what the play-in rules were, including the rules regarding time. It's the ultimate in fairness to stick to what you said and not to give anybody any extra time because you said these are the rules.
Except for a lot of time got eat with objections.
Right, but somebody might say the football game is on the line and the other team has the ball with 10 seconds left and they scored with 1 second left. It might seem fair to give the other side some extra time, but everybody knows going into a football game what the time constraints are and how you have to manage the game. And time is time.
Patrick might say, I think he already did this once during the trial, he might give them both a little extra time, which means if the prosecution wants a little extra time, then that also means a little more Tony Busby time.
Yeah, could be. Yeah, I don't know. But I also think that if I could see the travel calendars for these senators, I'm betting money.
Busby's got this vast deep state conspiracy that he's got to lay out, and he's got to have a little time to do that.
Yeah, well, and he, he might want to go. Maybe he puts George P. Bush up. Because he's made a big deal out of the fact that George P. Bush renewed his law license. But you don't have to be a lawyer. You don't have to be I didn't realize that.
He didn't have a license when he ran.
Right. I didn't actually know that you didn't have to be a licensed attorney in the state of Texas to be the AG.
No, we take walk-ins. It's just like Justice of the Peace. We take walk-ins for the job.
That feels kind of stunning to me. Did you know that, Victor? I did not know that until last week when Bud told me.
Yeah, I didn't know that either.
Is what you get for assuming things. Hey guys, I'm gonna watch the okay. Somebody asked, is prosecution allowed to object in court now? Well, yeah, they can object. Mm-hmm. I'm looking at the questions here. If you guys have any questions, we'll try to answer
as long as they have time. Oh, they can object, yeah.
And I assume the question I'm reading into the question, can the prosecution object? In the defense's case,
if the prosecution is out of time and under the rules
Oh,
that
that's a
we've
good question.
established,
Yeah.
I think the answer is yes,
Yeah.
because that's going against the defense's clock.
Right.
Right. So yes, I think they will be able to object, but if they've run out of time, they wouldn't be able to, they wouldn't be able to do cross.
But here's a strategic lawyer, a chess player, would make objections, but they would make the objections speaking objections. So they might not get cross per se, but through their speaking objections, they could kind of make their cross points throughout the direct examination.
Kind of sprinkle it in, yeah.
Right? So that
They
by
might
the
get creative.
time the defense witness is done, defense witness A, for instance, there might not be any cross-examination, but given the speaking objections we've seen from both sides here, the senators will clearly know what the prosecution's angle is on the witness.
So John Maybe says, the other point I would have made about the report is why wasn't Kamek paid if his hiring was legitimate?
That's a good question.
I mean, I think the fact that Kamek doesn't get paid is really problematic.
I think the only person that you can ask why he wasn't paid is the Attorney General, who is not here to answer that question. And I noticed somebody posted a picture of a car in Austin driving around with a sign, "Where's Ken?" You know, I think we have started to wonder that.
Somebody asked, how much time does each side have remaining? I don't actually know that. We know that as of this morning, it was about 5 hours for the prosecution. It was about 9 hours for the defense. But there's been so many sidebars and so many breaks that I wouldn't even hesitate a guess to try to figure out a couple hours.
It always seems to be more time than we thought.
It does seem to be more time. I feel like that Dan Patrick is being liberal with the time clock, which is not a word you would normally associate with Dan Patrick. But I think that's what's happening, because it feels like maybe they're adding time back in or something here and there, because I thought there was a lot less time than there was at various points.
We're building up the suspense for the appearance of Laura Olson, but there's still another witness on the stand for cross-examination. Right?
Mr. Brickman, yeah. Well, because we want to hear Laura Olson.
Right.
Richard Dunks asks, what's the potential legal and professional scrutiny for Michael Wynn in all of this? Michael Wynn was the attorney for Nate Paul. He's all up in the middle of this. He's the one that was providing this list of who should be subpoenaed to Brandon Kamek. And among those people that were to be subpoenaed were Ray Chester, who was an attorney for the Mitty Foundation, and others connected to Nate Paul's business stuff, as well as federal officials and this, that, and the other. Victor, I'm going to ask you that because you're the lawyer on the panel.
Well, it's a good question. As I assess it on its face and think about it, logically, Michael Wynn has a client to represent, and it might be argued that a zealous advocate, which our ethical rules require zealous advocacy on behalf of our clients, was doing exactly what he was supposed to do for his client. There's a difference between what Michael Wynn's responsibilities are, what Kamek's responsibilities are, and what the AG's responsibilities are. And if Michael Wynn is advocating for his client in a way that happens to help his client, it might be argued that what he did was entirely proper.
Somebody's asking if they're back in session right now. No, they are not back in session. You remember, Bud, you know what time they went out? Was it about 3:50?
You know, I think, you know, we said it was right about 3:50. It was right about the magic hour that they took a break. But now, you know, Dan, when they took a break, Dan said they had something to work out. So.
Well, he said they needed to work on planning things.
Yeah.
So Jonathan Yu asks, are extramarital affairs impeachable offenses? Bud?
Well, under the definition, anything is an impeachable offense. There is no definition in Texas of an impeachable offense. In the federal government, you know, you have high crimes and misdemeanors and all that, but in Texas, you know, it's wide open. The Supreme Court ruling defined the purpose of impeachment as delinquencies or maladministration. I think that Just simply having an extramarital affair probably wouldn't fall under one of those categories, but if it somehow affected the running of the office, or then it might.
Chris Grimes asked, do you think the defense will put on any witnesses, even though they don't have to? We've talked about that. We think they will, but they also might not.
They might. I think it probably depends in part on the effectiveness or not of Olson as a witness. The conventional wisdom amongst defense attorneys is you don't have a burden of proof, and if you think the prosecution, because of that, has not met theirs, then less is more, and perhaps you don't put on any witnesses. But there is the strategic advantage that we talked about with the mismatch of time between the defense and the House managers in this instance. You might see the defense make some points in direct examination in their case in chief without the House managers having the opportunity to cross-examine.
Certainly the peanut gallery on social media wants everybody in the FBI called in and everybody put on the stand, and everybody questions. So we'll see whether that actually turns out to be the case.
Darth Dionysus is asking, can Paxton be charged criminally after this? Well, there is an ongoing FBI investigation.
He's on bond right now.
Well, he's on bond in the securities fraud cases. He was indicted back in 2015 on 2 counts of first-degree felony securities fraud and 1 count of, I forget the other charge. It's a third-degree felony. It has to do with filing paperwork with the securities board. And there's certain law, a law that, by the way, he voted for.
He voted for. And in the civil side of this, he acknowledged some of the, doing some of this to the state securities board already. So he's already acknowledged some of this that he faces criminal charges for. The other argument on this, on his side, is that this is a criminal charge that, as far as anyone can tell, has never been filed in the state of Texas. It's never been filed as a criminal case anywhere. They're making a special example of KenPaxton. He is free on $35,000 bond and has been serving as Attorney General and reelected twice while free.
And Victor, how unusual is it for a case to take that long? I mean, he was indicted a long time ago.
It's not unusual, particularly in a case where the stakes are high or there's some profile for the proceedings to be protracted for one reason or another. And I'm not closely following those proceedings, but there have been venue challenges and lots of pretrial motions, and that tends to protract proceedings.
He had the long argument Collin County didn't want to pay the special prosecutor anymore, and then that had to go, and then it's moved around to Tarrant County, and now is in Harris County, and I think a hearing's been scheduled. And the answer is yes, he can be charged, with anything. Any evidence that came forth in this trial can be used in any future criminal case.
Let's see, I'm still watching these comments. Folks are asking, do the closing arguments count against the clock? I'm not actually sure of that answer.
I believe it was described as time for witnesses.
I think it's outside of, I think they have an hour for closing arguments.
Yeah, I think that was in the rules that were set. I can't remember.
So,
I don't recall.
Yeah, I'm going to claim a little bit of ignorance on that. I believe it's outside the 24, but I have to go back and look at the rules. Okay, so Joseph Calderara, I'm probably not saying that correctly, it says, if anyone is caught lying in these proceedings, can they be charged with perjury?
Yes.
And kind of walk us through that. I mean, I agree with you. I know that should be true, but explain to folks why that's the case.
Well, it's an official proceeding, and prevaricating in the context of an official proceeding has criminal consequences.
So let's see. Somebody says, how many times has Paxton been indicted? Well, he was indicted back in 2015. And then they actually did a re-indictment on the same charges. They reworded the indictment. I recall that. It's been a long time ago. But yeah, he was indicted back in 2015. And that's the only charges, those original charges that he got indicted on. There is that ongoing federal investigation. And we know from listening to this testimony, Missy Carey talked about being called to a federal grand jury.
Right.
But we know, although he's been reelected while out on bond, we know from the Texas Politics Project survey, and his defenders will say, well, the voters knew all about this and reelected him. But the survey shows that 40 to 50% of Texas voters did not know anything about any of his legal problems before either election. 50% before the first election, and then 40% before the most recent election. So a large portion of Texas, obviously there's very little state political coverage in much of the state. People weren't aware. He's a down ballot official. There are so many reasons that people are not keeping up with the Attorney General, but people weren't aware of the problems. In the general election, he was running against Democrats that had, had little money and were not able to run, any sort of statewide campaign challenging, Paxton. So people didn't really know.
Yeah, and the commenters here are saying that the closing arguments is separate from testimony time, and I believe that to be true. Actually, it's been a long week and a half, guys. I mean, 12-hour days every day, so it's starting to wear a little bit.
Right. You're wanting to wrap up tomorrow.
I know, and yes, because it's been long. My kid is kind of reminding me 27 total on each side. That's right. It was 24 for testimony time. It was an hour for rebuttal. And it was an hour for openings, an hour for closing. Now it's all kind of coming back to me, and so.
So there is an hour for rebuttal.
Interesting. There is an hour for rebuttal. I remember that now. Actually, that was in my notes earlier. So somebody's asking, will this be done this week? I think it'll be done this week. I'd be shocked.
I think so too, but whether or not it's done this week depends on whether extra time is given or not. Something you just said caused me to think about strategy here. If there's additional time for the House managers to put on a rebuttal case, that militates in favor of the defense not putting on a case, because if you don't put on a case, there's nothing to rebut.
Right.
Well, if the defense feels like that they haven't proven any of the 16 articles, that none of them will be sustained, then the defense, doesn't have to put on a case.
Right.
I noticed there were mailers going out from at least one conservative group saying to call your senators that the vote will be Saturday. I don't know how valid that information is, but we'd like to see it Friday night, but it may well be Saturday.
I just feel like these senators are going to want to go home.
Right.
But that's just, that's don't say that based on any information. I just say that based upon, really just upon having covered juries.
Right.
I mean, juries, they like to wrap it up before the weekend.
They really do. The last case I tried, I was telling you all, I was on a clock, federal court in New York City, and the case got to the jury on Friday morning, and they were out of there by 2 o'clock. They didn't want to stay.
No.
And what's interesting is they took lunch. So they ate their lunch that was supplied by the court, and after the lunch that was supplied by the court, they all of a sudden had a verdict. So they were going to get their court supplied lunch before they took off for the weekend.
In my experience, they almost always eat lunch. They always eat lunch.
Particularly the lunches that are being supplied are good lunches, and there were pretty good lunches supplied during this trial. So why not take advantage of the fact that you're doing a public service and the parties are supplying you a good lunch on their dime? You got to take it.
The senators would probably like to get out and go to the football games.
Absolutely.
Yeah,
and have a good weekend.
I know on Friday nights for me, that's high school football time, so I'm sure that there's some senators who probably feel the same way.
So Mike in Houston wants to know, what happened to the 44 minutes the prosecution saved on opening? I don't know the answer to that. I don't know. I don't know if it went into their.
Well, he said it added to their time.
I guess they just added it into their.
Added into their witness time. They've taken a lot of witness time.
I think that's probably what happened. Let's see. And so we've got a live look up of the Senate chambers, and we still don't have
no
Dan
jury.
Patrick back. No jurors. I mean, there's been a lot of great testimony today, but also a lot of downtime too.
Right.
Which is kind of surprising. So I don't know. And somebody's asking, why is KenPaxton not in the room? Do you, if you were one of KenPaxton's attorneys, Victor, would you have KenPaxton there?
Well, he's probably not there at the advice of counsel. I mentioned earlier that there are lawyers that make strategic decisions to not have their client in the courtroom. I tried a case here, the Civil District Court right up the street at 600 Commerce at the end of last year, and the plaintiff decided to not show up for the trial except when she testified. And I believe that was a lawyer-driven decision to ensure that the jury did not assess and judge the plaintiff throughout the trial. Maybe KenPaxton's not a good poker player. Perhaps his facial expressions would betray him, or there are any number of strategic reasons why a lawyer would not have their client in the courtroom.
And I've said that I think it's because he doesn't want to be photographed exchanging glances with Senator Paxton.
Right.
And to have her, it's enough that she's there, and so if they're both there, then that's what the photos are going to show. So.
I cannot imagine being in her shoes.
Well, and she doesn't get to vote.
No.
Which was the topic of a lawsuit of whether she should get to vote or not. When she was elected, we discussed on Inside Texas Politics the question of, what if her husband is impeached? She'll be in the Senate voting on her husband, on whether to remove her husband or not. And the Senate just, somewhat arbitrarily set this rule and said she can't vote. There was a lawsuit over that went to the Supreme Court and upheld the rules of the Senate saying she can't vote. But it did come up during her election.
Mm-hmm.
So Chris Grimes has a question for you, Bud. He wants to know any thoughts about senators knowing beforehand how they are going to vote, but proceeding with the trial in order to give their constituents justification for their final vote.
Well, I think a lot of the senators knew how they were going to vote going in. I think almost all of them did. I think that it was about one vote difference for or against removal going in. I think that the reason they've gone ahead with this trial is to first of all, to have the openness and show to the people of Texas that they were open and wanted to listen and hear the case and to hear all the charges. I do think that during the course of the trial, early in the trial, I think there might have been, a slide toward the prosecution. It seemed like maybe the prosecution might have picked up a vote or two, and then during some of the cross-examination of the early witnesses, then they may have slipped back to where they were. I think all the senators knew what they wanted. Some of them voted. We had the six that voted with Paxton on resolutions going in, and that didn't even want to have a trial at all. And I think that all of them know what they want, and they know who they're trying to please, and they know how to vote. I do see them paying attention. I think they're attentive, and I think that's because they have to go back to the public and explain why they voted the way they did. I don't think the trial has changed a lot of minds out of the 31.
So Tamara S. is asking, who are the 6 senators that, standing with Paxton, I think what she means is the 6 senators that initially voted to dismiss all of the articles. That was, you got that written down? I've got it somewhere in my notes.
See, I've probably got the opposite. I've got the 6.
It was Colhorst, Hall, Betancourt, Parker. I'm trying to think out the other 2. Shoot, I'd have to go back into all my notes. There was 6 of them, yeah.
And for different reasons, I think, on each part.
Why do you say that?
Well, I think some are voting because they are voting the way they think that Lieutenant Governor Patrick wants them to vote. I think that some of them are voting because they have future political aspirations statewide, and they think that this is where the primary is going, or this is where a statewide party is going. Bob Hall is voting because Bob Hall is the crusty old right-wing member of the Senate, and he certainly would vote that way. Brandon Creighton, Lois Colhorst, I think
they're going through the list, okay.
Yeah, I think they have statewide ambitions. Paul Betancourt in Houston is kind of Lieutenant Governor Patrick's right-hand senator, but although Lieutenant Governor Patrick's two allies voted on opposite sides of this, his two strongest allies, Hughes and Brian Hughes and Paul Betancourt. I think Betancourt, through his body language, he sees all this as just kind of a waste, and he doesn't want to be seen as weak. He wants to be seen as on board with the Patriot Trump team that's backing Paxton. You have Tan Parker, whose district stretches from Highland Park up through Denton County. I can't really explain Tan Parker's position in this, but I think it's probably pressure from the voters and pressure from his district. And then you have Senator Donna Campbell, who's former Chief of Staff Laura Olson, is in the middle of this. So those are the six who have been the people with Paxton all the way. And I'll have to look up and see who's up for re-election next year.
So Chance Escamilla asked how many votes are needed to impeach. Needs 21. You're going to need the 12 Democrats, because it would appear that the 12 Democrats are going to hold together, plus 9 Republicans. And we're going to see what's going to happen. Because it's a heavy lift to ask Republican senators to vote to remove a sitting Republican Attorney General from office.
Right. Yeah, you need 5 of the 6 swing. There's 6 that are considered, that probably will vote, and then there's 6 that are swing, and you need 5 of the 6 on only 1 article of impeachment. You have 16 articles, so you have 16 bites at the apple, but you need 5 of the 6 swing Republican senators, and that's why I've said all along that I just don't know if the prosecution can get there.
So Christopher Carson asks, let me see, maybe Victor will speak to this one. Can the panel speak to whether the shared ideological bent of the OAG enabled the alleged corrupt behavior? I mean, these guys had no problem working for the AG under indictment. In other words, I guess he's saying that, did the atmosphere in the office lead to this? I guess is what he's kind of saying.
Oh, that's something I really can't speak to. I'd have to ask Bud that.
Well, thank you for that hot potato.
I'm just tossing out hot potatoes in the comments now.
I think certainly the single mindset of the office and the conservative mindset and the belief that everything we're doing is righteous and pure, led originally to their belief in their boss and their belief in that everything their boss is doing must be righteous and pure. At the same time, it's what has led their whistleblower case to be such a strong reaction, is that they saw things that they felt like weren't righteous and pure and in keeping with what they saw as Christian and what they saw as something they should believe in. And this gets back to faith, but they saw someone who they believed, and we said this before, Ken Paxton, we should be seeing him, but we should be seeing him repenting. We should be seeing him asking forgiveness. We should be seeing him expressing sorrow, and we haven't seen any of those things. So I think the staff saw that he was an unrepentant, offender, and so they reacted very strongly to that. I think it was very much both their political beliefs and their faith and values that they felt like that he was, and this is where you get deeper into Christian belief, but they felt like that he was damaging to Christian witness, that
Right.
holding him up as an example of a Christian in politics was damaging to Christian witness and hurt other fellow Christians who wanted to promote the conservative cause.
Well, and there's a scripture that talks about, when you talk about Christian witness, the one about going, you go to your, someone's done wrong, and then if they won't admit it, then you take 2 or 3, and then I think it was part of
that was quoted in the trial. I
yeah,
think that was cited.
I'd have to. I think it's in Matthew.
Yeah, it was cited to one of the witnesses of why didn't you do that?
So, jumping subjects here. I'm going to go to Victor for this one. Explain why Nate Paul wasn't called. He's under indictment, so kind of walk people through why he's not, why they wouldn't call him.
Well, why the house managers wouldn't call him?
Yeah, let's just talk about that.
Well, I think it would be pretty obvious that if he were called, he'd take the fifth.
Right.
And do you want to waste time, since you're on the clock, with calling a witness that is going to take the fifth, and nobody's really going to try to infer one way or another why he's taking the fifth, because it's pretty much conventional wisdom that he should take the fifth.
Okay, I'm trying to talk in my ear.
I'm trying to find who's up for re-election. Well, see, I'm here with my two phones. They accuse him of having four phones.
Hold on, I got to put the correct ear thing in here. Sorry, I got multiple boxes, little boxes, one for the TV and one for the live stream. Okay, go ahead, Jay. Now I can hear you. Oh, really? Okay, yeah, so yeah, what Jay is telling me, there's some things going on behind the scenes that we're looking into related to what, the Laura Olson situation. Of course, we're waiting to see, when she's going to take the stand. I'm being vague here, purposely vague. So yeah, we're kind of like, I've had on my other screen, I've had the Senate feed up, and well, here you can see it on the screen. You can see Rusty Hardin. You can see a number of the senators have entered back in the room. Okay, there's Dan Patrick coming in. He's coming up to the dais. So I guess they're going to start back up. Jay, do you just want to go ahead and kill our mics and let's listen to what's going on?
Jason Wheeler report.
Just right refreshing. Okay.
Jason Wheeler just tweeted less than a minute ago. He's up at the Capitol. Like I said, he's at the Capitol, and it says, after being in the Capitol most of the day, alleged KenPaxton mistress Laura Olson was headed for the first floor exit. I asked if she expected to testify today, and the woman who ushered her out said they had something they needed to get to, and she is not expected to testify today.
Bailiff can bring the witness back in.
Okay.
Members, for the record, the House Board of Managers called Laura Olson. She is present but has been deemed unavailable to testify. As soon as we get the witness in, we can continue. I said the House Board of Managers called Laura Olson. She is present but has been deemed unavailable to testify. The statement has been made by the court. It says what it means. Both sides have agreed to that statement. Both statements have agreed to that statement. Did not mean to be short with you, Senator. I'm not amplifying the orders we give. It's stating what both sides agreed to in writing. Mr. Harden, you can continue.
Thank you, Your Honor. Stacy, well, first of all, very quickly, let me ask you, were you familiar with the House situation in terms of the Attorney General and the fact that it was having construction and they had to move out for a while and so on? No, your microphone, and there you go.
Yes, sir, I was.
All right. And you've testified earlier that the Attorney General's office was right next to you. In addition to that, would you regularly get reports from and follow information from Mr. Wicker?
Yes, the scheduler and the executive assistant, Mr. Wicker, both reported directly to me.
And do they give documents to you as to what they're doing or anything like that?
They did, and we met weekly.
And so from your own personal knowledge, do you know when the Attorney General moved back into his house?
I do.
When was that?
Sometime around mid-July, around the 18th or 19th of July.
All right. Now, were you also aware of the name of who was the company that was doing the work on it?
Recently, I became aware of that company's name.
Well, at some time, did you actually do some research into that person on your own after you were terminated?
I did.
And at the end of the day, the names, you of course know Mr. Nate Paul. Were you familiar with the name Kevin Wood?
Yes.
And were you the name of a person who went by the name of Raj Kukar?
Yes.
And have you reviewed certain materials concerning those people's names?
I have.
I'm going to ask you, if you would, Stacy, this exhibit is already in Your Honor. I think the defense put in Exhibit 134 is already in, and they put it in mass, and that production included the pictures. I believe it was the production by Mr. Wood. Yes, okay. Could you put up Exhibit Wood with bait stamp Exhibit 134.050? Could you put it up with the bait stamp 6211, please, Stacy? Now, I'm going to publish it for you and ask you a couple of questions. First of all, the Kevin Wood, were you familiar with the fact that he was the main worker or in charge of the work that was going on at the house?
Yes.
I won't object, Your Honor. He said he learned this later. He had no personal knowledge at the time this happened. Sustained.
This particular document that the defense put into evidence says, Nate worked yesterday 7 a.m. to 10 p.m., got home and fell asleep. Going right now to start guys on K job. Mr. Kujar's last name begins with a K, does it not?
Raj Kumar.
Kumar. And Mr. Kumar's company is what?
Cupertino Builders.
All right. Then guys at Ben White Concrete ask for help. After I check on the 3M guys, I can get email more detailed schedule. Does your house look okay for Father's Day tomorrow, or does it need cut? And this particular email produced by Mr. Wood was sent to whom?
To Nate Paul.
Now, it lists a series of things here. Would you read those off of things that are to be done?
Sat subfloor. Sunday subfloor.
Slow down. Go ahead.
Monday, restore old floor. Tuesday, new floor. Wednesday, new floor, landscape front and fix irrigation. Thursday, new floor, new fans and fixtures, finish landscape. Friday, finish new floor, finish electrical. Saturday, seal all floors up. Sunday, clean up.
Can you imagine any reason that the man doing the work on the Attorney General's house would need to be informing Nate Paul of the schedule and the work being done?
I cannot.
I'm sorry, Your Honor. He's assuming that this has anything to do with KenPaxton's home. This is not the witness for this. I object.
These documents, these are actually taken. Let me make sure I'm not falsely accusing him. Hold on. Is he seriously contending? We'll take some time out. I don't want to. This is an exhibit he produced. He used photos in this deal. He wanted photos of the house. My question is, I don't want to falsely accuse Mr. Busby, but is he seriously, as an officer of the court, contending there is any question as to whether or not the documents in Exhibit 134 have to do with Mr. Paxton's house?
Your Honor, I'll respond to that. And yes, he has accused me of a lot of things throughout this trial, but I'm not too concerned about it. You can see from the email itself, a fair reading is this man is working on multiple different jobs, and this witness has no ability to tell us what these things and whose job that is. This guy was also apparently a landscaper and was doing different jobs, and we don't know. We know that some of the pictures, obviously, are of the kitchen in the Paxton home, but we don't know, and this is not the witness to be asking about the renovations because he doesn't know anything about the renovations.
My question was, is he contending seriously, he hasn't answered it yet, that these documents do not have anything to do with Mr. Paxton's house? If so, we'll try to prove that up later. I don't believe he said that.
I didn't come here to answer his questions, Your Honor.
I was going to say,
thank you.
It's not his, you're not asking him questions. He made an objection. He explained it. You made an objection.
Thank you.
I'm going to sustain the objection.
Is the court ruling? All right, thank you. If I can now, Stacy, would you put up exhibit with the debate stamp 6212? The last exhibit was 620. This one's dated, actually, I thought 622 was the next exhibit. These would be 6212, 6215 is what I really mean to have up now, Stacy. I'm sorry. The date of this one, please, sir.
July 4th, 2020.
And this one is from Mr. Nate Paul to Mr. Kevin Wood, is it not?
It is.
Nate Paul tells Kevin Wood what?
Great. Can you send me pics?
Kevin Wood responds what to him?
Guys just finished applying second coat of sealer.
Stacy, I'm sure that it was wrong, my mistake, but I wanted to see if '6211 and 6212, if you would tell me which you put up first, and I'll put up the other one now. I don't know whether I gave you the wrong number. Pardon me? All right. Is that what you put up first? All right, thank you. All right, then 6212, please. This is on the 22nd of June. And to Mr. Kevin Wood, he's responding on top of an email from Mr. that we just read on the one on June 20th. Do you see that?
I do.
And this is Kevin Wood to whom?
Raj, Nate's guy, Raj Kumar.
All right. Raj Kumar is the president or CEO of the company that did the renovations, correct?
Correct.
And then below that, this is he's forwarded Kevin's to Nate Paul. So essentially, what's happened with this email? How does it begin? Kevin Wood forwarding the email, you tell me.
The initial email is Kevin Wood to Nate Paul on June 20th, and then it's forwarded from Kevin Wood to Raj Kumar on June 22nd of 2020.
So we now have we not, or have we, communications between the man doing the actual on-the-site construction, updating Nate Paul, and then the man on the site doing the construction, communicating with the owner of the company that's doing the construction, correct?
We do, that's correct.
And so in these messages back and forth, if they are in fact communicating about the lieutenant, excuse me,
No problem, Senator. No problem, Senator.
I'll put general if I have to. The Attorney General, the people who are doing the work on the Attorney General's house are all communicating among themselves, are they not?
That's correct.
And they're communicating about the Attorney General's house, are they not?
That's correct.
Now, I want to look at, if we can, 6216, please. Actually do 6215, Stacy, please. Now this one is dated, the other two were the 20th of June and the 24th of June. And this was dated July the 4th, is it not?
That's correct.
And it's from whom to whom?
From Kevin Wood to Nate Paul.
And Nate Paul says what to Mr. Kevin Wood?
Great, can you send me pics?
And he's saying that in response to Kevin Wood telling him what on Saturday, July 4th?
Guys just finished applying second coat of sealer.
Stacy, 6216, please. On July the 4th, in response to an email asking from Mr. Paul, can you put together, please, Stacy, side by side, 6216 and 6215? So, on July the 4th, on the left, the one we just went over, Nate Paul asked Kevin Wood to send him pictures of the work they're doing, correct?
Correct.
And then if you go over to the right, Kevin Wood does what? On the same day, on July the 4th?
He sends him the photos.
He says, does he not? This time, Kevin Wood includes Nate Paul and Raj Kumar on both of them on multiple pictures of the house, correct?
Correct.
Do you have any idea why those three would be communicating like that if Nate Paul had nothing to do with the Attorney General's house?
Objection, speculation.
Sustained.
Now, after you were terminated, did you start doing some of your, and of course y'all had a lawsuit starting when?
November of 2020.
Okay. Did you yourself start looking to see if you could find information that would help your lawyers and your lawyers for information and so on? Did you come into discover a receiver's report that had to do with Nate Paul's businesses?
I did.
And did you in fact yourself obtain that report and give it to us?
I did.
I'm going to show you what it has been and ask that that Stella submit to the court on the other side. This is a new exhibit, Your Honor. Now, without talking about the internal parts of it, what did you discover? How did you discover this receiver's report, and where was it filed?
Your Honor, I'm sorry to interrupt. This first time disclosed. Number two, he's already admitted that he didn't have any personal knowledge of this. He just went and found it. He's not here as some kind of investigator. He's supposed to be telling us what his personal knowledge is of things that occurred at the AG's office. What they just handed us looks like to be file stamped October 31st of 2022.
Your Honor, excuse me.
He was out of the office long before that.
All right, Your Honor, if I may respond.
Yes, you may respond.
This is a receiver's report filed in litigation in Harris County in the 165th Judicial District Court. And what we have and what you have is a certified report, certified public document. It's filed and now certified that it is a public record, and it comes in under 8038A3.
Your Honor, first it has to be relevant.
Let me just
I thought you were finished. Go ahead, sir.
Excuse me. Let me finish, please. Public records, and it has factual findings from a legally authorized investigation. And the relevance of it is it deals with the extended cross that Mr. Busby went through about the house and whether or not it was legitimate and all of that. And that is addressed, not the house, but the investigation. It was clearly, I respectfully suggest it's admissible as a certified public document.
Excuse me. Do I answer? Mr. Harden, forgive me. I did not understand what you said just now.
Oh, okay. That would not be.
Give me one more try.
Oh, sure. And that won't be the first. This is a certified public document. It is admissible without a sponsoring witness. If it is relevant to the issue, the matter that we're seeking to introduce it in, then it comes in under 803C without a sponsoring witness because it is certified as a public document. Comes in under the public documents exception to the hearsay rule. And in this particular case, the reason it is relevant, I will refer the court, perhaps would help you if you look on page, if we use so that you can yourself look, you will look at page 84, page stamp Brickman down below, 84, Brickman 85 in particular. And it has to do with Mr. Nate Paul. Go ahead.
Mr. Harden, I don't see an 803C. What am I missing?
Okay, I'm sorry. She's right. What Jenny, Ms. Vavorkas is showing me is you don't have the Brickman bait stamp. That's how we got it. So we then went and got a certified copy. And so what you would be looking at is page 47 of the report.
Okay, but I was asking the question of why it could come in 803C. I don't see an 803C.
And more particularly, if I could.
Excuse me. I don't see an 803C unless I'm missing it. I see 803 1 through 24.
If we can, if you look at page 72, Your Honor.
I'm asking the first question. I don't see an 803C. I may not be looking at the right.
Yeah, that's right. If you're looking at the rule.
Yes, sir. I am.
Okay. If you're looking at the rule, it's 8038C. I've got a lot of help, and obviously I need it. Yeah. So we got 8038A2. Thank you, Dick. And 8038A3. If you look at those, I would make it very much.
You see, you made me dangerous. You made me start looking at these numbers, and there's not an 80C3. There's 808. Yeah, it's 808C. Okay. Okay. Now that I have the right number, I'm going to overrule the objection. Thank you.
Your Honor,
Thank you very much.
Your Honor, my objection was not hearsay. I mean, he's given you a hearsay exception, but I want the court to note that this is a report from a receiver appointed by the court. His opinion, it uses the word opinion multiple times in the document. and it was done 2 years after the events in question in this case, has no relevance to this case. It's an opinion of somebody, Seth Kretzler, out of Houston, who, if he had some opinion that the court found relevant, then he should come here and be cross-examined. We can't cross-examine a report from somebody who's not in court. So, Your Honor, there's 3 or 4 different reasons why something like this should not be admitted. The first of which is that it's years after the events in question. 2, it's written by a lawyer who's been appointed to be receiver, and it's filled with his opinions about this and opinions about that, which I guess would be some sort of expert type opinion, although we haven't qualified him as such. There's a lot of reasons why this is improper. And the last one, I think maybe the one you might find most important, they put this on their exhibit list yesterday, and I just got a copy of it right now. So how am I supposed to, 100 pages of opinion by a receiver out of Houston, do anything with this? This is completely improper for various reasons.
Your Honor, that's always true of any publicly admitted document that comes in without a speaker. Right now, that doesn't have a prepared cross. He's free to subpoena any of these witnesses. This talks about the very 3 people that we were talking about and the arrangement that they have.
They put it on the list yesterday.
I try to...
Okay, gentlemen, stop. I'm going to relook at this. I based my ruling on your exception.
Thank you, Your Honor.
But he has brought up several other points.
Thank you. Now, if I can...
No, I said wait. You can stop the clock for a moment.
Thank you very much. Your Honor, may I, just information, I was just informed, this exhibit, without being certified, was on our original witness list. Exhibit list. They have had this exhibit notice for about a month and a half. Pardon me, Your Honor. This may not address what you're talking about. I just wanted to be clear in the record. Our original notice to them of this exhibit was Exhibit 129 in the middle of August.
Did you change the number on the exhibit?
We not changed. We did because the new one was certified. That one wasn't certified, but it was this document. We listed this exhibit. That's what they've had since mid-August, and all we did was introduce before you a certified copy of the exhibit that we had previously done. I can tender it to the court if the court wants to look at. Yeah, okay. Thank you.
On further review with my legal team, it appears, looking at the document, it contains double hearsay, so I'm reversing my ruling and sustain the objection. Continue.
Finally, Your Honor, we moved to introduce the grand jury subpoenas as Exhibit 172. This is very bulky. These were the subpoenas, the grand jury subpoenas that have been mentioned throughout the case. I'll tender to Mr. Busby, and because of we just have one copy for you.
Did you resume the clock?
Your Honor, these are, just for the record, these have been offered ultimate exhibits, 172 through 185, then 187 through 209, and 218 and 220.
No objection. You may continue. Let me admit these.
May I have just a moment to see if that's it for us?
Admit 172, 173, 174, 175, 176, 177, 178, 179, 180, 181, 82, 83, 183, 184, 185, 187, 188, 189, 190, 191, 192, 193, 194, 195, 196, 197, 198, 199, 200, 201, 202, 203, 204, 205, 206, 207, 208, 209, 218, 220, and 2 evidence.
Thank you very much.
Yes,
One
sir.
final question. Would it be possible for us to find out what sections the court considers double hearsay? In case of that report later, we could come back with bracketed, not to argue with you about the ruling of double hearsay, but to maybe admit stuff that was not.
With all due respect, we really did spend a lot of time on that, stop the clock, and on the advice of 4 very wise people up here to help me with that issue, I'm going to stay with my ruling.
I appreciate it, Your Honor. If I have just a second,
Yes.
if I could stop the clock to confer, because I think we may be through, I just want to make sure.
Sure.
Your Honor, at this time, the House of Managers rest.
He just rested without a cross-exam. I can recall the witness, though. I'm fine with that. We'll recall this man. We will accept the rest. And that's how it works.
He's certainly right. I mean, I want to concede he's absolutely right. I apologize. I think he is entitled to his day in court. Thank you.
So he has given you your cross-examination, if I'm understanding, Mr. Hardin?
Your Honor, we have some motion practice we'd like to take up with the court today.
All right.
Now, is he waiving cross or?
That I would recall this witness in our case in chief. If there is a case in chief needed from us, I'd like to do some motion practice today.
Well, here's the problem. I messed up and shouldn't have rested until he finished his cross.
And yet you did.
Excuse me. Having this witness come back doesn't make sense. It would seem to me the appropriate thing for him to do is to cross this witness, and then if we had an opportunity or took one to redirect. But it usually should be when both of us have finished with this witness and then we press. The court is having to put up with a screw up by me. I apologize, but I would really respectfully like for him to go and do his cross.
I don't have to do a cross. He rested. I will recall this witness.
Mr. Hardin?
He is waiving his cross for this stage. I understand. If that's the case, there's no problem.
You rested, sir.
Yes.
And I accept that.
Yes, you rested.
That's fine. And if he wants to put on his case now or he wants to argue a motion, what's the court's preference?
Well, it's now up to him. You've rested. It's up to him to either recall the witness or to make a motion, or it's now his call.
All right. May I ask what about this witness? He's caught in the box.
Is he asking for what?
He's asking about this witness. Can he step down at this point?
Subject to recall. Yes, sir.
Okay, you can step down, subject to recall.
Your Honor, we've seen, Your Honor, the House is...
Let's wait till the witness is out of the courtroom.
Okay, Victor, that was kind of stunning.
Yeah, I've never seen that before, I have to say. Typically, what Rusty really meant to do was to pass the witness for cross-examination, and his team probably informed him, go ahead and rest after the witness examination is finished. But to rest your case after the direct examination of the last witness without cross-examination, I've just never seen that before.
Mr. Busby.
Yes, Your Honor. As I understand from my colleagues, a motion for directed verdict must be filed and in writing. We have done that. We filed a motion for directed verdict on each of the articles, and I think we've also grouped some of the articles. I think those are dispositive. I would ask that the court consider those. I understand that the Senate would have to vote on those, and I just wanted to inform the court that those motions have in fact been filed, and I don't think you probably are interested in a bunch of oral arguments, so I'll stop it there.
So pursuant to the rules adopted 25-3 by the senators, a motion for a directed verdict as a dispositive motion must be submitted to the members of the court for a vote, as you stated. A motion for a directed verdict is a challenge to the sufficiency of the evidence. Therefore, these motions will go to the senators under the rules. It takes a majority of members present, that is 16 voting members who are eligible to serve as jurors, to grant a motion. If a motion fails to get a majority vote, the motion will be denied.
And I'll sit down and hear.
Do we have the motions? They need to be presented to the court.
Excuse me, Your Honor, it has to be submitted in writing, does it not?
Pardon?
It was submitted in writing. I think you
Yeah, in writing. We have to receive it in writing.
Your Honor, we have a cross motion that we will be filing.
that is being filed as we speak. Would like to take that up at the bench if we could.
So when would you like to take that up?
Now would be fine if we could take it up, please.
So,
We need to get the court a paper copy, but but we have in fact filed it electronically with the court.
I need a paper copy, as we did earlier with the other motion that was filed.
Very well. We'll get on that right now.
Sounds like you have multiple ones. Thank you.
So, these motions for directed verdict in a normal trial.
Well, after the government rests its case, you typically have a motion for ruling as a matter of law that the evidence is insufficient to meet the allegations that are laid out. What is atypical is to have the jury rule on the motion, but you know, this is an impeachment trial, not a criminal trial.
This is a democracy. So they're going to vote. It takes a majority vote. They said they will have some of the votes singularly on the 16 articles and some grouped together. So apparently it will take several votes to get through this.
So that'll give us some sense of where people are, right?
It should.
Or will people hedge their bets? I don't know. I mean, this is just a crazy situation because it was clearly so unexpected what Rusty just did here. He did not mean to rest.
No, he did not. He meant to pass the witness, not to rest the case.
What did you think about the way that Busby handled it?
I think the way he handled it demonstrates, it either demonstrates confidence in where the defense is with their case, or he was trying to project the confidence to the senators that what you just heard was throughout the entirety of these proceedings was such a non-event, I'm not even going to cross-examine this witness.
Yeah. It was, it really, when he said he rested it, I was like, he did what? It really caught me flat-footed.
Right.
And then, go ahead.
And caught Busby the same way, I think. And he said almost in the same breath that he reserved the right to recall the witness, but we are submitting motions to dismiss the articles.
Right.
Which typically does happen after, in a criminal trial. In a criminal trial, that's actually pretty typical, where the moment the prosecution rests, you ask for a directed verdict. So that's what's happening here. It's just the difference is you don't normally have the jurors vote on the directed, vote on the motion. That's just a very unheard of, rare situation. And you can see a live look there in the Senate chambers, various senators, talking, and of course we have no idea what the conversation is there.
Well, Senator Birdwell in the middle is trying to explain what the rules will be. I'm sure they want to know whether debate will be allowed, whether questions will be allowed. I'm sure the senators are asking, how much input they'll have or not have, and whether they'll even be able to identify which article is which. Are they going to read them off, say Articles 2, 5, and 7? What are they? Will they know what they're voting on when they're voting?
Well, because they're probably also a little bit surprised right now.
Right.
Because Again, Rusty Hardin clearly did not intend to rest.
That's right.
Obviously he is considered a legal legend, but what I've seen in this trial, I've seen a lot of missteps. Just in terms of management of the clock, and Aaron Epley today was stellar.
Yeah,
absolutely
I thought she
stellar.
did a very effective job.
And so it just, I don't know. I don't know the reasons why or what, and maybe the approach of the way he normally handles cases works in other venues, but it didn't feel like it worked here.
Well, this was sloppy, but he would have rested after the cross-exam anyway, right? So, was this really that much of a? It was off note and threw everybody off, but was it really? Was it ultimately that different? He would have rested after the cross-exam, and then we'd still have these motions.
Except it gives the opportunity for Busby to grandstand, which
is exactly what he did. He seized on it.
Project it in a confident manner that I don't even need to cross-examine this witness. You rest it. Let's just move towards throwing out these bogus charges.
Let's throw it all out, y'all. Come on, y'all. Let's all go home.
Busby's a showman, and he showed right there that he can seize on any misstep and turn it to his advantage.
And that's exactly, what he has done here. So what we're doing, what we're waiting on here right now is, and you can see Angela Paxton actually kind of coming up to the group. But they've, the defense is making a number of motions for a directed verdict to seek to throw some or all. I guess they're probably going to have kind of similar to what they had at the beginning of the trial. There was one that sought to throw out all of them all at once, and then they had them, grouped. And wouldn't be surprising if it's similar in terms of what we saw before.
Right.
At the beginning of the trial, the votes were from 22-8 to 24-6 to proceed with various articles of the trial. There were some that were questioned. The one about the special prosecutor was the one that was the least popular.
And go ahead.
The important thing about this is that it'll take 16 votes to throw out an article. If it's tied 15-15, then the motion fails. Mm-hmm. So it'll take 16 votes to throw out any of the articles. When we get around to another vote, if it were in favor of the prosecution, then it would go the other way.
Which of the articles?
Okay, you want to bring Teresa in? Okay, so we got our colleague Teresa Woodard, who's at the Capitol. We're going to bring her in on a video call to see what she has to say, because she's obviously there on the ground in Austin.
Hi. Yeah. So what a wild development this afternoon. Hi.
Hold on. I can't hear her under my ear.
Can't hear me?
Can't hear.
Nobody
Hold on,
can hear me?
He's fixing it. Jay is fixing it.
Okay.
Now you're in my ear. Wow, the magic of technology. Okay.
Can you hear me now?
Well, I can hear you now. Okay, Teresa, go ahead.
Okay, very good. Hi. Yeah. So what a wild turn of events. Just in the last episode, we had news that the alleged mistress, Laura Olson, we all expected her to take the stand late this afternoon. Then we got word she had been deemed unavailable to testify. We were seeking some clarity on exactly what that means, and maybe your experts there at the station could lend a little bit more shed a little bit more light on that, because it's unclear to us if that means unavailable to testify means for the duration of the trial or if it just means for today. But of course, the thing that is happening right now was that accidental rest. I think that was a very wild development that no one expected to happen. And now we're going to wait and see how this is going to go down as they ask for that directed judgment. It's not surprising that they would do that. Like you've been saying, we hear about a summary judgment in most trials, and so you would certainly expect this to happen. But what will the vote be? That's going to be key. And as you said, I think it's going to really sort of give us an indication of where things stand. Are we moving forward, or have we heard enough? Is it over?
How surprised were you, Teresa, that we suddenly didn't hear from Laura Olson after we spent all day, all of us waiting all day long, and then it didn't happen?
Yeah, that was that appeared to be the most stunning item of the day until the accidental rest from Rusty Harden kind of overshadowed it in the last few minutes. Yeah, our colleague Jason Wheeler happened to be out in the hallway, and he saw Laura Olson headed for the exit of the Capitol. And then I saw from another photographer who was stationed outside of the Capitol that she had left the grounds. And so that was definitely a surprise. It was unclear to us exactly whether, right at 4 o'clock, if we were going to see her take the stand. But we did know that her attorneys were trying, it appeared, to keep her from having to testify. And so, it was still very surprising that That was where it seemed like everything was headed, and then suddenly it didn't happen.
Yeah, we were certainly shocked when Dan Patrick said that she was present but deemed unavailable to testify, because at first we were like, okay, is that just today, or is that it?
Right. And so what are your experts there? Can we get some clarity? Because as I said, we've been trying to get some clarity from our perspective, but what does that exactly mean? That's one thing I need explained to me. What does unavailable to testify mean? Does that mean for the duration of the trial? And why would that happen?
So first of all, it's unprecedented. I've never seen a circumstance like this. One of the senators, I don't know who it was, asked for clarification.
Yeah.
And you'll recall that Lieutenant Governor Patrick said that's the agreed statement that the parties worked out, and that's as much as I can tell you. So I'm at the same place the senators were. The statement is a pretty bland and general statement that, if you take it on its face, means that she's not going to testify at all, because there's no temporal limitation on, quote, unavailable to testify.
Well, and now that the House is rested, I mean, presumably the defense is not going to call her. So it seems like we're not going to hear from Laura Olson in this trial.
That's right.
So, I mean,
which is shocking.
It is shocking, because there were things she could answer.
Well, Victor, we were asking if she decided to take the Fifth Amendment. Well, we don't know this, but there's some suggestion that maybe she decided to take a Fifth Amendment. Why would they not want that announced to the jury? Is there a reason that either side would not want the jury to know that?
Well, the defense would not want the assertion of the Fifth in connection with questions that are connected to Attorney General Paxton. On the flip side, you would think that the House managers would want that. So I wish I was a fly on the wall for the discussions about her testifying and her attorneys not wanting the testimony to happen, to see how that agreement was brokered, where we get this bland statement, quote, present and deemed unavailable to testify.
Now Elvis has left the building.
Yeah.
I mean,
it appears that way.
Yeah, it's pretty stunning. Hey, Ryan, will you send me that story you're talking about?
It's just a tweet.
That's a tweet, okay.
They're just taking a break so the jurors can meet.
Oh, okay,
That's
so
what specifically, that's kind of what's going on.
Yeah, the Texas Tribune is reporting that that there's a break for the senators to meet, and that seems to be what's happening. Of course, everything's in flux.
I glanced.
Go ahead.
We saw on the camera, we saw them gathered around
Glancing
Senator
down,
Birdwell.
exactly.
Yeah,
I
Senator
glanced down
Birdwell
and
chaired
the
the
stream
rules. Go
had
ahead.
stopped, and you don't quite know exactly what's going on, but okay, the House Board of Managers. Okay, so I'm told by our esteemed photographer, Martin DePorto, who's been down here covering the duration of this, that the House Board of Managers just walked from the Senate chambers back into the House, and so they've left the chamber. And so, as you said, that would make sense if the jurors are taking a break and they're going to discuss. They probably are in the same boat we are, that everybody's flying by the seat of their pants. Nobody really understands exactly how this whole thing goes down. So perhaps it's a good thing to take a breath and try to better understand exactly what the rules say and exactly how this is going to happen.
Well, it felt like we've had a lot of surprises. First of all, this morning, we thought we were going to get Laura Olson, then we didn't get Laura Olson, then when we thought we were going to get Laura Olson, then we didn't, and then Rusty clearly mistakenly rested. So it was just really, shocking kind of all the way around, and I guess everybody's kind of caught flat-footed here at the moment.
But now these motions are not a surprise, and as you said, Victor, I mean, this is customary at the end of testimony for the defense to move for summary judgment.
Yeah, whether it's a civil case or a criminal case, the party with the burden of proof has to sustain their burden, and if they don't, you typically see a motion after the close of evidence.
Okay, so we're going to let Teresa Woodard go. Teresa, thank you so much. It's good to see you.
Thank you, guys.
Appreciate
Thank you. Good to see you all, too.
Thank you. Okay. All right, so we're just kind of back to tap dancing again here?
That's right.
Just like, okay.
Well, the jury has to figure out what they're doing and how. Chairman Birdwell seems to be acting as sort of a de facto jury foreman, since he chaired the committee making the rules.
Right, we see them all kind of talking there in the House. They've got a computer out in the. You think they're reviewing the rules? Is that what we think's happening?
They may be reviewing the rules, or they may be reviewing the articles. I mean, we don't know for sure, exactly how these articles are going to be presented for them to vote on. Whether they're going to have to review which one is which, and go back through their notes and consider, how they feel about each one. We don't know how they'll be presented or how much time they'll have. So, those are things that they're working out. Senator Birdwell, of course, is from Granbury, serves a Senate district that represents mainly Waco, but stretches up into Mansfield and the southern DFW area. He was the chairman of the committee that wrote the rules for the trial. He also, this week, he was remembered as a survivor of 9/11 in the Pentagon. And so he was burned severely in the Pentagon and survived the attack on the Pentagon. And so he is, this has been a week of when thoughts were with him in many ways. He's on the spot here.
Yeah, no, this is all very fascinating, and I guess it'll be a little bit like we saw on the first day, where they'll vote on each of these motions and they'll read out each senator's name, right? I mean, that kind of feels like that's what's going to happen.
Roll call. But this is these articles are separate, and what they said was that they would group some articles and then have others individually. I assume that they'll group the articles. I'm really guessing about this. I don't know at all. I assume they'll group the articles relating to to any sort of bribery, and then they'll separate out articles related to the mishandling of the alleged mishandling of the open meetings law and some of the other articles that you could make a separate debate, have a separate debate about.
Brickman's testimony up until all this happened was up until we kind of got in this thing about can we get this report in or that reporting, it was actually kind of effective testimony. And it feels like it's kind of lost in here.
It was very interesting for sure. It's akin to driving 90 miles an hour and then all of a sudden at the end coming to a screeching halt is kind of the analogy I would use.
Yeah, it was, all of a sudden we've had this whole day where we thought certain things were going to happen and then they didn't happen, and then something that we didn't expect, which is Rusty resting the way he did, and then now everybody's just kind of, flat-footed trying to figure out, I guess, what do we do?
Right.
But how, in your mind, Bud, how much do you think the votes here on these different motions will telegraph how people are going to fall on the final motions?
Well, theoretically, you would say that the senators will vote on whether they want to continue the trial and hear the closing arguments, whether they're ready to make a decision or not. That's theoretically the way they would vote. But in actuality, I think that many of them had made up their mind before the trial. A couple more may have made up their mind since then. And generally, I think that we're going to know from these votes how much further they want to go. I think what they've done is given them a chance to go home if they want to go home. And it is so they're going to have to make the case for continuing the trial. They had the opportunity to go home at the beginning of the trial, and only from 6 to 8 of them wanted to go home. There were 22 to 24 who wanted to stay and have a trial. So we'll see how many want to continue.
So at 5:45 p.m., KenPaxton tweeted, "I'm heading to Maine next week to sit down with Tucker Carlson and discuss the last 2 weeks in Texas politics. It should be interesting." So that was about 4 minutes ago.
Yeah, well, that fits the political, kind of the team, the team patriot that has been arguing Paxton's side all along.
You think they'll argue the motion on, while we're at it, you think they'll argue the motion from the House Board of Managers about combining the two votes? I mean, it seems like they would go ahead and do all of those, right?
You would think so.
That can't be argued until tomorrow under the rules, and I'm sure the House Board will want to say, wait a minute, we have a motion that we want to make that we can't make till tomorrow. You can't stop the trial now without debating our motion. But that, this vote may make that vote moot.
It could. I mean, do you think that's likely?
I don't think so. I mean, I would think at this point that there would be 16 senators who would want to proceed with at least one of these articles. I think that some of these articles were not well phrased, well cast to begin with, and they may eliminate some of these articles, but I think that there are a few that the senators will want to continue with.
Do you think they moved too fast? Should they have done a better job wording these articles?
I think that it's obvious in some of the cases. The case in the article involving the special prosecutor, for example, it calls him a special prosecutor, but the defense says he wasn't really a special prosecutor. They called him by that term, but legally this was his status, and so that article is not valid because that really wasn't what he was, and things like that. I think that the writing in some of the articles of impeachment has been imprecise, and the defense has taken advantage of it. I'm not sure that they moved too fast. I think that they were trying to string together a lot of threads and tie the bow together, and I'm not sure. Some of those were vague for a reason, and you felt like that they were going to come to court and explain all this, and they explained some of them fairly well, and some of them they didn't explain very well.
Did they tie the bow together, Victor?
Well, if you look at the reaction from Busby when Hardin accidentally rested, you would think that they didn't tie it together. But it ultimately is going to rest in the hands of the senators, and it's anybody's guess.
I mean, you still get back to the questions about bribery, which are, if this was bribery, what did he get? Who got anything for it? He didn't get a new kitchen. What did he get? And so, are the bribery, articles valid? Of course, it was certainly the prosecution proved that there were attempts and discussions that headed that way, which are enough to uphold an impeachment article.
Well, there is an impeachment article on attempted conspiracy.
Right, and there's enough to sustain an impeachment article on attempts. So it's how each article's worded.
Is it usually better, and I understand this is not a criminal case, and we have to be careful about that, but is it usually better in your experience when you're trying a case to take a more focused approach? In other words, to try to, I remember one of my colleagues years ago covered the Holy Land Foundation case, and the first trial ended in a hung jury. They kind of threw everything up against the wall, and then they came back the second time and they won, but they had a much more focused narrative that they told the jury. Would that have been more effective in this?
So when you have a complex case, it's always the challenge is how do you make something that's complex unify and streamline. I love a reader, and I love reading Stephen King novels. Anybody who reads his novels know that they're very lengthy, but typically he has one or two or three things that go streaming through the entire book, and that's what happens. Like in the Holy Land case, you might have a very complicated story, but if you can string it together with a few simple things that tie everything together, it's much more effective than throwing a bunch of things against the wall.
All right, we gotta fix Victor's mic. It has died, guys. This is what happens when we're up here all day long, all day. Sorry, guys.
Yeah.
We're gonna fix Victor's mic.
We see no jurors now. They've all
we got a live look there in the
with
Senate
their
chambers.
discussion. They've left the room.
I think it feels like I don't know. This is kind of crazy.
Thank you.
Well, okay, sorry about that, guys.
It's kind of like a pit stop.
This is. Look, I understand you guys are complaining about the audio. This is what happens when you've got people who are up here all day long, and we have to kind of and I've been keeping an eye on mine. I still got 2 hours left on my mic. Okay, start that over, because they didn't hear you.
Yeah. So I think the question was, what do you do in a complex case where you have a lot of information? Here you have a lot of allegations and articles of impeachment. What you want to do as a trial lawyer is to have a unified story or theme so that you're tying everything together and keeping it focused rather than having a bunch of things that you're throwing against the wall and taking a more scattershot approach, which really knocks your ability to be persuasive.
Yeah, and that's just, it feels like to me they were trying to do too many things all at once. And I mean, of course, we don't know how this is going to turn out, but you know, when you have time limitations, you know, telling a focused narrative is really important.
It's critical. It's critical. But it's critical when you have time limitations. But even when you don't have time limitations, people's attention spans are not very long, and you want to have maximum impact. So you got to tell a tight story with really focused themes and write that in a very focused manner.
Hey Jay, can you put up the live look in the Senate chamber real quick so we can kind of, I mean, so folks are asking there it is. You can see pretty much, well, there's still a few senators in there, but you can see the House Board of Managers over there in the corner. You see Rusty Hardin and the rest of them. Dan Patrick's not in the room. I don't see Busby anymore, or maybe that's him off on the side. It's hard to tell, but I mean, it just feels like everybody's trying to figure out what to do.
You know, I think for the KenPaxton devotees who are watching or commenting, the fact that we're already talking about how Rusty Hardin mishandled time and mishandled the closing and mishandled everything, and I think that other people are commenting too about Rusty Hardin's handling of the prosecution. I think that means that people generally feel like the prosecution hasn't totally done their job, and they had 16 bites at the apple on this. We'll see whether they were able to bring home any of the 16.
I mean, I think that there was certainly a lot of really troubling things testified to in this trial. And again, all of these whistleblowers, these are all handpicked KenPaxton people who, to a person, you know, testified about this series of interactions they had that involved the way that the office was handling Nate Paul. Now, whether or not the senators decide that that makes KenPaxton unfit for office is a separate matter, but it's still troubling. I still don't think you want the Attorney General of Texas acting that way on behalf of one citizen of the state of Texas.
Well, that's the basis of the articles. Ultimately, we'll see if the senators think that's the case.
Right, you know, and again, that's up to the senators, but you know, you just have to question a lot of what was happening. You have, you know, the hiring of Brandon Kamek, this attorney who has no experience, certainly he's never been a prosecutor, he has no experience in public corruption, and he's never so much as done a subpoena up until that point. And, you know, you put him in charge of this investigation, and he's relying on Michael Wynn, who's representing Nate Paul, to kind of direct him in what to do, which is just, I mean...
It's shocking.
It is shocking.
If you're one of the senators out there who's up for re-election, who's in the primary in the spring, who's on the general election ballot in the fall, you know, has the prosecution given you enough to go on to go back to your voters and say, well, you know, there was a reason that I supported, that I wanted to sustain the articles of impeachment. I mean, I think I think some of the senators who were in the middle, I mean, it's a little tougher for them to go back to their voters and say, well, I thought the prosecution was right on.
Well, I think overall, you know, I've watched the trial, and it seems like the defense, in some areas, outlawyered the prosecution.
Certainly, we saw that today from a procedural standpoint.
Not, you know, certainly Tony Busby with his using of the prosecution's time and his, you know, constant objections. And then Mitch Little was very effective. You know, I thought the defense team had some talent, and had the touch that Tony Busby's famous for.
Well, I think if we had seen a lot more of Aaron Epley in this trial.
Well, I was going to say that to me, if we're picking stars for the day for both sides, regardless of what people think about Busby's tactics, what he did was very effective in breaking up the flow of the House manager's case. But on the other side, the star would have been Aaron Epley for sure. She was very effective, particularly when she came back in a fiery, passionate manner on redirect.
Oh, yeah, she was really good.
Yeah, she was on fire during that redirect examination, and she was making a lot of good rhetorical points, some of which she knew would be objectionable. Using her rhetoric as opposed to the answer to make her point. She was very effective in that regard.
You know, it wouldn't surprise me if they don't come back and say we're wrapping up for the day. Well, it kind of seems to be the par for the course.
I think that's very likely. They say, okay, we've talked enough, and we're coming back tomorrow to take up these motions, because they'll require, how many? Not 16, but probably 12 individual votes of 30 people standing up a piece and voting yea or nay. So that's going to be a couple of hours to deal with.
So Aaron Orner's asking, do the experts see this motion as a way for the defense to get a jury poll before starting their case?
Well, you typically see a motion like this in every trial, but I think in this instance, it definitely is a way to poll where you are to see where things stand between you and the jurors.
It's a motion to give the Senate a chance to go home if they want to go home. It's a motion to end the trial right here if the Senate so chooses, and it's not just polling. It's say, okay, y'all, we could wrap it up now if you want to, and I think that there were only 6 to 8 senators who wanted to wrap it up at the beginning of the trial, and we'll see if that number's changed.
Yeah, and I guess the question is, are we going to see that today, or are we going to see that tomorrow morning? Is this actually going to,
It takes 16 to pass a motion, so the defense would have to pick up 8 to 10 more senators over what they had at the beginning of the trial. That would be a pretty substantial swing.
So somebody's asking if Rusty accidentally rested. I think it's very obvious he
that
accidentally
was,
rested.
Yeah, it was. He was. So there is a procedure in courts allowing the opportunity to reopen, which is a discretionary call. I'm surprised that Rusty didn't pull that out of his pocket and say, a motion to reopen.
Oh, okay.
So it's an accident. I didn't mean to do it. Move to reopen. To give the other side the opportunity to cross-examine. I don't know that such a motion would have changed the result because Busby was there saying, I'm willing to forego my cross-examination. Let's get to what I really want to get to, which is throwing out these charges.
Right. Yeah, do you think he should have done that? You think he should have?
Well, I mean, it was an option. Whether he should have done it, I don't think, whether he did do it, I don't think it would have made a difference. I think the result would have been the same. The lieutenant governor probably would have said, well, you're moving to reopen in the face of Mr. Busby saying he's willing to forego cross-examination, so I'm not going to deny your motion and let your resting stand, and let's move on.
Yeah.
If I'm Tony Busby, I want to go ahead and have a vote tonight when everybody's tired and may want to go home. If they take the night off and go home and rest, they may come back in the morning and say, let's continue this trial and let's listen to the closing arguments as long as we're here.
That's right.
Yeah. I mean, but I would say that just the way that we've had these things the last few nights where they tend to go out and do this, usually they come back out after a while and just say, see you at 9 o'clock tomorrow morning.
That's true. It's very possible.
So then, and this vote is, if this vote comes out 16-14, 17-13, anything below a 2/3 vote, then we know that the rest of the trial probably doesn't mean a whole lot, probably won't result in a removal.
Right. And well, and it'll be more than one vote. They didn't say exactly how many motions they had.
Right.
But it's more than one.
Right.
And again, there was 14 or 15 motions the first day, right? I mean, it was a bunch.
There were at least 8, I think. So
it was quite a few. So it feels like there's going to be maybe a number because they were talking about grouping them. So I don't know. It's just really, I don't know. I'm struggling here.
And what they're doing, if someone is trying to figure out what's going on, the defense has moved to dismiss the articles of impeachment, and we're going to have an individual vote, or maybe not some combination of single and combined votes on the 16 articles of impeachment. It'll take a majority vote to dismiss any of the articles. That's 16 senators out of the 30 who are voting can dismiss the articles, and then that would mean that article was no longer under consideration. We have 16 different articles.
I could see some of the articles getting tossed.
Right.
It's very possible.
I think that's quite likely, actually, because I think there's some of the, there's some catch-all articles, some ones that are broader, based on broader conduct. Those would be the ones I'm really interested in. Okay, so somebody's asking what happened. Okay.
That's what I just tried to explain.
Yeah. Somebody's asking. I'm reading the comments. It was kind of a wild situation that we saw unfold, and we're all still kind of coming to grips with it. And I think the senators are also trying to come to grips with it.
Laura Olson headed out, didn't testify. Dan Patrick said she's not available. Rusty Hardin accidentally rested, and so Tony Busby of the defense has called for a vote on whether to continue the trial.
Yeah, and we're waiting to see what they're going to do. I guess they're reviewing the rules, and we're just kind of waiting to see how it's all going to shake out.
There was some question about these motions and which ones were not, the Senate was not allowed to debate, and which ones would be debated like a typical Senate floor debate, which ones would allow senators to argue. So, I'm sure that's gone into the discussion now of how, whether the senators will be allowed to debate and discuss in open Senate floor these articles, these motions.
I've certainly never seen anything like this before. Of course, what we're watching right now is we're looking at this live feed of the Senate chambers, and you see, actually we can see Busby, and there's Mitch Little, and I don't know if that's not Chris Hilton. Let me ask you this: we haven't talked about this while we're still kind of killing time here, Victor. Did you read? Have you followed the whole issue where 6 attorneys? Oh, look, Ryan's walking over. It's okay. Go ahead.
A couple things. So, Texas Tribune reporter does say a Senate is about to vote, so it does sound like they could vote tonight. But also, Paxton has tweeted.
Oh, I talked about it.
Okay. Yes.
I talked about it. Now we're all over it. We talked about it. That's okay. See,
Yeah.
Ryan, you should watch the stream.
So the House and KenPaxton's team have both filed arguments. This is, I'm reading from the Tribune, have both filed their arguments for and against tomorrow's motion on combining the vote. So we have what both teams feel about tomorrow's vote.
But
there is for those of you who missed that much earlier, there was a motion by the House prosecutors to combine the final vote at the end of the trial. They were set to have 2 votes, one on whether to remove the Attorney General, and then a second vote on whether to bar him from seeking future office. The House prosecutors moved this morning to combine those 2 in one vote so that they're not voting twice on that. Yeah, but that can't be considered until tomorrow.
right. So Chance Escamilla asked, does the defense get closing arguments since they haven't rested? Well, the way, can you kind of explain to folks what's going to happen next?
So give me the question again.
Does somebody's asking, does the defense get closing arguments if they haven't rested? I mean,
So the
the defense will not get closing arguments if the articles of impeachment are thrown out or dismissed. That will be the end of the case.
Okay,
But if the articles of impeachment stand, then we will move towards argument, and both sides will get argument.
Okay, so we've got a live look there in the Senate. We can see Dan Patrick up on the dais. We've got, you can see Tony Busby up there, and the House impeachment managers listening to what Dan Patrick has to say. So we're waiting, finding out. You can see Dan Cogdell there, and I guess waiting to see what they've decided to do and how they're going to handle this.
KenPaxton is apparently on his way to Maine, and we don't know where Laura Olson is. So.
Well, I'm guessing Maine temperatures are probably a lot nicer than it is in Texas right now, although it's not as crazy hot as it has been. But I'm assuming we're gonna, there's Rusty Hardin. You can see, of course, Mitch Little. They're all up there talking at the bench. What do you think the conversation is, Victor?
Well, they're probably discussing the procedure for dealing with the pending motion to dismiss the articles of impeachment.
Well, you know, Dan Patrick looks like he's in a pretty good mood. So, interesting. We're just waiting to see what they're going to... I mean, are they going to wrap it up for the night, or are they going to do these votes? That's what we just don't know.
That's right.
It's a stunning way to end the day, is all I can say.
All right. Natalie Haddad says the prosecution plans to file a counter motion. So we'll wait and see what that'll amount to.
Lots of motions and counter motions, but it's certainly not the way we thought this day was going to end. This is definitely the way we started and the way we're ending is not. Of course, you know this, Victor. In most trials, the moment you think you know what's going to happen,
you just don't know exactly.
But the perception is already that the House screwed up. I mean, that is the prevailing perception of the day, that they screwed up in not having Laura Olson scheduled earlier, that they screwed up in their timing, they screwed up in their handling of the clock, and now that they have screwed up in resting too early. I mean, there is a prevailing perception that for whatever you may feel about the articles in the case against KenPaxton, that the prosecutors have not handled it in a effective way.
Right. You have to wonder whether senators can use the cover of those errors to say, well, you just mismanaged the pursuit of the case, so I had to vote against the articles.
Mm-hmm.
Well, and if they, I mean, I think that, a lot of people think that, and you said this, Bud, that pretty much most of them knew what they were going to do and into it.
I think they all knew what they were going to do. They all had their minds up and their loyalties set. And like I've said, I did not think this would come to trial. I thought it was within 1 or 2 votes either way of 2/3. And I was surprised when it did go to trial, and I thought, well, wow, we're going to go ahead with this thing. And I thought the first couple of days that more senators were leaning toward the prosecution, but then they started kind of taking apart some of the young attorneys that had worked in the office, and and you had some effective Busby theatrics that really haven't had a response from the prosecution.
Yeah. Huh.
Of course, that we got into this discussion of whether Rusty is really appealing more to the senators while Busby is appealing to the TV viewer. Whether Rusty's more effective with the senators making their case. But the senators have to go out and get votes from the TV viewers. The senators have to go out and campaign. The ones up in next year have to go out and campaign. 3 of the senators who are up next year are the ones who voted firmly with the defense every time. Tan Parker, who we mentioned from Highland Park, Denton County, Paul Betancourt from Houston, Donna Campbell. They were all firmly on the side of the defense every time. The interesting is Joan Huffman sided with the prosecution. She's on the ballot. and then 2 of the people from the Metroplex, Phil King from Weatherford and Fort Worth, and then Drew Springer from Munster and Northwest Texas. They're both on the ballot next year, and it will be interesting to see which way they vote in these votes. It does take more than 2 people swinging. It takes a 8 to 10 vote swing from the original vote to throw out the charges at this point. So it would take a huge swing in jury opinion, despite the prosecution's miscues, for the trial to just suddenly blow up in smoke right here.
Right.
So they just sent me a copy of the House Board of Managers motion to reconsider Senate Rules 27 and 30A.
So that's the motion for
Yeah,
tomorrow?
that's the motion for tomorrow. Yeah, that's the one where they're trying to combine the votes in terms of removal, and they're basically saying that it says these rules are inconsistent with the Texas Constitution and the purpose of impeachment, which requires that a state official who is convicted of committing impeachable offenses be both removed and disqualified from holding future office. I mean, I don't know. I mean, can they have? I mean, that's a constitutional question, I guess, right?
Right.
They can combine it. I mean, under the Constitution, the trial is to decide whether to remove and bar from future office. It was the committee that decided to hold separate votes. There's nothing in the Constitution that requires separate votes.
Okay, and then there's the motion. Okay, this is the response from Paxton's team. Okay, hold on. Okay, I'm catching up with these emails that are coming in, and they're basically saying it should be denied outright or deferred until after a vote on Attorney General Paxton's innocence. Regarding deferral, should the Senate vote to acquit the Attorney General later this week or early next, the acquittal will this. Furthermore, as the House points out, every precedent weighs against this House's position. Modifying 100 years of precedent on the fly and at the last minute would not respect the gravity of that precedent or this process. And in the event the House is wrong on the merits in their misreading of the Constitution, and it goes on. So they're just arguing back and forth about. I mean, presumably we're going to see a vote on it.
Absolutely, right.
In terms of deciding one way or the other, but there's going to be, I think what we're going to see is just a whole flurry of activity. Is this, I mean, I know this is not a criminal trial, but this is pretty kind of normal in trials, right? I mean, especially big trials.
Sitting around and waiting is something that happens when you have a complex trial with multiple participants.
And then somebody else has sent me this tweet showing that KenPaxton is heading to Maine next week to sit down. We actually read that earlier, but he's going to talk to Tucker Carlson, and I guess he'll have his answer by the time he appears with Tucker Carlson in terms of how this is going to shake out. I think. Okay, so all right, we see Dan Patrick up on the dais. Looks like we're about to get started again. Is it? Let me pull up the Senate feed too.
I don't see the jury in their seats.
No, but it looks like we're kind of starting to head towards something, maybe. I don't know. It's just kind of interesting. We're trying to figure out, you can see Dan Patrick there talking to Lana Myers. Do you know Lana Myers, Victor?
I do. She's a very good member of the bar, very respected, former jurist and lawyer.
Justice Myers has worked really hard these last few days.
She has, and I think she's been really helping, get Dan Patrick where he needed to be. And let me ask you this, Victor, how would you assess Dan Patrick overall today?
Well, what I will say to the point that we were just talking about with Lana Myers, having her alongside him gave him a great deal of credibility today, given her stature in the bar.
Have you ever argued a case in front of her?
I have not, but I have known her in professional circles, particularly the Dallas Bar, and other professional organizations I've been a part of, including assessing her qualifications, and just an outstanding lawyer in person.
Well, she's one of the few Dallas folks that's involved in this, because all the most of the attorneys that are, you know, the big names in this are out of Houston.
That's right.
You know, and she, like you said, she has a very good reputation among Dallas attorneys. And she was a former Dallas County District Judge, and then she sat on the 5th Court of Appeals, and she retired maybe within the last year or two.
Yes, she is. So it's really good to see her participating here, and like I said, she's adding a great deal of credibility to the administration of these proceedings by being alongside the Lieutenant Governor.
And of course, she was the Lieutenant Governor's second choice. He originally named Mark Brown, who was a former state appeals court judge in Harris County, and he was named to this role all in one day. And it was found that he had donated money to Eva Guzman in the campaign last year, and so he stepped down from this role because he had a campaign donation on his record. But Justice Myers apparently did not.
Okay.
Yeah, and so that's how she was a...
That's how somebody from Dallas sneaked in.
They occasionally let a Dallas
We talk
person in.
often on Inside Texas Politics about how Houston runs the whole state, that Greg Abbott was a judge in Houston, you know, Dan Patrick's from Houston, Ted Cruz is from Houston, that all the power players are from Houston. And you know, General Paxton was an exception. But the Houston really is the just kind of the cauldron of politics, and tends to elect the most colorful Republicans and Democrats that wind up moving into statewide office.
Well, you know, I technically grew up in the Houston area.
I was
Texas City.
born in Houston.
Oh, okay. So
Yeah,
we're like transplants up here.
That's right. We've been here since 1998.
Well, I left in I moved away in the mid-90s to take the job in Abilene at the newspaper out there, and I always thought I would end up back down there, and you know, I moved to North Texas in 2000, and you know, here we are, 23 years later.
Well, things are calmer here.
They are calmer, but I don't know. I've covered a lot of crazy stories in Dallas over 20 some odd years. I mean, you know, just so many things have happened. But yeah, I guess it has been very much the battle of the battle of the Houston attorneys. These
Houston lawyers, everybody from Houston. I mean, Houston has all the reputation that goes back to Percy Foreman, who defended Jack Ruby for a while, and so many other cases, Patty Hearst. And so Percy Foreman's flamboyant courtroom style led to Racehorse Haynes, who was the defense lawyer for Cullen Davis, who, and so many other cases too in Houston. But and here he was known for defending Cullen Davis in 2 series of trials in Fort Worth, where despite eyewitness testimony identifying Cullen Davis, he was acquitted by a jury, both of first in the killing of a man at his former home, and then later in a murder for hire case involving a former judge that they convinced was staged and that he had no idea what was going on and that he was improperly charged. So Racehorse Haynes achieved the acquittals in both those with a great flamboyant style and a long series of colorful characters. Then that is what led to this round. I mean, the Racehorse Haynes begat Tony Busby, and of course Dick DeGuerin came along, overlaps both generations. Right. And we haven't seen too much of Dick DeGuerin in this trial, but Dick DeGuerin overlaps both and has his own style. And then you have Busby comes along with this flamboyant, just this attack dog style that makes him famous. I mean, people call him the best trial lawyer in the country.
Well, and certainly the defense team has been more flamboyant between
certainly,
Mitch Little
sure.
and
Members,
here we
after
go.
consultation, Members, after consultation with the jurors and both parties, both motions have been withdrawn, and the Defense will now call their first witness.
Mr. President, Mr. President, the Attorney General calls Professor Michael Gerhardt.
Bailiff, bring in Professor Michael Gerhardt.
Mr. President, before we proceed, may we approach?
Yes, you may.
Okay, another head-spinning moment.
Resolutions withdrawn, motions withdrawn.
And now we're going to hear testimony.
Or not. We have the lawyers huddled up in front of Lieutenant Governor Patrick after he said we were going to hear a witness, so who knows what's going to happen.
I mean...
So you're right, yeah, head-spinning day.
Well, I think there weren't 16 votes to back it in. I mean, I think that is, the most probable case, that the defense saw that they didn't have the votes, and so they wanted to go on with their case.
And I don't know who Michael Gerhardt is, but they said Professor Michael Gerhardt. Let me see if I can't figure out who he is. But I mean, this was just unexpected. I didn't see that coming. Okay, he is, assuming this is the right Michael Gerhardt, he is a professor at the Carolina Law faculty.
And I'm looking over at your screen, it looks like he's a constitutional.
Yeah, he's some kind of constitutional lawyer. He was one of 4 constitutional scholars called by the House Judiciary Committee during President Trump's impeachment proceedings. During the Clinton and first Trump impeachment proceedings, Gerhardt served as an impeachment expert for CNN. In the second impeachment trial of President Trump, he was an expert commentator for CNN, Fox, and MSNBC, and served as special counsel to the presiding officer, Senator Patrick Leahy. Okay, I'm reading his bio on the UNC's website. It says in 2015 he became the first legal scholar to be asked by the Library of Congress to serve as its principal advisor in revising the official United States Constitution, annotated. Ooh, it's kind of like it. Why would you start with a guy like that?
Well, in civil and criminal cases, you have 2 species of witnesses. You have lay witnesses and you have expert witnesses. Typically, lay witnesses are people with precipient knowledge like Drew Wick, who can testify based upon firsthand knowledge on things that they perceived. Here, they're going to start with what would be in court an expert witness, probably to frame the entire case through the lens of, look, there's nothing to see here. This is an eminent constitutional scholar who's going to tell you that this is much ado about nothing.
And I would agree. I think this sounds like he's just going to attack the impeachment process and say that this is not the way you impeach, is what he's going to say, that this was, that they didn't do it the right way, whatever their complaint is, and that there isn't enough here to proceed.
Corky Ray says, we should be able to hear the conversation between the Lieutenant Governor and the attorneys on both sides. That's not the way this works. Talk to us a little bit about how this is called a sidebar.
This is a sidebar, and typically in a sidebar, neither the courtroom observers nor the jury get to hear what's happening at the bench. What happens at the bench is between the lawyers involved in the case and the judge. Here, that position is occupied by the Lieutenant Governor.
Is this being recorded? Will we ever hear this?
No.
Well, at a bench conference in a courtroom, bench conferences are recorded, not unless the judge wants to go off the record.
Oh, you mean by the court reporter?
Yeah,
right.
by the court reporter.
Right.
And there are instances where the judge wants to go off the record, perhaps to light into a lawyer at the bench conference, but 99.9% of the time, the bench conferences are recorded by the court reporter. So
it will be in the court record.
And I haven't seen a court reporter at these bench conferences, but frankly, I haven't looked for one either. So it'll be interesting to see if these conferences are being recorded by the court reporter.
Yeah, I mean, it doesn't, I don't know, I don't see that they are, but is it the lady in the...
But typically, the court reporter does not have to be at the bench if she is wired like we are here to hear what's going on, and there's a microphone up at the bench. She could be some distance away and still hear what's going on at the bench conference.
Right.
So the key is to find a court reporter and to see if her fingers, his or her fingers are moving.
But again, just as we thought something was about to happen. Then we go back to a bench conference. So it's just kind of, I'm still, and while we're, I mean, just for folks that are jumping on this live feed who maybe haven't been following us all day, if you haven't been following us all day, you should follow us all day. But we started off with the morning thinking that we were going to hear from Laura Olson. You know, it's been admitted that she was Paxton's mistress. Then we had the situation that arose where the House didn't put it in time, so it was going to be 3:53 before she could be heard from. And so then they put Drew Wicker on the stand, and Drew Wicker testified about his interactions with I was about to say Dan Patrick, with Ken Paxton, and things that troubled him, and things that he overheard, and things that he felt were problematic. And then we heard Brickman, who was one of the whistleblowers, and he described his concerns, and he used some pretty strong language to describe how he felt about how things went down. And then just as we thought, when they came back from a break and we thought we were going to hear from Laura Olson, it was announced that she would not be available. And then we found out that it doesn't, and then Rusty Hardin finished up with Brickman and then mistakenly rested.
Well, a head spinning
And
day
then,
for sure.
and then, and that wasn't enough.
Members, since we're having an elongated discussion up here,
Okay.
we're going to adjourn for the day at 9 o'clock tomorrow morning, okay? See you at 9 o'clock tomorrow morning. Okay.
Okay, so, all right. Well, I was right. They did end up adjourning for the day.
You said that was going to happen.
Which is kind of the way it winds down.
Yeah, I think they just finally said, yeah, we're going to call it. We're going to end for the day.
Right.
So, and I am inclined to wrap this pretty quickly. I want to give both of you guys a chance to kind of give your thoughts. Victor, starting with you, your thoughts on what we've seen today.
Well, I think the theme from the day is missteps by the House managers in the presentation of their case. Procedural missteps, and then some missteps right there on the floor at a pretty pivotal moment, it would appear, towards the end of the day when they rested, when they didn't mean to rest. It's obvious that they meant to rest after the examination of the witness was completed, the examination of Brickman.
You know, I get down to the fact I've said all along that these senators have their minds made up, and they had their minds made up. And I've just read Scott Braddock, often a guest on Inside Texas Politics, says that his sources tell him that maybe a supermajority of senators, 2/3, were opposed to the demand for a directed verdict. That would have signaled the defense that this is over. And so I think that definitely the withdrawing the motion meant something. I think that I've always thought it was within a vote either way. I don't think it's changed more than a vote either way, despite all the fumbles by the defense. And I think that we're going to be counting closely of whether there are 20, 21, exactly how many votes there are when it comes time to vote.
Well, and I would expect in the morning, when they restart, Dan Patrick, as he's been doing, he'll announce the times, and so we'll have a better, because he didn't announce it. I think he just kind of said, I'm done for the day, and just ended it. So, okay, so I'm going to wrap it up because I have a child at home who feels slightly abandoned, and I'm going to go home and spend some time with my son. And it's been great having Victor with us today. It's been really an amazing legal guest, and of course Bud. Bud will return tomorrow, and then tomorrow we have Deandra Grant, who's a very well-known Dallas attorney, joining us. And so we'll see if things wrap tomorrow, or maybe we go to Friday, and maybe we go to Saturday. Who knows?
Who knows?
I've given up prognostications at this point.
Now we get to see all the defense witnesses who will be complete surprises. So we'll see what kind of surprises they hold.
Absolutely. Okay. Thank you guys for joining us. We will be back tomorrow morning.